Welcome, everybody. Welcome to today's Law of Self-Defense show. Oh, my camera's a little off. Let's see if I can fix that. There we go. It's a little... No, I'm a little off. All right. Welcome, everybody. For anybody who does not know, I am attorney Andrew Branca for Law of Self-Defense. You are always so kind. Thank you very much. We should be streaming on multiple formats, channels. We're on YouTube. YouTube is working. Law of Self-Defense member dashboard is working. We're trying to start to stream live to Twitter, and we are, in fact, working there. And finally, Rumble. That was interesting. For those who are looking for us on Rumble, just in the little search window, Google Law of Self-Defense, or I think we set up a shortcut URL. Yes, if you go to lawofselfdefense.com/rumble, it'll bring you right to our channel there. So that's another way to find us there. This day should be relatively short. We're going to cover yesterday's trial proceedings in the Dean Cummings murder/self-defense trial, but the court was only in session for about 3 hours. So I don't expect us to be together too long today, which is good. It's a Saturday. And then we'll be completely caught up on the trial. Now, we may have some guests. I sent out invitations to some of my attorney friends and others. I don't know whether they'll pop in or not. It depends on their interest and schedule. And of course, some of the attorneys are following this case themselves. So they're doing their own streams, which of course is totally fine. So we may be joined by others over the course of the next 3 hours or so, or we may not. You may just be stuck with me, folks. No worries. That's all good too. We will be answering questions and comments, but this is how we work it on these shows. We do have Super Chat activated for today's show, I believe. So if you're watching on YouTube and you'd like to ask a question and make sure it's answered, I mean, those are the only ones we will answer, or a comment that we would read aloud. It needs to be in Super Chat form, $5 minimum, folks. $5 minimum to filter out the riffraff. Or even smarter, instead of paying $5 a question on YouTube, a third of which YouTube takes, by the way, you can just become a Law of Self-Defense member at lawofselfdefense.com/join. That's $10 for the entire month, less than $10, only about 30 cents a day. And our member questions and comments all get read, guaranteed. And again, you could do that right now. Become a member immediately, get instant access to the show in the members member board on our website at lawofselfdefense.com/join. $9.95, I think it is, a month. And no offense, but I get to keep all that money instead of having to give a third of it to YouTube. So that's the way I would prefer you all go. But if you'd rather have the Super Chat thing, that's fine. I will take a look from time to time on Rumble. Rumble does what? Rumble Rants. That's their version of Super Chats. It does appear as a different colored kind of comment. If I see those, I'll read them. Again, $5 minimum, same as YouTube. And I think that is about it. So a quick recap. Dean Cummings is the defendant here. He's apparently some kind of formerly famous skier. I don't follow skiing, so I don't know, but that's what I read about him in the media. He had a concession in Alaska for helicopter skiing. He was in some outdoor books. Oh, the local train is going by. That's always nice. Second time in this hour. Can you all hear that? You hear the horn? We don't have proper railroad crossings here in Castle Rock, Colorado, so the train blows its horn. Very, very old school. So Dean Cummings, former famous skier, but I guess he was born and raised in New Mexico. He returned to New Mexico later in life, was looking to buy some property from the victim here, Guillermo Arriola. Arriola? I think that's it. And Arriola had 16 acres of land just west of Los Alamos that he was interested in selling to Dean Cummings. He was allowing Dean to stay on his property in a trailer to kind of get a sense of the property, evaluate the property over some period of time. At some point, the men got into an argument in that trailer, an argument that resulted in the death of Areola. Dean Cummings says that Areola attacked him with a canister of pepper spray, one that looks a lot like this one, was beating him with it. He got sprayed with mace, they're characterizing it as. And it was during this attack, Dean Cummings retrieved his 6-hour rifle. The men fought over the rifle. 11 rounds were discharged all over this little tiny room. They were in a little tiny bedroom. 2 of the rounds struck Areola, resulting in his death. Cummings, there was no cell phone reception in this remote 16 acres of land. Cummings left the property, ran into a gentleman riding a motorcycle around. The gentleman called 911. Dean Cummings spoke to 911, gave them his name and so forth. Police ultimately showed up some hours later. This was quite remote, didn't have a real address. You had to use GPS coordinates to find it. And within a week, Dean Cummings had been charged with murder in this case. And ultimately, a trial, he's been charged with murder, a lesser included of manslaughter, which is, in this case, murder mitigated by what the law calls adequate provocation. In this case, the fight between the two men, it said that it's creates an emotional state where the killing's not in cold blood anymore. It's in hot blood. You could not form the intent necessary for intentional murder, so they mitigate it down to voluntary manslaughter. Also, he was charged with concealing his identity from police and for tampering with evidence. And those last 2 charges are particularly ridiculous. They're based on, he had one conversation with one officer where he apparently only provided his first name. They already knew who he was. He provided his name to officers already. He was not trying to hide his identity. He was not trying to avoid identification. But I guess that one cop got irritated and charged him with failure to identify himself. And he got charged with tampering with evidence because he said he got sprayed with mace and he washed the mace off himself and changed his clothes. Now, he didn't try to hide the clothes, and he told them he had washed his face. So when you have a reason for doing something other than attempting to conceal or alter the evidence, in this case, getting the burning mace off your skin, that's an explanation consistent with innocence. So it's not proof of a crime beyond a reasonable doubt, certainly. And spoiler alert, this is the end of the state's case, what we'll be covering here. The state's going to rest at the end of this 3 hours, and the defense will motion the court to dismiss. I presume they motion the court to dismiss all these charges. They all, frankly, seem ridiculous given the legal standard that has to be met for conviction. But certainly what happens, I've been told, is that the court does dismiss the tampering with evidence and failure to identify charges. So by the end of today, those charges have gone away. What's left is the murder and manslaughter charges. And that's what the defense will start to address on Monday when they start to present their case in chief. Now, we've watched everything up to today. So today will catch us up on the trial. We've been playing catch up a day or so behind the actual trial proceedings. But we have watched every minute of the trial that's occurred up till this last couple of hours. And my general sense of the state's case in chief is that it's just terrible. It's terrible. Their whole argument seems to be, well, this could have been a murder. It could not be self-defense. But remember, the state's burden is to disprove self-defense beyond a reasonable doubt. And they're nowhere close to this. The state's witnesses have been more or less awful. I mean, the medical examiner yesterday was fine, but she doesn't know whether this was murder or not. All she can testify to is, the injuries, the cause of death, and so forth, which she did. She was fine. They had a DNA analyst who, like in the Rittenhouse case, they only DNA test parts of the rifle that was involved. They didn't DNA test the barrel, for example, which is where you'd expect a man to grab it if he was fighting for control of the rifle. The police officers who have testified have, without exception, been awful, just terrible. None of their body cameras work. Nothing works. They don't have any equipment. They don't have computers in the car that work. They didn't photograph or collect evidence in a reasonable way. They fail to test anything, it seems like. They just come across as completely incompetent and incapable. And remember, this is the state's witnesses. So very, very unimpressive. And again, the burden is on the state to disprove self-defense beyond a reasonable doubt. Now, what I'd like to do before we jump into this last 3 hours of the state's case in chief is actually rewind and go back to the opening statements to kind of reset our expectations for this trial. The opening statements are quite short. They're only about 15 minutes for the state, 15 minutes for the defense. So I think they're worth doing again. In fact, it'll be a little shorter than that because I'll play them a little faster than normal speed. And particularly when you're listening to the state's opening statement, keep in mind what they're supposed to be doing. They're supposed to be presenting the jury with a coherent narrative, a story of why they are going to be able to disprove the defense claim of self-defense beyond a reasonable doubt. Because I find the state's opening to be very disjointed, not coherent, not compelling, boring. And a great advantage the state has in a criminal trial is they get to talk first, right? The jury is supposed to be there impartial, unbiased, basically a blank sheet of paper. And the first words they hear about the trial are from the state. And folks, if you invite me to a debate and you let me be the first person to speak, I'm 90% of the way to winning that debate because I get to set the battlefield. I get to set the terms because the first words the audience hears are from me. It's an extremely powerful advantage, and the state completely wastes it here. Completely. Now, they may be wasting it because they don't have anything substantive to say. The two prosecutors here both happen to be women. They strike me as technically competent. When they're questioning witnesses, they're not Elaine Bredehoff. I mean, they know how to ask a question, at least on direct examination. We haven't seen them on cross yet. So they strike me as competent prosecutors, but they don't get anywhere. And I think they don't get anywhere because they don't have anywhere to get. Now, and then we'll do the defense opening statement, which is a coherent narrative of self-defense. And keep in mind, the question isn't whether you think it was self-defense or not. Is it more likely than not it was self-defense? How do you feel about it? Could it have been a murder that was framed to look like self-defense? That's not the legal question. That's all fine for conversation over beer, of course, but that's not the legal question. The legal question is, has the defense at least raised a reasonable doubt that it could have been self-defense, as opposed to the state having disproved self-defense beyond a reasonable doubt? I will say of the two defense attorneys, the one who does the opening statement is fine. She seems quite competent. Nothing particularly notable there. The other one, Carrie Morrissey, the taller woman, she is a pit bull of an attorney. I'm extremely impressed with her. She is awesome. I'm going to try to interview her after this trial. She is, in fact, we had a very funny, I looked her up on the internet to see about inviting her on the show, and I came across this very funny review of hers. I wonder if I still have it pulled up here. Yes. Okay. Let me see if I can share this with all of you. There's two reviews here. One is, and this is from a website called Martindale-Hubbell. It's a website that serves lawyers as a profession. They do lots of stuff for lawyers. So it's like Yelp, but for lawyers, these reviews. And they don't identify the reviewers, but they identify them by their job. So the first review here is by another lawyer, and the second review is by a judge. Now, when I saw these reviews, I clicked on them because I'm watching this woman in court, Carrie Morrissey, and she's awesome. She's fantastic. And I see the overall review for her is like 3.6 out of 5. And I'm like, how can that be? She's doing great. So I clicked through to look at the individual reviews. And the first one from the sole practitioner, from the other lawyer, is just 5 out of 5. There's no comment, just 5 stars out of 5 stars, which would have been my ranking, at least. The second one from the judge, from a judge, someone who identifies to Martindale-Hubbell as a judge, is very funny. Let me pull that up here. It's the second one here. 2.6 out of 5 stars. Okay, that's pretty bad. And it reads, this attorney tends to be unreasonably hostile, oppositional, and borderline on courtroom decorum and respect for the court. And then it continues. She zealously advocates for her clients and generally demonstrates above average trial skills. Folks, that's a 10 out of 5 stars for a criminal defense attorney. That's who I would want defending me, defending my family, if I were on trial for murder. So how you can say those words and then rank her 2.6 out of 5 is, I don't know, more than I can imagine. But I think those words are an accurate description of what I'm seeing here in this courtroom from Carrie Morrissey. She looks fantastic. As a criminal defense attorney, I'm not sure I'd want to be married to her, but as a criminal defense attorney, she looks absolutely awesome to me. And let's see, so she doesn't present the opening statement. So we're not going to hear her until we get to the second video, which is yesterday's proceedings. The opening statement, of course, occurred earlier in the week, I think this past Tuesday. And we have covered it before already, but I want to do it again because it's sufficiently brief. It's not burdensome to cover it again. And I think it highlights the shortcomings of what the state has to offer compared to what the defense has to offer when the burden is on the state to disprove self-defense, not just by a little bit, not just by a majority of the evidence, but to disprove self-defense beyond any reasonable doubt. Okay, so let's see. Anything else I should address? Well, for anybody who's new here, of course, Law Self-Defense has a book that is a plain English guide to how to be hard to convict if you're compelled to defend yourself, your family, your property against criminal predation. It's very easy to read, plain English. We give this book to you for free. You can buy it on Amazon. In fact, I encourage you to go to Amazon and read the reviews. We have over 1,000 reviews. They're 5-star rated, solid 5-star rating. But don't buy it there. If you buy it from Amazon, it's $20 or $25 plus shipping and handling. You get it from us, we'll give you the book. We do ask you to cover the shipping and handling, to full disclosure. But the $20, $25 cost of the book will eat. You can get this at lawofselfdefense.com/free book, lawofselfdefense.com/free book. If you don't even want to do that, we have for free our 5 elements of self-defense law cheat sheet. Any claim of self-defense has up to 5 elements. This applies in all 50 states. These are the 5 elements. We provide a brief description of each. It's just a PDF download, folks. We don't charge a penny for this. You can get this at lawofselfdefense.com/elements. And something else we have for free is a periodic webinar we do, a free webinar. Let's see if I can. I thought I had this prepared to pull up. Here we go. Yes. So this is our Law of Self-Defense Hard to Convict webinar. It's about, I forget, an hour and a half long, typically. We don't charge a penny for it. And we debunk a lot of myths that people believe are self-defense law that will only put you in prison if you believe those things. And they're very, very commonly held beliefs, even among people who think they're relatively sophisticated about self-defense and self-defense law. So I would encourage you to take advantage of this opportunity. We do the webinar periodically. You can go to the website here, hardtoconvict.com, and sign up. What this webinar helps teach you, of course, is to be hard to convict if you're compelled to defend yourself, your family, your property from criminal predation. It's 100% free, folks. So hardtoconvict.com. It doesn't cost anything, but you do have to register for a seat because we limit the number of seats for each webinar. So there you go. And with all that out of the way, let's get back to the opening statements from last Tuesday. Let's see. Where are we? This is it. All right. So the judge has just finished instructing the jury on kind of general role of the jury in the courtroom type things, what to expect from the proceedings. And now he's about to tell them that they're about to hear the opening statement from the state, to be followed by the opening statement from the defense. So here we go.
The prosecuting attorney may now make an opening statement. The defendant's attorney may make an opening statement or may wait until later in the trial to do so. What is said in opening statement is not evidence. The opening statement is simply the lawyer's opportunity to tell you what the lawyer expects the evidence will show. State, you may make your opening statement.
Thank you, ladies and gentlemen, for your time and attention this morning. I know it's a long morning, and now that you ate lunch, hopefully we won't put you to sleep. So thank you, though, for being honest in your answers so that we can pick the most fair and impartial jury for this trial. This is a criminal trial, as you heard, commenced against the state of New Mexico against Dean Cummings. And I'm going to play for you a phone call from a 911 operator to the Sandoval County Sheriff's Office dispatch that was made on February 29th of 2020. And hopefully I can. Let me see. I bet my audio is on. Nothing like electronics. Is it on the court thing?
Pardon me?
On the podium thing? Because I have it plugged in.
Is Jason here? Give me a second.
That's okay. I'll proceed without it.
Pardon me?
I'll proceed without it.
Okay, if you need it, IT is coming in, but you may continue.
There we go. Plugged in. And that's from the last trial. That's okay. I'll proceed without it.
Okay.
Thank you for your time and attention, ladies and gentlemen. Nothing like technology to put a bump in the road, right? Ladies and gentlemen, as you heard, or you can guess from what this case isn't about who did it or how it was done. This case, the facts for you to decide are whether or not this homicide was committed in self-defense or whether it was committed with or without sufficient provocation. A second-degree murder is a homicide that was committed without having been sufficiently provoked, whereas a voluntary manslaughter is a homicide committed after having been sufficiently provoked. And the judge is going to give you the definitions to all of these things and what that law means. This case, ladies and gentlemen, is a case about reasonableness. And you, ladies and gentlemen, are the finders of the facts. The state has the burden of proof of showing that Dean Cummings, the defendant in this case, committed this homicide beyond a reasonable doubt. And the state will also show that the defendant, Mr. Cummings, also committed the crime of tampering with evidence. And that is because he washed his face, his hands, and changed his clothing after committing that homicide. And the state will also show that he committed the crime of concealing identity, because when law enforcement came and interacted with him, he didn't give his identity to them. The evidence is going to show, ladies and gentlemen, that on
Ms. Walker,
February.
Ms. Walker, IT person is here if you want.
That's okay. I'll just proceed. It's fine.
Okay.
Thank you.
Thank you.
So, ladies and gentlemen, the evidence is going to show that on February 29th of 2020, at Guillermo Adiola.
Yes, folks, this is the opening from Tuesday. I'm playing it again because it's short and it helps reframe us for our set our expectations for what the state was supposed to have been doing since then through the end of yesterday's proceedings when they rested. It's about 15 minutes for the state, 15 minutes for the defense opening. If you don't want to watch it, go have a cup of coffee for half an hour. See you later.
Ranch, which is way out past Cabazon Peak in the far remote area of Sandoval County, New Mexico. A ranch that is so remote that there is no cell phone service out there. And a ranch that is so remote that law enforcement had to use GPS coordinates on the search warrant. The evidence is going to show that the defendant killed Guillermo Adiola in his trailer. And the evidence will show that Mr. Adiola had been contemplating selling this ranch to Dean Cummings. He had his realtor, Christine Landers, draft up a real estate contract to sell this property to Mr. Cummings. Mr. Cummings had time to contemplate the purchase of this property and had not yet signed the real estate contract at the time of the homicide. On February 29th, 2020, Guillermo Adiola drove out to his ranch out in Sandoval County to meet with Mr. Cummings. Mr. Cummings shot and killed Mr. Adiola with a Sig Sauer AR-15 rifle. This rifle had a 30-round magazine and a scope on it. Mr. Adiola was 47 years old at the time of his death, and he was shot 2 times that day. He was shot once in the head and once in the chest. Law enforcement came and processed the scene, and they recovered 10 casings, spent casings, from that bedroom where he was shot.
Remember, folks, what we're looking to hear is what evidence the state's going to present that would disprove self-defense beyond a reasonable doubt. No one's contesting that this defendant shot and killed the victim with a rifle in this location. The rifle had a scope on it. It was not an AR, by the way. It was a Sig Sauer. It looks like it was, in fact, we know now it was a Sig 5.56 model rifle. No one's contesting any of this, and this doesn't make this a crime until the state can disprove self-defense beyond a reasonable doubt. So that's what we're listening for. What's the evidence that the state plans to present? And again, we're replaying their opening here, but they're supposed to be telling us what's the evidence they plan to present to this jury over the course of their case in chief that would convince a reasonable, impartial, unbiased jury that they've disproven, the state has disproven self-defense beyond a reasonable doubt. Keep your ears open for that. That's the legal issue in this trial.
In Mr. Adiola's right hand was a can of mace, and that can of mace was facing Mr. Adiola, not outwards towards any attacker, but facing him and his body. You will be asked to determine whether the reasonableness of Mr. Cummings' actions when he committed this homicide. Were his actions reasonable when he shot and killed Mr. Adiola with an AR-15? Initially, when law enforcement went, Mr. Cummings refused to identify himself when the deputies made contact with him. And Mr. Cummings told the Sandoval County Sheriff's deputies that he killed Mr. Adiola in self-defense because he was sprayed with a neurological agent, presumably the mace. Mr. Cummings told deputies that he washed himself off to get rid of the neurological agent and that he changed his clothing. Now let's talk about the evidence that's going to be presented to you over the next week, week and a half. You're going to hear testimony from Christine Landers. Ms. Landers is going to tell you that she drafted that real estate contract for Mr. Adiola to sell the land to Mr. Cummings. She's going to tell you that she met Mr. Cummings and Mr. Adiola about a month before the homicide to go over this real estate contract. She's going to tell you that Mr. Cummings had his 5th will parked on the ranch property. And you're also going to hear testimony from...
And none of that has anything to do with whether or not this is self-defense. This whole thing with the real estate agent, the sale of the property, and they do have the real estate agent testify, not very effectively at all, but it's completely irrelevant to the key legal issue here, which is whether or not the state can disprove self-defense beyond a reasonable doubt.
David McCullough. Mr. McCullough will tell you that on February 29th, 2020, which was a leap day, he was out riding his ATV out in the middle of the desert at Cabazon Peak, and he came upon Mr. Cummings. Mr. Cummings spoke with him and conversed with him for about an hour, and then Mr. Cummings asked him to come with him to witness the body. Mr. Cummings told Mr. McCullough that he killed a man in self-defense, and he wanted him to witness the body.
Does this all sound like consistent with self-defense so far? This is the state's opening. So it's not like the defendant told the man on the motorcycle, I killed this guy because there was a drug deal gone bad. I killed this guy because he was sleeping with my wife. I killed this guy for some motive other than self-defense. He told him I killed him in self-defense.
Mr. McCullough followed Mr. Cummings back to the ranch, And Mr. McCullough will tell you that he had medical training, so he believed he could render aid to anybody who was injured. So that's why he went back to the trailer, to the ranch, to see if he could render aid. Mr. McCullough will tell you that Mr. Adiola was past the point of aid being rendered. The defendant, Dean Cummings, told Mr. McCullough that he had used the rifle in the back of his truck to kill Mr. Adiola. Mr. McCullough will tell you that he saw the rifle in the back of Mr. Cummings' truck, and then he proceeded to drive to an area where he could get cell phone service. Mr. Cummings stayed back at the ranch while Mr. McCullough drove out to get cell phone service. The area was so remote that it took him several times to get in touch with the 911 dispatch. And you'll hear those calls, and they continue to be dropped. He made about 4 calls to 911. You'll hear those calls. Mr. McCullough waited for law enforcement, and then he led them to the remote area where the ranch was located. After Mr. McCullough called law enforcement, then Mr. Cummings also called law enforcement. You're going to hear testimony from several Sandoval County Sheriff's deputies. You're going to hear testimony from Deputy Hayden Walker.
These guys were so unimpressive.
The initial responding officers that responded on February 29th, 2020. You'll hear that he met Mr. McCullough, and Mr. McCullough led him into the ranch. And you'll hear that Mr. Cummings told him he killed Mr. Adiola in self-defense because he was sprayed with a neurological agent.
So that's not quite true. He did say he was sprayed with a neurological agent. That's not the defense narrative of why he killed the victim. He killed the victim. The defense narrative is because the 2 men were fighting over the rifle. That's a gunfight.
Deputy Walker placed Mr. Cummings in the back of his patrol car while they conducted the investigation. And Mr. Cummings tells the deputies that he placed the rifle on the porch and that he had the magazine, he took the magazine out, and they were both laying on the porch for them. Mr. Cummings tells Deputy Walker that he washed his face off and his hands and changed his clothing. You'll also hear testimony from Deputy Jonathan.
Does that sound like tampering with evidence when you're telling the cops what you did and why you did it because you're apparently sprayed with mace?
Crispin, and he also responded to the scene with Deputy Walker. They secured the scene. They made contact with Mr. McCullough. He collected some witness statements while he was there on scene. And then they secured the perimeter. They went into the trailer to make sure that there was nobody else that was injured. And then they held the scene until the remainder of law enforcement can come. You're going to hear testimony from Sergeant Thomas Griffin, another officer with the Sandoval County Sheriff's Office. And he was the on-scene sergeant out there at the ranch.
None of these officers' testimony was inconsistent with self-defense.
He arrived with Deputy Gutierrez, and he was present when Mr. Cummings was evaluated by emergency medical services. Mr. Cummings told Sergeant Griffin that the clothing he was wearing at the time of the homicide was in the back of his truck. So Deputy Griffin collects those clothing, and he's going to tell you that the clothing was indeed wet, as if Mr. Cummings had washed himself off. Sergeant Griffin also assisted with the towing of the vehicles from that ranch. They towed the vehicle of Guillermo Adiola. They towed the vehicle of Mr. Cummings, his truck, as well as the fifth wheel.
What's that have to do with anything?
Sergeant Griffin also collected the evidence. So in this homicide, the Sandoval County Sheriff's Office called the New Mexico State Police, and they come out and they assist with the crime scene. So he collected the evidence from the New Mexico State Police that was collected from the scene that day, and he's the one who tags it into evidence. You'll also hear testimony from Lieutenant Frank Tomlinson, our case agent here.
So this is what happens when the state doesn't have anything substantive to talk about. They just say, well, we have a witness who'll say this, a witness who'll say that, a witness will say another thing. Look at all these witnesses, 4 cops, real estate agent, guy on a motorcycle. You're going to hear from this person and that person and that person. But what do these people actually have to say that's inconsistent with self-defense in a case where the state has to disprove self-defense beyond a reasonable doubt? And the answer is nothing.
He was assigned this investigation, and he's the one who was in charge of making sure everything got done. Lieutenant Tomlinson assisted with the investigation while working out of the...
They could have had stuff to say, in theory. If this defendant had shot the victim in the back from 100 yards away, they might have said, we found the victim 100 yards from the site of the shooting with a bullet to the back. That would look inconsistent with self-defense. So in theory, their testimony could be favorable to the state, negative to the defense, help the state disprove self-defense beyond a reasonable doubt. But in fact, they don't have anything like that to say.
The Sandoval County Sheriff's Office, which is right here in the courthouse, while Thomas Griffin was the one at the ranch because there was no cell phone service. They had to play telephone tag, if you will, to get sure the warrants done. He wrote several warrants and he interviewed several witnesses, and you're going to hear about all of that.
So far, it's been a train wreck for the state.
He also transported the evidence. As I stated, the New Mexico State Police assisted with this investigation by processing the scene, and you're going to hear testimony from Carlos Herrera, the New Mexico State Police case agent. He was the criminalistics agent, so he was the one in charge of making sure all of the evidence is documented.
I think these were the guys that were testifying when suddenly there was, in the courtroom, there was two magazines for the rifle when only one of them was ever seen.
Were granted so that they collect and document everything.
Yes.
He'll tell you
This
about
defendant's
the
been locked up for
processing
2
of the
years,
scene.
2.5 years in jail since the shooting happened.
One person is assigned to scan the scene.
Yes, we're watching the opening
He was
again.
assigned with documenting the casings, the trajectory, where the blood was, and things like that. Agent Herrera is going to tell you that he collected 10 spent casings from the scene that day. He collected the mace and he collected the AR-15 rifle. Agent Bogue, also to the New Mexico State Police in the criminalistics portion, she was assigned with running what's called a Leica scanner, and it's a scanner that scans the whole room, and she uses the information from that scan to create a diagram. And she'll testify about the diagram that she created that documents where the body is, where the casings were, and the outline of the house.
And none of it was inconsistent with self-defense.
And you're finally going to hear from Jennifer Otto. She is the New Mexico Department of Public Safety DNA analyst. She's going to testify about the analysis of the evidence that was sent to her for review and whose DNA was on what and what kind of DNA it was.
So the only relevant item here would be the rifle the two men were fighting over, and there was multiple DNA. She wasn't able to match DNA to the victim, but that's common when there's mixed DNA, and she didn't test for DNA at all. On the most prominent place on the rifle, you would expect someone to grab if they were fighting over it, and that's the barrel of the rifle. This rifle has a very lengthy exposed barrel past the forearm of the rifle. Didn't bother testing that for DNA.
And finally, you'll hear from Dr. Heather Gerald of the Office of Medical Investigator.
They got the PowerPoint idea from Legal Bites.
Investigator there at UNM. And she conducted the autopsy of Guillermo Adiola. She's going to testify that Mr. Adiola had 2 gunshot wounds to his body. The first gunshot wound was to the head, and it entered at the right temple with a trajectory of right to left and downward. Dr. Gerald will testify that there was a second gunshot wound of the chest, and it entered at the supraclavicle region of the chest and exited the left side of the chest. As I stated, ladies and gentlemen, this is a case of reasonableness.
But left unsaid, of course, they also did toxicology on the victim, and the victim had alcohol, cocaine, and marijuana in his bloodstream. And just before the testimony of the medical examiner, the state tried to get the toxicology results excluded from evidence. That sounds like justice, right? They failed. It ultimately was brought into evidence by the defense. But they don't mention the tox at all here in opening.
A second-degree murder is a homicide committed without having been provoked, and a voluntary manslaughter is a homicide committed after having been sufficiently provoked. And the judge is going to give you the definition of what sufficient provocation is. Again, this case isn't about who did it or how it was done. The facts for you, ladies and gentlemen, are to decide whether this homicide was committed in self-defense or whether it was committed with or without sufficient provocation. This is a case of reasonableness, and you are the finders of fact. You are going to determine whether or not Mr. Cummings' actions were reasonable on that day when he shot and killed Mr. Adiola with an AR-15 rifle when he only had mace. And I surmise to you that the evidence will show that there was no struggle.
The prosecutor speaks so poorly. So she's actually touching on a number of different elements here in self-defense. Again, the cheat sheet is free, folks. Let me take just a moment to step through these so we know what we're talking about here. Make myself a little bigger. So the 5 elements, they're no big secret: innocence, imminence, proportionality, avoidance, and reasonableness. She keeps talking about reasonableness because it's kind of an umbrella element that sits over all the others. Everything that a defender perceives, decides, does has to be reasonable, meaning he has to genuinely believe it's necessary for self-defense. And that belief by itself, however genuine, is not by itself enough. A reasonable and prudent person in his circumstances would have shared that belief. So you have to have that subjective, reasonable belief, and the belief has to be objectively reasonable. 2 sides of the coin that make up the element of reasonableness. But the other elements matter too. You have to be the innocent victim of an unlawful attack. The attack you're facing has to be either actually occurring or immediately about to occur. The force you're using in self-defense has to be proportional to the force against you. That's what she's bringing up when she's talking about the victim here had mace and the defender had a rifle. She's trying to raise that question of proportionality. And avoidance is not an issue here for technical reasons. It's not a stand your ground state and so forth. But if any of those elements can be disproven by the prosecution beyond a reasonable doubt, either the arguments she's making here seem to be there's a lack of proportionality, rifle versus mace, and or the defender's perceptions were unreasonable. If he loses the element of proportionality or loses the element of reasonableness, if the state can disprove either of those beyond a reasonable doubt to the satisfaction of the jury, then they've disproven self-defense. And in a self-defense case, if you disprove self-defense, you've won the conviction, because an inherent part of claiming self-defense in the first place is you're not saying it wasn't me, I didn't shoot the guy. You're saying I did shoot him, it was me, but I did it in self-defense. If the prosecution can wipe out self-defense, disprove it beyond a reasonable doubt, the only thing left is effectively a confession. And that's what we're dealing with here. If the state can disprove, it seems like they're trying to disprove reasonableness or proportionality, they've disproven self-defense, they've won the case. They won a conviction. On the issue of proportionality, and of course, when she says reasonable, she's really trying to suggest, was the defendant's decision to use a rifle against a mace attack reasonable conduct? Given that we think of mace as a less than lethal force, non-deadly force, and of course, a rifle is deadly force. And the element of proportionality normally requires you can't use deadly force until you're facing a deadly force threat. But there's more to this fight than just the mace. The defense does argue that the defendant was being pummeled, struck with the mace about the head, that the defendant picked up the rifle, they would say, to be prepared to defend himself from perhaps an escalating attack. But then the victim grabbed the rifle. The 2 men are now fighting over the rifle. That's a gunfight, folks. As the defense will say, or maybe even the prosecution says it, I forget, but whoever ends up with the rifle lives, and whoever doesn't end up with the rifle dies. That's a deadly force fight at that point. So frankly, I think if you're all amenable to self-defense, it's the proportionality is not really an issue here. So again, I don't see much that the state has to work with. But let's listen to the last few moments of her opening. What happened looks a lot like self-defense. Oh gosh, sorry folks, we didn't miss much. Sorry about that. Sorry. Here we go.
no struggle in the bedroom, that little bedroom on February 29th, 2020, and the evidence will show that this was not a justified homicide. Mr. Adiola cannot speak about what happened in that little room on that day, but the evidence will show what happened on that day.
And most of what
And at
happened
the end
looks
of
a
the
lot like
case, the
self-defense.
state, we're going to ask you to find Mr. Cummings guilty of second-degree murder or the lesser included offense of voluntary manslaughter for the killing of Guillermo Adiola. And we will ask you to find the defendant guilty of tampering with evidence for him washing his hands, his face, and changing his clothes after the homicide. And we will ask you to find him guilty of concealing his identity when he refused to identify himself to the law enforcement officers on that day. And thank you for your time.
Now, there's two defense attorneys here. They're both women, of course. The defendant's sitting between them. The one on the left is going to give the opening statement. And I think that's the right choice here. I think the one on the right, Carrie Morrissey, is actually the better criminal defense attorney. But one of the qualities I like about her is she's very, very disagreeable. It's a very masculine trait, which is good for a criminal defense attorney. But it might be off-putting. Remember, this is the first time the jury's hearing from the defense. And, you know, if you're super disagreeable, you might kind of want to phase it in and not have an abrupt shock to the jury about how disagreeable you are from the very first moment. So I think they were smart to pick the more agreeable of the defense attorneys to do the opening here. It did sound like she was reading, didn't it? Like that's what I thought too. Is like a junior high school presentation on like how I would do an opening statement when I'm an adult.
Counsel. Ladies and gentlemen of the jury, good afternoon. This case is not about who did it. Ms. Walker is correct, because Guillermo Areola was shot and killed by Dean Cummings.
This is Nicole Moss.
There's no dispute in that.
Defense.
So the question before the court, before the jury, isn't who killed him, but why. And the evidence is going to explain to you why that happened. The facts that led up to the death of Mr. Areola. Mr. Cummings told the police when he called 911 that day. He called them and he told them, "My name is Dean Cummings. I just shot and killed a man in self-defense." So he told the police that right away.
New Mexico courts
and he told David McCullough that right
folks.
away. Because after this shooting happened,
New Mexico is pretty liberal.
Mr. Cummings reacted. He was in the middle of nowhere, and you're going to hear evidence, and Ms. Walker showed you some overhead photos of where this occurred, the ranch where this occurred. It was out in the middle of nowhere. It's a remote area. There is no cell phone service out there, not for miles. It's a place that is.
I had actually heard that the trial judge here was amenable to not requiring masks, but because this is being televised, someone in state government called him and said, "You better put masks on those people." So I don't know if that's true, but that's what I was told.
So remote, there are no neighbors, there's no other buildings. You have to drive for miles before you reach anyone or anything. And that's where Mr. Cummings found himself on February 29th, 2020. Because as you heard from Ms. Walker, and you will hear in the evidence, Mr. Cummings was looking to purchase some land. He grew up in New Mexico, Los Alamos to be specific. He grew up
very
here.
nearby this ranch.
He spent his childhood in New Mexico before leaving for Colorado and then Alaska. And then in 2019, he returned to New Mexico. Mr. Cummings is an outdoorsman. He's a man who loves to be out in the wilderness, to be out in remote areas, to live off the land. And so he was looking for a piece of land back home here in New Mexico where he could build a home, start a new life.
This is a good line for the defense because the man who was killed, the victim here, was apparently well liked in the community. And of course, Dean Cummings, having only returned after decades away, is a stranger to the community. And the jury, of course, is pulled from the community. So they want to emphasize that Cummings is not really a stranger. He grew up there. He's just coming home.
And Mr. Areola owned property that was what he was looking for. This property out there, out near San Luis, San Ysidro area, near Cabazon Peak, remote, beautiful land. So Mr. Cummings and Mr. Areola were planning this real estate transaction. And Mr. Cummings was excited about his future. And you're going to hear evidence about this real estate contract that they were negotiating. And Mr. Cummings had every intention of buying that land. And in the meantime, he was permitted to stay out there. He put his RV out there, and he was allowed to stay in this little trailer. Mr. Areola encouraged him to stay out there, encouraged him to get to know the land, the property, the trailer. There were some horses out there. Mr. Cummings was helping take care of the horses, feeding them. And that's what led up to this incident on February 29th. Mr. Cummings was staying there, as he had been told and encouraged to do, when Mr. Areola showed up. He showed up unexpectedly. Mr. Cummings and Mr. Areola started talking about this real estate contract, and they started arguing. It was a verbal argument in the kitchen of this small trailer. And while they were arguing, all of a sudden, Mr. Areola attacked Mr. Cummings. Without any warning, Mr. Cummings was all of a sudden fighting for his life. Mr. Areola and Mr. Cummings were in this physical altercation. It led down this very short hallway to a small bedroom.
Really small bedroom.
And it was during this physical altercation that Mr. Cummings realized that Mr. Areola had something in his right hand. You're going to hear testimony Mr. Areola was right-handed. You're going to hear testimony that Mr. Areola routinely carried a canister of mace with him. Mr. Cummings
Not exactly this one,
didn't
but
know exactly what it was, but all he knew was that he was being struck with this thing in Mr. Areola's hand over and over again. During this altercation, Mr. Cummings was able to grab his rifle that he had sitting there. He had recently purchased a scope and was putting the scope onto the rifle, which is why it was sitting.
By the way, folks, this goes to, of course, proportionality, because it would be one thing to spray someone with mace, which I would argue, by the way, a defensive use of mace may presumptively be a use of non-deadly force, but an offensive use of mace, especially if the other party's holding a weapon, a firearm, I would argue an offensive use of mace under those circumstances is reasonably perceived as a deadly force attack, one likely to proceed to death or serious bodily injury. But in any case, if you're not just spraying someone, but you're beating them on the head with an object, is that an attack reasonably likely to cause serious bodily injury? I would suggest that would be a reasonable perception, which makes it a deadly force attack, against which deadly defensive force would be justified.
There, he grabbed the rifle, and he and Mr. Areola started fighting over this rifle. And it was during this struggle, Mr. Cummings has one hand on this rifle. He has his other hand blocking, his left hand blocking Mr. Areola, who's repeatedly striking him. During this struggle between these two men, all of a sudden, Mr. Cummings realized that his eyes were starting to burn, his lungs were starting to burn. Something had been sprayed. He didn't know what this stuff was.
This is another piece of deception by the state. So the defense never claims that the defendant was sprayed full on in the face. But this is a very confined room, folks. It was like 5 foot by 8 foot or 8 foot by 10 foot. It's really, really small. And even an incidental discharge of mace in a confined space like that, everything in the room is exposed. You'll feel it burning your eyes, burning your throat. You'll feel like you've been sprayed with something, but it could be an incidental. contact or exposure to the mace. And the state makes a big deal about saying that, well, the evidence doesn't support that he was, soaked in the face with this mace. But of course, the defense never claims that that's what happened.
But at the same time, he starts to feel this burning sensation. He feels Mr. Areola pulling on the rifle. They're fighting over control over this gun. Whoever wins is going to live. Whoever loses was going to die. And during the struggle over this gun, the cap on the scope of the rifle comes off. And that's important. And you're going to see the evidence. You're going to see photos of that cap. That cap had been taped onto the scope with electrical tape. Mr. Cummings had taped the cap on with electrical tape, so it was on there good. And you'll see photos, and you're going to see the evidence that shows that the cap from that scope ended up underneath Mr. Areola's body because it came off during a physical fight for control of that gun. During this struggle for the gun, shots went off. You're going to see photos of bullet holes in the trailer. That is important because those bullet holes, or we call them impact sites, a lot of times that's what we refer to them as, those impact sites tell the story of what really happened in that trailer. And you're going to hear from an expert who's going to explain that to you. But some of those bullets sprayed down the hallway and out of the trailer. Three bullets went out the trailer on the other side of the trailer from where the small bedroom was. And that shows how this fight was progressing and continuing as these men are fighting each other for control of this gun. They end up in this small bedroom, and Mr. Cummings ends up basically trapped in that room. Mr. Areola's in front of him. The only way for him to escape is through Mr. Areola. And you're going to see other impact sites on the floor in that bedroom, and those impact sites are really important. And you're going to have an expert who's going to explain to you why those impact sites are so important. And the reason that those impact sites are so critical is because what they're going to show you is that at some point during that struggle, the gun that ultimately killed Mr. Areola, that firearm was upside down, almost on the ground, when it went off. Again, the evidence will show that that gun was upside down, literally almost on the ground.
So I should clarify this because I found this very confusing when she first described it. Legal Vices and Megan Fox are waiting to come in. I'll bring you guys in just a second. Let me just finish this thought. Later on in the trial, they actually have the rifle there as an exhibit. And what she means by upside down, she doesn't mean the muzzle's pointed at the ground. She means if you took the rifle horizontally and flipped it, so the muzzle, the scope on top is now facing the floor. That's some of the rounds were discharged when the gun was in that position, which would be consistent with a struggle over the weapon. So that's what she's trying to describe here. Not doing a great job, but of course they get to circle back with the actual exhibit. All right. Legal Vices, hey. You're alive, my friend.
Well, it's kind of the old Addams Family, kind of the lurch feeling. I must admit, I've had better days.
So Legal Vices was celebrating what, your 32,000th subscriber on his YouTube channel the other day and last night. And it was
if it was 31,587, that's what I would have been celebrating.
Okay.
10 hours.
And Megan Fox. Hey, Megan. Hey, Fox.
Hi, how are you?
What's up, MF?
Can you hear me okay? Because I'm on my phone. If I sound terrible, I'll pop out and head to my studio.
No, it sounds okay. It's a little reverby, but nothing disruptive.
Okay, good. I'm good. I'm just doing laundry. So I thought I would catch up on this trial with you because it's interesting. I didn't even know what was going on. So
I'm so happy they gave him apparently a do-over on opening statements.
Yeah, I thought it would just kind of, now that we've heard most of the state's case in chief, we've been playing catch up. We've been a day or a day and a half behind because this trial wasn't on my radar screen either until someone brought it to my attention late Tuesday evening. So that was the first day of proceedings, so I missed the first day. That was opening statements. But we've been playing catch up ever since, and today we have the last 3 hours of the state's case in chief before they rest. Tomorrow, Monday, the defense will start with their case in chief. But for today, because the yesterday's proceedings were only 3 hours, I thought we may as well take the first 30 minutes and just go over the opening statements again, so to kind of recalibrate our expectations for what we were supposed to have seen in the case's state in chief. And of course, the argument here is that the defendant's charged with murder. The defense is self-defense, which means that the state has to disprove self-defense beyond a reasonable doubt. And they kind of said they were going to do that in their opening statement. Most of what they said in their opening statement had actually nothing to do with what their legal burden is. They don't actually come anywhere close to that so far in their case in chief. And now this is the last few minutes of the defense opening, which has a lot more. It's a lot more coherent. Their narrative of self-defense, their opening is much more coherent, much more narrative-based, storytelling-based, much more concrete, internally consistent about what they're going to be presenting. Now, of course, we haven't heard their case in chief yet. They've only been doing cross-examination of the state witnesses, and the state witnesses have been horrifically bad, especially the law enforcement officers. Just absolutely terrible, profound lack of competence in performing their jobs. And more importantly, at least until these last 3 hours, which we'll cover today, there's been really no evidence inconsistent with self-defense. When the state has to disprove self-defense beyond a reasonable doubt, the state asks a lot of questions that are actually defense type questions. Like, isn't it possible that this happened? Or could this be the case? Or it's all a lot of ambiguity, uncertainty, possibility, where again, it's their burden to disprove this legal defense beyond a reasonable doubt. So
what stood out to me in the state's case is that they tried to claim that he washed his hands and his face after being sprayed with something, and that shows evidence that he was hiding evidence. Like, excuse me?
Tampered with evidence. That's one of the criminal charges in this case.
Yep.
And of course, it's ridiculous. He never tried to hide anything. He was very open about what he did and why he did it. There's an explanation for the conduct that's consistent with innocence, which makes it not a crime. I mean, then you're not proving a crime beyond a reasonable doubt.
And then the other crime of not identifying himself or hiding his identity from the police officers when the first question was, so did you ever ask him his name? Well, no.
Okay.
For an hour and a half, they didn't ask his name.
Didn't he actually give his name on the
his first
call?
name.
The 911 call,
Yeah,
the
911
first
call's his
witness
name,
on the scene. I mean, he'd identified. He was never trying to hide his identity. One cop, I think there came a point where he was like, I don't know if I should be talking to the police for obvious reasons. So that one cop, he gave him his first name. He'd already identified himself to other cops. So, but to this particular cop, he gave him his first name, and then he didn't want to talk anymore. And that cop decided to charge him with, concealing his identity, which is ridiculous on its face.
Yeah.
Seems ludicrous.
So last few minutes here of the state's opening, and then we'll catch up on yesterday's proceedings.
When 2 shots were fired. That shows you that there was a physical fight, a struggle occurring over that firearm. You're going to see that firearm. It's going to be in this courtroom. You're going to have a chance to look at it. And it's important that you take a close look at that firearm.
Because it's not an AR-15.
Yeah.
No matter how many times the state says it, it's still not true.
Technology.
Well, they did eventually change to AR style platform.
It still isn't. It's not even that. I hope that's tea, Jeff.
It is. Yeah. I went out to dinner with friends, and when your group of friends look at you and go, "What happened to you?" is the first thing out of their mouth. And then, "What are you going to have to drink?" I say nothing, and they say, "Are you okay?"
This is a photo of that gun that was taken by an investigator with the Office of the Medical Investigator. What you're looking at there, this is the AR-15 that was involved in this struggle. What you see there is some kind of residue or spatter that dried on that firearm that is consistent with Mr. Cummings' story that something was sprayed at him that day during that struggle while they're fighting over that gun. You're going to be able to look at that firearm.
So yeah, I see someone in the comments mention it too. This is a nice touch by the defense, right? Because one of their arguments is we know there was a struggle because we know shots were fired when the rifle was being held upside down with the scope towards the ground. And now they're showing the jury a photograph of the rifle upside down with the scope towards the bottom of the photograph. Normally you'd naturally show the photograph in the proper orientation, in an upright orientation, but they're showing the photograph in a manner that's consistent with their narrative of self-defense. It's just a nice theatrical touch.
When it's in this courtroom. So those are the two important things about that firearm that the evidence is going to show. One, this residue or spatter that dried on the gun. And two, that the muzzle created those marks on the floor, showing that that gun was literally on the floor or almost on the floor when it went off at least twice.
She's talking about the pattern of discharge from the rifle that comes out of the muzzle brake or the flash suppressor on the front. It only had vents on the top of the muzzle brake, but you can see the pattern from those vents on the floor, meaning those vents must have been facing downward.
You're going to hear evidence from Dr. Gerald with the Office of the Medical Investigator, as Ms. Walker indicated. Officer Gerald conducted the autopsy of Mr. Areola. And there's a couple of important details that she's going to tell you about what that autopsy revealed. First, the trajectory of those bullets. Mr. Areola was shot and killed by 2 bullets. Both of those bullets entered in a right to left trajectory. One through his temple and downward, and ended up in his chest. The other one entered on the right side of his chest and went through and exited on the left side. So those 2 bullets, both right to left in a downward trajectory. Dr. Gerald will be testifying to that, and you'll probably see some photographs that also help to demonstrate some of that.
That actually could go both ways. So the defense is suggesting this weird trajectory would be consistent with the struggle over the gun. The muzzle's going everywhere, and it's not just 2 men facing each other and one of them gets angry and shoots the other in the chest. That's not what happened here, or shoots him in the back. That's not what happened here. The state's going to try to argue that perhaps the victim was like on his knees and shot from above, like in an execution type manner.
The other thing that she's going to tell you is that Mr. Areola was intoxicated at the time of
Such
this
an
altercation.
unfortunate name.
He was intoxicated
Areola
with
or
alcohol.
Cummings?
He
Yeah.
had cocaine in his system, and he had marijuana in his system. And Dr. Gerald will explain to you the significance of that combination of alcohol and cocaine when it's in someone's system at the same time. You're going to see photographs that detail the scene. And again, I explained, you're going to see photographs of those impact sites that tell you the story of what happened in that trailer.
And most of them are very
Impact
close to
sites
the
that go
ground.
down the hall out of the trailer. The other
They're close to
impact
the floor.
sites next to Mr. Areola's body that show that the gun was on the floor when it went off. And you're going to also hear testimony from an expert by the name of Aaron Brudenell. Mr. Brudenell is a forensic scientist who has spent decades working with the Arizona Department of Public Safety. He is a forensic scientist. His full-time job is working for the prosecution in Arizona. He analyzes crime scenes, especially when there are firearms involved. And he reconstructs shootings. He took the evidence that was gathered by the New Mexico State Police and the Sandoval County Sheriff's Department. He took that evidence and he examined it and he reconstructed what happened in that trailer that day. Mr. Brudenell is going to testify that he closely examined those impact sites that I've just briefly described for you. And he's going to tell you that the physical evidence that he saw is consistent with some kind of physical struggle occurring over that firearm.
Well, that's not good for the
So at the end
prosecution,
of
is
this
it?
trial, there is not going to be a dispute about the fact that Mr. Cummings did shoot and kill Mr. Areola. And the evidence is going to show that he acted in self-defense. The evidence is also going to show that he did not conceal his identity at any point in time. In fact, the evidence will show that he placed a 911 call to the police, identifying himself and explaining what had just happened in that trailer. The state has also charged Mr. Cummings with tampering with evidence, and I'm just going to briefly address what the evidence is in that. The state is going to ask you to convict him of tampering with evidence because he washed his face, washed his hands, and removed his clothing after this incident occurred. However, what did Mr. Cummings do with that evidence? What did he do with his clothing? Well, the prosecution's own witnesses are going to testify that Mr. Cummings put his clothes on the back of his pickup truck. And the prosecution's own witnesses are going to tell you that when the police arrived on scene, he told them where his clothing was. He asked them to collect his clothing and test it for whatever he had just been sprayed with. So the evidence is going to show
And the rifle is still up on the
that
screen in
Mr.
the
Cummings
courtroom.
acted in self-defense, that he did not tamper with evidence, and that he did not conceal his identity. That is what this evidence will show. Thank you.
Was he supposed to suffer? Like, was he supposed to
Yeah.
suffer with the pepper spray? Is that what the state wanted him to do? Not
Apparently.
wash?
So
It's
I know I
insane.
can see in the comments a lot of people saying, well, I don't know, this looks sketchy to me. This looks sketchy to me. It's maybe it wasn't self-defense, but that's fine for discussion purposes, of course, but that's not the legal question here. The legal question is not do you think it was or was not self-defense, or do you have doubts about self-defense? The legal question is, can the state disprove self-defense beyond a reasonable doubt? None of us will never know with absolute certainty whether this is self-defense or murder. We can't know. We weren't there. Nobody else was there. But that's not what the law requires. The law doesn't require absolute certainty. The law places burdens of different legal thresholds for different issues of a case. And for this issue, the legal defense of self-defense, the burden is on the state to disprove self-defense beyond a reasonable doubt. That means you could think it's only 30% likely that this was self-defense, 70% likely it was a murder. And that's an acquittal because they have not disproven self-defense beyond any reasonable doubt. That's the legal question here. And frankly, from what I heard of the state's evidence, and I did a different show earlier this week about involving a different shooting where I brought this up, but we have a real problem with probable cause thresholds for dragging people into criminal trials in this country. To my mind, the appropriate threshold for probable cause, the amount of evidence that should be shown before you can drag someone into trial, should be a preponderance of the evidence. It's at least 51% likely that this person committed a crime. It's probable. To me, that's what probable cause means. It's probable they committed a crime. Now we're going to drag them into court to prove it beyond a reasonable doubt. The real standard for probable cause is complete bullshit. It doesn't exist. It's tissue paper. If the state can come up with a narrative that if you believe everything they say is true and there's no counter argument that it would have been a crime, like 5% of the evidence, you get dragged into a criminal trial. This guy spent 2.5 years in jail waiting for this trial. And so far, the state's been completely lacking in a compelling narrative of guilt, but he could still get convicted. Juries are dangerous and unpredictable creatures. So there's a lot of risk, at least 10% risk of getting convicted, no matter how innocent you are, if you're put in front of a jury. And you ought not be put to that risk at the whim of the state. We're supposed to have things like grand juries and probable cause hearings. So you're not put at that risk at the whim of a prosecutor.
It doesn't sound like the state has very much evidence in this. I think it sounds like a terrible case for the state. I don't know why they would have brought this either. Very confusing to me.
And frankly, after the Rittenhouse trial, I had proposed something called the Rittenhouse law that would actually hold prosecutors personally accountable if they brought a case to trial And afterwards, the jury, with a special verdict form, said, you know what? Not only could they not disprove self-defense beyond a reasonable doubt, they didn't even have a preponderance. They not only couldn't they disprove it by 95% of the evidence, they didn't even have 51% of the evidence. They were that far short. Under that circumstance, a prosecutor should be held personally liable for the expense and damages to that defendant, because as a prosecutor in a self-defense case, going in what your burden is, what your burden will be, that you'll have to overcome self-defense beyond any reasonable doubt. And if you can't even do it by a mere 51%, that wasn't a case that was brought on the merits.
I wish I had something to argue with you about that. I mean, that's, and even grand juries, they would say grand juries can indict a donut if they want to,
Well, the trouble with the grand jury process, of course, is that the grand jury really only hears one side of the argument. They only hear the prosecutor's side of the argument. The defense is not allowed to present. The defense has a modest ability to impeach the state's evidence, but they can't really present a defense narrative to the grand jury. And we all know as human beings that if you only hear one side of a story, it's likely to sound compelling. And then it's not until you hear the other side that you see all the weaknesses. Hey, Megan has come back on her computer. I just have to find my cursor, Megan. Let's see. Where is it? Where are you? I have 3 giant screens here. Okay.
Hey.
There we are. Hey,
Megan. Good to see
Hi.
you.
Good to see you too. Yeah, this case is a strange one to me, and I agree with you. I think the prosecution should be held liable if they and I like the idea of having the jury decide, hey, this shouldn't have been brought forward in the first place because there just wasn't the evidence. What is it with prosecutors? Is it that they're just desperate for those numbers, those convictions to go up? But if you think if that was the case, they would pick better cases than something.
A defense lawyer doesn't get fired from his job if he loses, because they just pretty much assume they're going to lose going in, unless it's a cut and dried case. But the prosecutors, they need to keep their jobs. If they keep getting L's, so it's the idea, just throw everything against the wall, and then you hope that you can get some sort of a plea bargain out of it. Plead to something lesser that, whether it has a jail sentence or not attached to it, and that goes up as a W in your column, whether or not you believe this guy had sufficient evidence.
I would like to think if I were a prosecutor, I would choose better cases I knew I could win, instead of cases that I'm just hoping to throw it up against the wall. And because you're talking about somebody's liberty.
We have these politically energized or racially energized cases. Rittenhouse was politically energized. George Zimmerman was racially energized. And in those circumstances, if you have a politically motivated prosecutor, it's a no-lose scenario for him to bring the case to trial. The worst that can happen is it's an acquittal. And so he lost the case in a technical sense, but he still fought the good fight for his political team. And he wins political capital for doing that. That's what we saw in the Zimmerman trial, for example. Zimmerman was acquitted of all charges. And you'd say that, well, the prosecutor there, she lost that case. Well, did she lose the case? Because she was actually running for re-election and was about to lose re-election in a district with a largely African-American electorate. She happened to be white. And there were marches against her in that district as she was running for re-election by the Black community. Al Sharpton was marching against her. The whole thing was going on, the whole circus. And then she charged Zimmerman and brought him to trial. And now there are marches for her in that community, and she won re-election. So if you define the goal in the normal, traditional legal sense of winning a conviction, she lost. But if you define the goal in terms of politics, she won. She won her re-election. She didn't lose that case.
I hate that about our justice system. It shouldn't be.
And of course,
political.
in Rittenhouse, we had different political considerations going on, right? It was less race and more kind of Antifa and, who do you want to support? A Second Amendment versus Antifa kind of thing. I don't know what the politics are here because I'm not sufficiently familiar with the area. I have heard that the victim was well-liked in the community. He's Hispanic, of course. This guy's white. I don't know if that's playing a role here, but there certainly seems to be, there have to be some factors at play other than legal merit, because so far the state's not brought forth any legal merit for charging this case. All right, so let me take a quick look at the super chats. before we start up yet on yesterday's proceedings. Sean Bailey, $5. Yeah, the super chat's got to be $5 minimum, folks. He says, thank you very much, Sean. Says, come on, Andrew. Wait. Nope, that's not it. There we go. That's the right button. Thank you very much, Sean. He says, come on, Andrew, you keep talking constitutional law when we're now a nation of social justice. Yeah, that's one of the downsides of social justice, tribal justice, my team against your team justice, is we end up with this kind of chaos. And folks, I would suggest that if you put any kind of prefix on the word justice, whatever you're talking about, it's not justice.
Mm-hmm.
Let's see if there's any Rumble. Oh, there is. Let's see. By the way, for those who don't know, we're streaming on YouTube, on Rumble, on Twitter.
Oh, I need to get over to the Rumble chat too.
I didn't even know you could do that until recently. So we're live streaming on Twitter, and of course to our Law of Self-Defense members at Law of Self-Defense, which you should all be, folks. It's less than $10 a month, 30 cents a day, and you don't have to pay super chat money to YouTube for me to read your question, answer your question, or read your comment. Or at Rumble, you can do whatever they call it. What do they call it? Rumble Rants?
Rumble Rants.
Yeah.
Okay.
Yeah, Rumble Rants.
So here's one from House Fur, $10. Thank you very much. Hit that plus sign. Yeah, if you're on Rumble, please hit the plus. As Legal Mindset says, hit the plussy. You want to hit that plussy hard.
No. It's pound the plussy. Pound
Pound
it.
the plussy. Okay.
Yeah.
And
Or sometimes
so thank you
stroke.
very much for that $10. If you're on YouTube, please hit the like. In fact, I'm going to take a look. How many likes do we have compared to how many people? Folks, if the likes stay below 50% of the people watching, I'm just going to stop the stream because we all have other things to do on our Saturday. And right now we have 900 people watching and 300 likes. So we got to fix that. Another 200 of you within the next few minutes better hit that thumbs up like button or this show's over.
I got to do it. I'll do it. There we go.
So, I mean, and no one's here to waste our time. The likes are free. That's the most powerful metric YouTube uses to share our content more broadly. And that's the only reason I'm here on a Saturday, is that try to grow my Law of Self-Defense community, make more people aware of us. So please hit that like button. I know you don't normally think of it because you're just busy enjoying the content. That's great, except you got to hit the thumb. Hit that thumb. All right, let me pull up yesterday's proceedings now. We'll when we start up, we're going to have I think the judge will be walking in. Yeah, he'll be walking in. They'll bring in the jury if the jury's not already present. Normally they wouldn't be present yet. And then the state will continue with its witnesses presenting its case in chief. It'll be a relatively short day because I think they only had about 2 hours 40 minutes is the video from yesterday's proceedings. And I'll play it faster than normal. At least the state's portions, I play faster than normal because it's boring and they don't have much to talk about. The cross, especially if it's Carrie Morrison, I'm going to play at normal speed because
I feel like this is fun. This is the best way to catch up to do trials so that you can fast forward through the boring parts. Maybe we should do this more often.
No, the trouble is there's already people talking about what happened yesterday, right? In other streams. So you're kind of behind. I mean, there was nothing I can do about it. I can only catch up so fast. But starting Monday, I'll just be covering it live like normal.
Cool.
All right. Let's see. What do we got? Whoop, not that one. Not that one. That one. And the defense attorney on the left here with the red jacket is Carrie Morrison. She is the one to watch. She is the pit bull in the courtroom. And the likes are up over 540 now. We're over 50%. Keep hitting the likes. Don't stop, folks. It should be 100%. 100% likes, right? One for every person watching.
Your chat listens to you way better than mine listens to me. I'll tell you what.
Okay, but
if you've been watching more than 30 seconds,
right?
I want like it if you've been here more than 30 seconds.
I want likes beyond a reasonable doubt, folks. That's like 90%, 95% of the audience should have hit the like button. But if you don't hit at least a preponderance of the evidence,
yeah.
Well, you have. So thank you very much. I really appreciate that. All right, let's go ahead.
Good afternoon. They're bringing in the jury. Are we ready to go, counsel?
Yes, Your Honor.
We're going to bring in the jury.
They pan the camera up. There have been some funny moments with the courtroom camera. They showed an autopsy photograph at one point, which I'm sure they were not supposed to do. They showed a member of the jury. It was very low resolution, so I don't think you could actually identify the juror, but it showed a corner of the jury box, which I know they're not supposed to do. And if you see the masks, this is not a trial from 2 years ago, folks. The event was 2.5 years ago. New Mexico still requires masks.
Yeah, can you
David, call your
believe
next
that?
witness.
I hate it. I hate not being able to see faces, and I also can't hear them. They're muffled.
People are saying they hit the like button for me because I have a gun. It's true I have a gun, but that shouldn't be the reason you're
They
hitting
said
the
they
like
were afraid that you would shoot them.
Yeah.
Everybody in New Mexico has no one's short of food, I've noticed, and all these witnesses. Everybody gets plenty to eat in New Mexico.
Now we need to get this guy and then the bulky bailiff to
Good
like do a big
afternoon,
wrestling
sir.
match,
Good
big
afternoon.
sumo match.
Can you please state and spell your name, please?
So just to remind everybody, what are we looking for from the state's witnesses? Evidence that a reasonable jury could interpret as disproving self-defense beyond a reasonable doubt. So let's see if we hear anything like that from this guy. We haven't heard it from
Also-
any state witness so far.
Yeah, I'll settle for
Frank
coherence at this
Tomlinson,
point.
FrankTomlinson.
And where do you work, sir?
San Juan County Sheriff's Office.
What is your position at the Sandoval County Sheriff's Department?
Currently, I'm a lieutenant over our criminal investigations, our civil division, animal control, SROs, school resource officers, and hopefully
Do they
soon
make
chapters.
extra large masks? It
I
looks
was
like
gonna
the,
And what was your assignment, sir?
If the mask doesn't fit, you must
In
acquit.
2020, at that time, I believe I was assigned to just patrol.
This poor guy.
And are you a full-time sworn, salaried, and commissioned peace officer?
Yes, I am.
How long have you been with the Sandoval County Sheriff's Office?
Since 2016, so
He sounds like potentially
8 years.
criminal Sean.
Okay. And prior to your time with the Sandoval County Sheriff's Department, where did you work previously? Have you worked in other law enforcement entities?
yes. Previously, before coming to Sandoval County, I was with Corrales for about 8 or 10 years. Prior to that, I've worked for tribal agencies such as Sandia and Pueblo of Jemez. I originally was got my New Mexico certification.
that's
in
an unfortunate
1997.
glove box placement
Okay,
behind his.
so how long is your total time in law enforcement?
Are you ready for your prostate exam, sir?
27, 26 years.
Okay.
Yeah, I'm going to speed it up. Sorry,
So
folks, I just forgot.
As the, you said you were a sergeant.
I'm going to go
over the field at the
1.5.
Sandoval
No, I was a lieutenant.
County?
over
The
patrol.
lieutenant over the field?
Now
What
he
were your duties
sounds
as
normal.
lieutenant?
At that time, I was basically just in charge of the patrol operations, supervising sergeants and patrol deputies, and everything that handles on a day-to-day basis. During the
Investigating
time of
donut
this
shops.
incident, I was the lieutenant over CID. I believe was out of town, and I was filling in and taking over his responsibilities as far as on call.
Can you tell the jury what CID is?
Criminal Investigations Division.
Okay. So what kind of specialized training have you undergone, sir?
Currently, I have a command level certification through the state, which requires, I believe it's approximately 15 or 1,500 hours.
This
of
guy's
advanced
prostate
training
might be the size
in
of
any
an
different
antelope.
fields.
I mean,
Most
come
of
on.
mine have been in investigations related, white collar, violent crime, sexual assaults, and so forth. Crime scene
Last
processing.
thing, I'm fat, and if I'm calling you
Do you
fat,
have
you're fat.
another position that you also employ as well?
Up to a month ago, I was also employed by the Office of the Medical Investigator.
And what was your position there?
I'm a field deputy medical investigator.
And what do you do in that capacity, sir?
So at the time when I was working, I would respond to scenes, conduct a field investigation, which included examination of the body, photographing, working with law enforcement, conducting medical related interviews, basically gathering all the information that I could for the doctors down at the main office in case they needed to perform any autopsies and such forth.
So you would be conducting an investigation alongside law enforcement as well?
Yes, the system's designed to basically parallel law enforcement, and the theory is that if we both come to the basic same conclusion as to why this person is deceased, then we got it right.
And how long did you do that position for?
2014 is when I started, so 8 years.
Okay. And what kind of training did you undergo for that position?
When I first started, most of it's field. You take basically a 1 week training class. I put myself through different online classes.
I'll slow it down to 1 1/4 when he's talking about anything important.
They would provide to us on different aspects of death investigation. Plus, I also took death investigation.
As long as
classes
he's
for my
taking
full-time job.
online courses, he should
And
take
you
something from the law of
classes on
self-defense.
collecting evidence?
Yes.
Tell us about that.
Throughout the years, covers photography, covers collection of samples, both medically and with the sheriff's department, also for evidence purposes. How to process a body, how to process a scene. It's too broad really to get to.
Any law enforcement in the chat can attest that a lot of this training these guys talk about, it's such tissue paper thin training. There's no real examination to test at the end. A lot of it is just cops standing around drinking coffee, telling each other cop stories. It sounds good in the courtroom to people who don't know, but a lot of this, I've had a training in this and training in that. It doesn't mean much.
Specific.
Okay. So as a law enforcement officer and not in your
So it's like
position as an
law
online
CLE
investigator,
classes.
how many major crime scene investigations have you been the lead on?
I would say lead probably
It's like CLE,
20
right?
or more.
Okay. And how many times have you had to testify in court based on those investigations in which you were the lead on?
Maybe 5 or 6.
Okay. How many crime scene or major crime scene investigations have you assisted on
Oh.
as a law enforcement officer?
Probably over 50. And that includes from, controlling traffic control at the scene to being number 2 on the investigative team.
Might those be two different things? Being number 2 in an investigation and telling cars which way to turn at the intersection? For God's sakes. I wonder how many of those 50 were like actually doing anything important.
Okay.
Well, if you're looking for someone to block the road, I know
So
how you
is
can do
Sandoval
it.
County Sheriff's Office a large law enforcement entity?
I would define it more as a medium. We have, I believe we're budgeted for 60.
Do like the
Sworn.
fat jokes.
I could be wrong about the exact number, but it's approximately there. We run, normally our staff
Yes,
runs anywhere between
get closer. It's so difficult to see him.
There's certified officers or in training.
The
in
mask
going
is
to be
making his
certified officers.
ears come
And
forward.
in 2020,
Like,
were
it
the numbers
just
the
looks
same,
so
or were they higher
ridiculous.
or lower?
Cutting
Um,
off the circulation
to
goes
be
ears.
exact, believe
I think
we're
this is a
closer to
danger to the court, man.
55.
If that thing snaps under
I
tension,
know we have an increase in deputies over the past.
that'll be a murder.
So
We'll have
can you
another
tell the jury
trial.
roughly how many deputies there are on every shift?
In 2020, there was,
I've seen
for the
what
entire
snap
county,
mooring
we
lines
had a
can do
minimum
to
staffing of
bodies.
4, and normally, so it runs
Can you hear it
6 on a
creaking?
shift
It's
at
like
a
a
time.
rope on a ship.
Okay. And how many violent crime detectives did you have?
It's
in
like
total?
an anchor line.
So in 2020, we didn't really have a violent crime detective per se. We had a detective sergeant, Sergeant Griffin, and then we had 2 other detectives, and they would just switch off on who would take what case, whatever came up. It was more of an on-call type situation.
So they rotated based on
Check his
on-call
sneakers
Yes.
for salt stains.
shifts. Where's your main
That
office?
mask off, like a
Right
whole
downstairs.
sandwich is
So
going to
in
fall
this
out
room,
from behind
right
it.
Downstairs on the north side.
Are there any substations?
We don't have substations per se. We're allowed, like in Hamas, we can
I'm
use
so
their
glad I'm
facility if we
perfect
need
and
to.
can talk about
In
people.
Cuba, we can use their facility sometimes, for
I
paperwork.
lost
bathroom
25 pounds,
processing,
so
that
I
kind of
feel
stuff.
okay telling
Okay,
fat
so
jokes
what
now.
areas does the Sandoval County Sheriff's Office cover?
It's one of the largest geographic areas in the state that we're required to cover. We go approximately to
Now it's like one of those
Counselors, which is about
recent
100
pieces of
miles
art they
from
do
here,
where they
about
keep
550
pulling
past
back
Cuba,
from the art and it keeps
all the way
getting
to
bigger.
the border of Los Angeles, to Costa
Like the big
Rica,
Hitchcockian
and,
fade
Highway
thing
14,
there.
Highway 16. We also go to the East Mountain off of Highway 14. We have areas up there, La Madera. And then, of course, we do cover a large
The
portion
mask
of,
wearing
Navajo
really
Nation,
does make me enraged, though.
on area Torreon.
The data's
I think
in,
it's-
We go,
people.
uh,
It's
all
I
the way
think
to
it's a
Rio Rancho,
fundamental
Northwest Albuquerque,
injustice to
and
not
part
be
of
able
Pueblo City
to
is also included.
face
You guys
your
know how many
accuser.
stars
Like
there
Yeah, I
literally
agree.
face
Okay,
them, to
so,
read their
can you tell the
faces, to
jury
read their
about the
expressions,
CAD
to see
system
how they're
with your
reacting.
aided dispatch
No,
and
if they
what
feel, if they believe mistakenly, of
CAD
course, but if
system
they
is
genuinely believe
dispatch.
you have to mask
It's
these witnesses
same
for
system that we
safety
have today.
purposes,
Except
then you
for the
can't have a
best
criminal
part, we didn't
trial.
have it in our vehicles.
You cannot
So
have a
we didn't
criminal
computers in our
trial.
vehicles, as you
Yeah,
see
I
a lot on
agree.
cops and so forth, TV shows. We couldn't pull up someone's picture. We couldn't do anything. We
The
didn't have a computer in
jury
our
is
vehicle.
also supposed to
The CAD
look
system
at the
itself,
faces
dispatch,
and
was still the same
expressions
CAD
Yeah.
system.
to see
So
whether
would
they believe
dispatch
them or
calls,
not.
Yes.
How can they
write
do that?
notes, put information in the calls for service, but we just didn't
Clearly
have
this
real-time
cameraman
access
is
to that,
bored
provide
as
that information
hell.
over the radio.
So when you tell the jury,
He's
someone would call in
practicing
and
for
then
when
someone
he
on the
goes
other
to
line would
Hollywood.
type up a log. Is that how you would call it?
A log's a fair
A little
assessment.
foam tip on the
And then more
microphone is
information
actually
would
the
come in
size
and
of a
they would
Coke
ask
can.
for the call. Okay. So how would a deputy get information?
So deputy, if
Who was that
something
character
simple and
from the
quick, we
Harry
just
Potter
communicate
movies? The
with
guy who
process,
just
we would
died,
just communicate
but in the
with
movies,
that.
the
That way.
giant on the
Hagrid.
There's
motorcycle.
going to be a long
Hagrid.
run out.
Hagrid.
So
This is
only one
Hagrid.
deputy
Hagrid's
can talk on the radio at a time. So to avoid, for safety reasons, another deputy needed to be on the radio for emergency and he couldn't. If they had cell service, they would call
Officer
in
Hagrid.
via telephone to dispatch. That wasn't necessarily logged or monitored or anything.
Hey,
So
Harry.
it's bounced between the two depending on the situation.
And was this like real time that this log was being
Where's
created?
the
or was it
Hogwarts
delayed,
PD?
or Can you tell the jury about that?
So when they're getting information, it's not like it's voice activated.
Dragon
It
Cook
reads the
141 on
transmission.
Rumble
A dispatcher
says,
actually
looks
has to
like
type in
Patton
whatever
Oswald's
information
fatter,
and
older
phrases
brother.
and use their own,
Oh, no.
I guess, shorthand, I guess, sometimes in a way. So there's an accountability for like misspellings and stuff because they're listening to different avenues of information and trying to put this all in the log. So they could be processing 2 or 3 different conversations at the same time.
So you testified that Sandia County is a large area of land that you guys have to cover for
Sandoval
your
County.
age. Sorry.
I object. He's probably the largest
And this has a lot
landmass
of
there.
different geographical features, mountains,
He's
hills.
his own county.
Yes.
How does that affect your radio?
Oh, man.
Oh, absolutely.
How many
Officer
residents
zip
in
code.
the county? Oh, just
It's-
me.
It can be so bad at times. Deputies.
His badge
lose
number is
their
just his
areas,
own
dead
personal
spots.
zip code.
If they have to do anything in that area,
Badge-
there's no
his
communication
badge number is
with dispatcher,
XL.
it can be a cell phone or
XXL.
as somebody's been to Camas, through the mountains. You get up there, there's no way to contact people sometimes. So they would have to do law enforcement
Clothing
jobs,
provided by Bob's Tent and
without
Awning.
any request for backup, without any information. So and these spots are not like just in the mountains. They
Oh,
can be.
God. You guys are
in
making me
hilly
cry
places,
already.
Distance, everything. So we have our dead spots that we've identified.
Does this happen in other cases or just this one?
Oh, it happens daily. Whether it's a call for service or whether it's a major crime investigation, it doesn't change the geographics.
Okay. What kind of funding does the Sandoval County Sheriff's Office get?
To my knowledge, I'm not really involved too much in the budget issue at my rank. We get most of
Objection, relevance.
Sustained.
The only
there's a
reason
not-
that's good objection. The only reason the state's bringing this up is because of how incompetent all these law enforcement witnesses have been for the state. And they have to kind of explain it away to the jury. It's like, well, I know all these people suck, but it's a funding issue. It's not my fault. And that's why the defense is objecting. Like, what the hell is this? This has got no relevance to the trial.
Well, that was
Whether or
the-
not
that was
adequately funded. If you can't
That was
prove
the-
your case, you
yeah.
can't prove your case. I don't care if you're adequately funded or not. You don't get
That was
to
the cops'
because
first-
you have inadequate funding.
Yeah, that's
the
a ridiculous
first police
thing.
witness said, did you turn your body cam on? No. Well, do you have one? Yeah. Did you turn it on? No. Why not? It didn't work. Well, how do you know it didn't work? It hasn't worked for 2 months. They can't afford to buy us more. That was how we started this trial.
Yeah.
That's ridiculous. You know what else? I think they should be fined for that. I think they should have to, if their body cams are not working, I don't know why this is not a law across this whole United States that every police officer must have a body cam that's functioning and working on every stop I don't know why this is still a thing. I actually think judges should have body cams too. I think we should have it all. Everything should be on recorded for posterity forever. But
And
I
let's
don't
be honest.
understand how they get away with it. Well, it wasn't working.
And it's not like this guy's on a starvation salary. Let's face it.
Yeah.
He's clearly being paid enough to look like that. Maybe they should cut the salaries and pay for the body cams. I don't know.
It would be funny if like the entire courtroom just started revolving around him. Like
His gravitational pull.
time started slowing down.
Weather
Officer
patterns are
Butter.
developing.
I'll move
Yeah.
on. Let's talk about the body camera issue. Okay.
Sure.
So
course,
in
he'd need, like,
2020,
4
did
body
every deputy
cameras.
have a camera?
if one was available.
Okay. Tell us about that.
So in 2020, we were using, if possible, a system from a Digital Ally. It's a body cam camera system. We only had so
It was
many,
from
that were
eBay.
common to break down. So we tried to keep our deputies.
So I think if we
working
just
on
cut
as-
his food
we
intake in
could.
half, we could buy the body cams
and
as
then
well
if
as
one would break,
hairbrushes for the
our
prosecution.
budget might not allow for them to be repaired. They're quite expensive to
Okay,
repair. Some were beyond repair. We wouldn't replace them. We tried to supplement.
Gloveworks has quite the
digital
product placement there.
Belt tapes, if you'd call them. Just to try to give the deputies every opportunity.
Available in colors that match your attire.
Did deputies sometimes have to purchase their own, or did they have that option?
The deputies did have the option to
Why do they
purchase
have
and use
those
their own
there?
belt tapes, their
Are they
own.
also using gloves
time,
in the courtroom?
The cameras were becoming.
They were
more
handling
affordable
evidence.
for personal
Oh,
use. So if they wanted to buy
that
their
makes
own, they
sense.
would.
Okay. So tell us a little bit about the belt tape thing. How did that work?
So a belt tape's a digital recorder.
I'd be like, well, officers, they
my
were free to
use of
find,
them
buy their own
is
patrol
only if there's
vehicles.
investigation and I'm conducting an interview. I will run that tape to record.
I bet there's a knot in the back of
Deputies
his
in the
neck where
field,
he's
if they didn't
tied
have
2
a
ties
belt cam,
together
they'd
so
have
he can
digital
make
recorder, They
one.
would keep it on their belt. And when they came into contact with an individual.
He's got another tie hanging back down the back.
Of course, it would capture more of what the deputy was saying because it's right here. It's either in the
Someone
pocket,
said
on
the
belt,
prosecution
with their
has
person
hair extensions.
versus,
I need to see this.
talking
I
like
don't
in this
see.
Walker,
No, it's
who
just she hasn't
doesn't
brushed her
display
hair
it,
since about
but at
1984.
least it's something.
It might be hair extensions, though. They look really messy if they're not done right.
Her hair looks very,
February
how
29th,
can I put
2020.
it?
Were you
It
on
looks
duty
very
that day?
post-coital.
Actually, I believe I was at the it was after
Sort of Chewbacca hair.
and I received a call.
Okay, so what was your role in this investigation?
It started as a lieutenant.
You
it
think
started
the
out
camera is
as
then just
being
from the
able to
gravitational
call
pull?
out personnel and
It's like-
resources
like a
to
big
assist with
elastic.
the investigation. So I contacted Sergeant Griffin. I believe he was also off.
This is Sergeant
Advised
Peter
him
Griffin.
to start his detectives and to handle the scene and call me if you needed me.
So initially then was your role in the investigation more as supervisory because you were in the chain of command to be called?
In the very
assist.
in the initial part.
Yes. And then what eventually became your role?
Eventually it became my role due to personnel that I was going
And
to
weirdly, the shirt is too big on him.
co-detective with Sergeant Griffin, who would proceed to the scene because there was no availability of anyone else.
Okay. How many homicide investigations does the Sandoval County Sheriff's Office do in a typical year?
Typically now, it's very spotty, and it's not necessarily homicides that occur in the county. We also attribute it to, if someone, for lack of a better term, leaves.
How many do they do competently? Oh, that would be 0.
And we'll
Nearly
do
one.
maybe an average of 4 or 5.
So this is like a really
it's
small
just every year's
place in
different.
New Mexico.
How
It's
many
very-
did you do in 2020?
I think it's a big county, but it's very remote, so
2020,
nobody lives out there.
for the
There's
So
no
they don't
people.
have
Yes, for the
much,
Sandoval County Sheriff's Office.
not much
believe we
happens
did
there is what I mean.
4 or 5
No,
counting
right.
this one.
Okay.
I
So
like
in
that
this
the
case,
Navajo
you
came out
were,
to do the
Yeah,
called to
yeah,
help
they were
because
the
you're
closest.
medical. Yeah.
At that time, I made the determination that
They're probably just coming to bring him
Sergeant
extra
Griffin
baby
would proceed
powder.
to the scene.
Well, they might have
Involve,
actual money. I mean, if they have
crime scene,
casinos.
Yeah.
and I would remain at.
They probably have
command post is
working
what you
body
call it, which
cams.
is Me in my office
Yeah.
to arrange any logistical help, contact state police for a crime scene if necessary, prepare any warrants that we needed exigency on for like the residents and the property that they were going to, communicate with the district attorney, basically just have a place with sorry,
A permanent
have a place
the
where
mask lines on the side of his face here. We're digging into the flesh.
because they didn't.
Okay, so let's start at the beginning. The call comes out. What time was the call received by dispatch?
Can I refer to the CAD just for accuracy's sake?
Yes, sir. If the CAD will refresh your memory.
Thank you.
That's her hair right there. That's the prosecutor's hair.
God. Oh my.
See, it's just
No,
Chewbacca hair.
no. Those are
I'm going
extensions.
to lead
They're
you
right.
By no objection by the defense.
Well, then
She
what's
does-
the other lawyers? What they have
So,
the same
sir,
hair thing
the
going on.
call
She
comes
doesn't have the
into
front.
dispatch
She
at
needs to
about
comb this part over
17:31.
that so we
Yes.
can't see it.
How is
She's
the
got like
accuracy of the
clip-ins.
times on that?
It can be plus.
So
or
she's
minus
not going for
minutes,
dreadlocks.
because again, they're logging this in manually, so it could take a minute or two for them to actually put in.
Now, Megan, did you see
information,
the
depending on how
two
they're-
police officers testifying about the?
And the calling party
There were
was
like
Mr.
5
McCullough?
hours difference between when it
What
got
time
dark on the
was
day in
call
question.
from the
No,
Bureau
I
of
haven't seen
Indian
any of this trial.
Oh,
So this
yeah.
is I'm
I
trying to
believe the
catch up, you
original
know.
call was
The one police
at
officer was saying it got dark about
5:30
10
p.m.
p.m. in
but was
February.
not logged until 5:49.
Yeah.
So they're talking about timing
And
now.
who made that call?
It was reported by BAA to be a gentleman named Dean Cummings.
Okay.
That was
And so the time
5:49
difference from
p.m.
the call from Mr. McCullough and the call from Mr. Cummings was about 12 minutes.
Approximately.
And Your Honor, at this time, the state would request to publish Exhibit 2.
This is February
the 911
29th,
call made to
2020. So it's that time of the year.
Go ahead, boss. Let me publish it.
A lot of the police were not on the scene till the next day after midnight, March 1st. So that's how many hours. They're talking about the call here was just before 6 p.m. So many of the cops who testified, they only got there hours later.
Are you playing it off your laptop there?
How many hours?
5, 6.
Wait a minute.
Well, the one
police didn't
officer
show up?
testified it took an
For-
hour and a half to get to the place. It's out in literally the middle
Yeah,
of nowhere.
and they had to use GPS coordinates. I heard that part where they had to.
Yeah.
There's no like address or whatever. But wait, why would it take
Right,
5
so, like,
hours?
part of the issue here is, for example, a cop's testifying that he did not smell mace residue in the room, which of course would be favorable to the state because the state's trying to say this guy was never maced. Maybe that's what they're
Oh.
trying to say. Who knows? But the cop wasn't there until 6, 7 hours after the event.
So it could have
he
dissipated.
doesn't know if doors were open, windows were open, if the space was ventilated. I mean, there's,
Does all pepper spray have a residual smell?
it would depend on how much, the concentration, the environment.
And
It
if
certainly
most of it-
can. But
If
the
most of it
state's
was
trying to
on
suggest,
him, if most of it was on him and not in the room, and he washed his face and hands and stuff, maybe it wouldn't be so concentrated.
or maybe it was just an incidental blast that came out when he was actually using it as a
Yeah.
striking weapon, which would be enough to feel a burning sensation. So you would feel like you got maced, but it wasn't sufficient to soak anything down. and
Right.
leave a residue 7 hours later in the room. But
Right,
this
and
is
if I
all
remember
uncertainty, and all this uncertainty is favorable to the
Yeah.
defense, not to the state.
Yeah.
And if I remember correctly, they said it took him an hour and a half. The first responding officer an hour and a half to get there, and then after he got there, it was another hour and a half before they contacted the guy. I guess they were worried about an active shooter. So I can't remember. Am I remembering that right, Andrew?
I don't remember the exact sequence. I just remember a lot of the cops testifying that they technically arrived on the scene March 1st, which would be the next day, the day after the event, presumably just after midnight, but March 1st. And I still
Incidentally-
don't really know what this stuff was, because they keep calling it mace. And there is a chemical product called mace that's different from pepper spray. But mace is also the name of a company, and that company makes pepper spray products too. So it's unclear to me whether when they say mace, they just mean the company that made the product, or they mean the actual chemical product itself. It's
They haven't specified what it is. Incidentally, Andrew, why can't I see the YouTube chat on StreamYard? It doesn't do that anymore?
No, I'm seeing it.
That's weird. All I see is our private chat. It's weird. Anyway, doesn't matter. I can go. I'm on a different screen.
Maybe I'm doing something wrong. Am I doing something wrong?
I don't think so. I don't think it's on. I've never seen the ability to change that in the studio, but it's just weird. I just don't have the. I don't have the chat, but that's okay. I have it on a different screen.
Yeah. Okay. Fair enough. All right. Let's hop back in. Maybe this guy will start talking about something important now. We're 47 minutes into the day and nothing's happened yet.
I have it on.
Except a bunch of fat
Here.
jokes.
Logistics.
Oh, I see.
There we go.
Oh, actually, before we go, why don't you guys introduce yourself to the audience? I'm not sure that everybody knows you. Jeff?
Hi, I'm Legal Vices. I live in Korea, do maritime and corporate law, and have my YouTube channel over at The Legal Vices, and stop on over there.
And Megan?
I'm Megan Fox. I write for pjmedia.com. I'm a journalist and I'm an investigative journalist. I do cover a lot of court trials and things like that. And you can find me on Rumble at Megan Fox Investigates. I'm on Locals, meganfox.locals.com. You can also find me on YouTube if you can find me because the one with the weird toe thumbs always comes up first. But if you're in the chat right now, you can find me because my little icon's in there talking to you.
And we have another guest. Hey, Karen.
What's going on? How's it going?
You popped in just as I remembered to be kind enough to ask the other guest to introduce themselves. So you're popped in. Why don't you go ahead and introduce yourself as well?
Fair and balanced journalist, just like Megan over here, and work in DC and cover all things politics.
Sound like you had a party last night. Little horse there. Little.
No, it got really cold here. Really cold. So yeah. What was it? What was
Jeff? And I know Jeff had a party yesterday.
I had a party.
Well, the thing is, we had that party. Why did they give that guy a baby mask? Did they run out of adult masks?
Yeah, that's what we're trying to figure out.
No, that's actually a truck tarp. It just looks small.
I was dying when I was hearing these jokes.
All right, so we're hearing this guy's testimony for the state. Here we go, Mr. XXL. They call him the love blob.
Hi, I have a call for you. Okay, go ahead. Okay, I have a male individual, first name of Dean Cummings.
Do you have a call for me though?
Yes, I do.
Okay, can you go with the address first?
So they know his name, right?
It's going to
He's not
be
hiding
4
his
miles
identity.
in on Cabazon Peak.
Okay.
They're saying
So this sounds like
dispatch
dispatch passing information on to him, and one piece of that information is the name of the defendant, Dean Cummings. So clearly, Dean Cummings is not hiding his identity from law enforcement.
Which is
They
what
already
makes it
know.
so stupid for them to make this a thing.
Yeah.
Right.
Okay, and what have you got?
I have a male individual, Dean Cummings.
Oh.
Phone number 907-831.
There it is.
512.
Well, don't get that
He was
for anybody.
attacked by male individual.
Don't call him.
Only
Yeah,
first name
but do we know who he is?
First name George Edward Ocean Mary Edward.
Okay.
He said that he was attacked by this male individual. He tried to defend himself, got a hold of his weapon. He had a gun, He did shoot the individual. He said that the individual is dead.
Okay, we do have a call up already. Let me make sure these aren't.
The trouble with the dispatchers always talk fast anyway, folks. So I slowed it down so we could understand her.
Yeah.
When did he call you?
He called me at 17:43.
That's 5:43.
Mhm.
And give me the location once more.
Okay, he told me 4 miles in on the Cabazon Peak Monument Trail, the BLM Monument Trail.
There's no real
It's
address.
gonna be a ranch house, like a ranch. Trailer. There are 2 trailers there. One's a Hallmark trailer, and then there's 2 gates.
Hallmark?
Yeah.
Damn, this is like self-defense case at its finest.
Yeah, he said it's
Out in the middle of nowhere,
Yeah.
nobody to help you.
No one to help. Yeah.
And New Mexico is
What was the name
pretty
of that trail again?
big.
the Cabazon Peak.
I've driven
Trail?
through it. It's
Or
terrifying.
Monument Trail
Especially this
access. He said
part,
it's
it's
the
really
BLM
it's really
Monument Trail
desolate.
access.
Yeah,
Or
that's
the
what I meant,
volcano.
desolate.
You can drive for hours and not see another car.
Oh, that sounds so wonderful living in this city of 5 million people.
What was your name again?
Andrea.
You know, this guy's writing down these notes with a Crayola crayon.
Did you have anything else?
No, that's it.
Thank you so much, Andrea.
You're welcome.
Bye.
Bye.
So that call was relayed to Sandoval County Dispatch about 20 minutes after Mr. McCullough's call.
I believe so.
Okay. Tell us how messages between you at the command post here at Sandoval County Sheriff's Office and the people on scene, how were they relayed back and forth?
That was an adventure. Because there was no cell phone service
This
and very
mask.
limited radio traffic, and I was in my office, I would have to telephone dispatch, have them get on the radio to reach a unit at the
Those
scene.
poor little
Find an
strings. They're like, ah!
And they couldn't tie up any of the main lines on the radio because local wouldn't reach me here.
Did they change the lighting, or is he actually turning redder as we go along? I'm worried.
It's the mask. It's cutting off the circulation to his head.
Yeah.
I called in, had him
He's
call
got
me.
that Fetterman bulge, but it's on the front.
Yeah.
And come back to the area.
And what relationship does he have with the police department other than taking the pizza orders? What is
He's the head guy. He's the head
Oh.
investigator
A lot of
guy.
online classes.
At the cell phone location.
Yeah.
And
Got it.
so not all the times I did this was related to
The comment's funny. This is like Shrek's albino brother.
Okay, so what sheriff's deputies responded to the scene?
Initially at the scene, it was Deputy Hayden Walker.
Okay, you're all right.
Walker, Texas Ranger, what?
He's not a walker, obviously.
He has not testified to this.
I'll let her continue on.
Thank you, sir. So Deputy Walker responded to the ranch,
Yes. And
Deputy Honey Estua,
yes.
and Sergeant Crispin.
Yes, that was the initial.
Krispy
response.
Kreme?
And
That
I'm-
was
Yeah,
it.
that's what I heard too.
No, I did not.
Okay. You said that you stayed back at the office and ran background checks and handled the logistics, right?
Correct.
Were you able, as part of that, to determine what Mr. Cummings' height and weight was?
Via his driver's license information, because I'd never seen him. That's what I received my information off of.
Okay, and was he about 5'11" and 165 pounds?
According to his driver's license.
Okay.
His glasses
Now,
are
Mr.
fogging
Cummings
up
was
now.
eventually transported back to the Sandoval County Sheriff's Office, right?
Why are
Yes.
they still wearing
And was
masks?
that, what time was that at?
New Mexico. They're obviously
The
retarded.
law.
Okay. And did Mr. Cummings consent to having his DNA swabs taken and swabs of his face and hands?
Yes.
Can you describe to the jury how DNA swabs are taken from somebody?
For a DNA sample, he's provided usually 2 sealed Q-tips. He takes it and swirls it around in his mouth for about 30 to
me 1
45
second.
seconds. Then it's placed in a small envelope once it's dried, which doesn't take very long, and then in a larger envelope, and then that's all sealed up to collect any other samples.
Well, And then obviously you probably use personal protective gear, gloves,
Oh,
things like
absolutely.
that.
Gloves, and I would just hand him the Q-tip. I wouldn't even do it.
And glove works.
You hand it and they do it themselves.
Okay. Who assisted Mr. Cummings with doing these swabs?
I did.
Okay. And
He sounds super
did you also
compliant.
swab his hands and face?
Yes.
Can you tell us how you did that?
I had a bottle of water similar to this. This is all we had available. And I would take the swab and get it in the water to where it was damp. And I wiped his each side of his face and his hands. I believe it was the top and the palms, as I recall.
So, and this was a new bottle of water?
Yes, it was sealed.
Okay. Can you show the jury on your own face where you swabbed Mr. Cummings?
If my normal procedure would be to swab each side, maybe in the forehead.
Imagine the swab he would use.
The hands.
Be like a mom
You did the
mop.
palms of the-
That would be
Like
how
the
I
one that the
normally do it.
Cuomos were yucking around with.
I can't recall.
Remember
exactly
that?
day, but that's how I would normally process.
Nope.
And where was this done at?
At the sheriff's office.
We're listening for evidence
When
that would
you were
disprove
swabbing
self-defense
Mr.
beyond
Cummings
a
or
reasonable
assisting him
doubt.
with swabbing himself, did he have any injuries that were visible to you?
No.
And then what happened to those swabs from Mr. Cummings' person?
They were sealed similar to the DNA standard in a small envelope and then in a larger envelope, and they were sealed and then tagged in as evidence.
Okay. And was Mr. Cummings medically cleared at the hospital?
Yes.
Now, the portion of the investigation going on at the scene, what time did that wrap up?
The last CAD report shows, I believe it's Sergeant Griffin coming to the office about 1:33, 1:35, the next day, March 1st,
So was that AM or PM?
PM. And I can't tell you if anybody was left at the scene after that, but according to CAD, that's the last person that left.
Okay. And who collected the evidence from the state police?
Sergeant Griffin.
And that would have been the rifle, the mace, the 11 spent cartridge casings, and the magazine from the stairs, right?
Yes.
Now, let's talk about how evidence is handled in your agency. So
Poorly.
when evidence is collected from a scene, what happens to it? Or at least in 2020. Let's talk about it then.
Sure.
Oh, girl,
So-
you forgot to brush the back of your head.
I think it's
they would
extensions.
Prepare a at the
She
time.
No,
doesn't,
she
have,
just
she
didn't.
doesn't
She's-
have them covered. Like
Prepare that
I
system,
think
on that system. They would.
No, they're not
as
extensions because you'd see it in
evidence,
length. She just didn't
you know,
brush the back of her
I
head.
don't think so.
log it
I
in,
think
create
it
a
was
evidence
weird.
report. Then they would print that, take it, and we have lockers.
4
in
female
our
lawyers in this
evidence room.
courtroom, and only one of them owns a
They
brush.
would put it in one locker one way, shut the door, secure it, and then the evidence tech the next day would come in, open it up, and then process it and store it and confirm the inventory.
So this system you said UDIS, does it give each individual piece of evidence an item number?
Yes, it does. Well,
And-
I'm sorry. It doesn't give us a number. It has a place where we would track our own numbers.
Okay. So this is like a running ledger or report.
Correct.
Does it document who tags something in and what time they tag it in?
Yes.
All right. So
With all this discussion of evidence handling, I just want to remind everybody that yesterday in the courtroom, it turned out that there was an AR magazine in evidence that nobody knew where it came from or what it had to do with anything. Just an extra magazine just popped out of nowhere.
That can't be good. I want to
this
know
is
why
a
they found 10 shell
okay.
casings. Were there
Yeah,
10
well,
shots fired?
Yeah,
That's
what-
actually indicative
what we're
of self-defense.
yeah, a struggle over the gun, right? So it's being fired as the two men are struggling over the weapon.
Okay, that's terrifying.
In a very small room. So it's not like he was just
Right.
spraying wildly to the horizon. They were this close to each other, struggling in a small room.
So you would expect, though, that there would be a sign of a struggle. The state is saying there was no sign of struggle. I'm interested to see their evidence on that.
This is funny from the state did this yesterday. So in the actual room where the actual shooting occurred and the body was found, there's a Rubbermaid plastic bin with the lid ajar. There's a rug that's folded on itself. There's a wall heater that's torn off the wall and laying on its side. So there is sign of a struggle there. But what the state was doing was showing pictures from the rest of the trailer, saying, "Well, it doesn't look disheveled here. It doesn't look disheveled there. These things weren't knocked off a table." Well, no one's saying there was a fight in that room. Of course, it's not disrupted. It's very, very cheesy.
How did they bring this case? So far, everything the state has claimed, there's it just doesn't appear to be true at all. It's
and
weird.
Sergeant Griffin collected from the state police.
Yes.
Your Honor, may I approach? And hand to you exhibit
That better not be food. Nom nom
Was
nom.
this evidence collected during your investigation in this case?
Yes.
Your Honor.
He's gonna eat the evidence. We need to approach.
It may not have been collected by him. I mean, this is all. None of this really has anything to do with the legal issues in the case. I'm sure that's what the defense is like. What's going on here? Where are we going? What's the purpose of all this? Because otherwise, it just begins to feel like cumulative police testimony. You know, like you're supposed to convict the guy because we had 20 cops testify in the witness stand, but that's not how it's supposed to work. Their testimony is supposed to be relevant to the legal issues in dispute in the case.
I'm looking at that could be extensions now that I'm looking.
Told you.
Lawyer in the I don't know
is,
what do you
just-
call that color? Peach colored, whatever, the pinkish jacket on the left there. She's awesome. She is a pit bull. She also doesn't own a hairbrush, but she is a pit bull of an attorney. She's very impressive.
Somebody needs to fix that hole, Farron. See,
Mhm.
it's a clip-in. You can actually see that. You can see
Yeah.
it.
Now you can see it the way it is.
She just needs someone to brush that top part over it. See, this is why I just do not like extensions. I think they always look like this. I don't think anyone ever looks good in them. I think you should just quit using them. Stop using extensions. They look dumb and fake.
This is why every girl needs a gay best friend. They will never let you walk outside without
No.
brushing the back.
And
of
look
their
how
head.
it doesn't
You need
move.
men? Just a gay man?
Yeah.
It also doesn't even move like hair. It's not, it just doesn't move like hair at all.
Mhm.
It's stiff and like gross. It's a good color match at least, but that's it. Man, that hole is going to drive me nuts. How can one of her coworkers not be like, okay, can we go to the bathroom during the break and let me fix your hair? She's
I mean,
don't
they're
they
asking
know
the judge to use his comb. The judge definitely, he looks like a guy's got a plastic comb in his back pocket, right?
Oh, for sure.
Look at that
for
hair.
sure. His hair is in place.
One
know
of
what's
those plastic unbreakable combs.
You know what's great though? It's finally watching a trial where professionals are the ones making the arguments, because after Darrell Brooks, I really wanted to gouge my eyes out.
Yeah,
and my
these
ears.
prosecutors do appear to be technically competent. I think they know how to do their job. I just don't think they have anything to work with.
Yeah, it's
I
not
was going to ask if the state of New Mexico had showed up yet, but then I was like, "Whoop, wrong trial."
wrong trial. Grounds.
Oh man, I'm gonna miss that guy.
Have we addressed subject jurisdiction though?
It's yeah, they're definitely not like even an Elaine Bredehoff. Remember her, of course, from the Johnny Depp trial. I mean, she just didn't know how to question witnesses.
I still don't understand the masks.
I know
I
it's
don't
a
get it.
terrible thing. They shouldn't be allowed to do it anymore. The data's in. The masks do nothing. Absolutely nothing.
Well, we still have to wear masks indoors here in Korea
What the
as well.
business? What the business with that hair? Fedorowski, what the business with that
The
hair?
body of Mr. Audiola. OMI collected the body from the scene, correct?
Areola? What?
Typically, tell us how a body is processed for evidence.
By the way, the defense won there. The defense won that objection. They were just about to ask them about evidence in a plastic bag, and they're not doing that anymore. So they've moved on from there.
It's by OMI.
So a field investigator is going to go to the scene,
Very interesting.
photograph the entire area.
Wonder what it
Or
was.
at least the defense is compelling them to lay some foundation before they get to the actual evidence.
Photograph the body and photograph weapons or drugs or anything they find on the scene.
Let me be more specific. Tell us about how, like, the hands are bagged and the fingernail clippings, and how is that kind of evidence collected from a decedent?
Gotcha. When he's preparing the body for transport, some deputies, depending on the nature of the decedent, will bag their hands. I cannot testify if his hands were bagged at this time, but that would be a normal procedure that I would do. He's then placed in a body bag and sealed with a tag, and then transport would take them down to OMI in Albuquerque.
Okay. And then at OMI in Albuquerque, do they then do the clippings, and what do they do with the body in Albuquerque?
So what I've witnessed and been part of is normally, and I can't quote from their exact SOP because that's a different division, but they would, when it's time for autopsy, they would bring it in, do photos, clothes, they would unclothe them, go through the clothing, secure any items that were found in the clothing once the decedent was not wearing any clothes, They would do more photographs. Then they would do fingernail clippings and tag those in. Also, I believe they do DNA at that time. And then they would proceed with the autopsy. I can't say if that's their SOP. I'm just going by what I've witnessed before.
Okay, so that's how they would have gotten Mr. Adiola's DNA standard.
I believe so.
Does somebody go pick up this evidence from OMI, or how does it get to your facility?
More times than not, they will send it to me via mail. Depending on, I have gone down there to actually pick up evidence from time to time.
Got to change
For
my
the most part,
laundry.
I've
I'll be
received
right
it.
back.
And then how does it get to the lab?
I go through the big box. It usually comes in a big box or an envelope. I open that up, confirm all the items match the list, the packing list that they gave us. And then I process the evidence as if I had collected it as seen, inventory it on, at that time, UDS, create an evidence report, and then place it in the locker for evidence tech to process.
And that would be your evidence tech then just takes it to the lab and picks it up from the lab?
Yes.
Okay, and then it goes back into evidence.
Yes.
Okay. As part of your investigation, did you determine who was the owner of the AR-15?
Yes.
Who was the owner?
Dean Cummings.
Okay, now on March 1st, did you also have contact with other witnesses? Did you do any follow-up interviews?
I'm sure I did. To my recollection, through this investigation, I can't say specifically March 1st, but through the investigation, I spoke with Mr. Cummings' dad via telephone.
Okay,
I've interviewed Miss Landers.
okay,
I did on March 1st, I did do the death notification.
okay.
And through the whole investigation, it's very difficult for me to remember that far
Okay.
back
Okay.
without recollection.
So you interviewed Miss Landers on March 6th, 2020,
Yes.
a couple of days after.
Yes.
That's also been another complaint, excuse we've heard from these cops over and over again that, well, it was 2.5 years ago. I don't really have a good recollection of, well, okay, that's fine. You're a human being. Our recollection diminishes over time. That's still not helpful to the state. And these are the state witnesses. That's helpful to the defense.
Okay.
When you would normally have your report to fall back on, but the
I believe
first
that's
responding
what I said
officer
with
wrote
the
a one-page
real estate
report.
Contract.
Okay, and then as case agent, do all of the different things you sent out for testing then subsequently come back to you?
Yes.
All of the reports?
Yes.
Okay. Have you ever requested nitrate lab testing on an item of evidence?
No. To be honest, I don't even know what that is.
Okay. Have you ever requested ejection pattern
Oh.
testing on an item of evidence?
Not in a case that I worked.
Nitrate
Uh-oh.
would just be gunpowder residue. I would think that would be one of the most common things they would ever order tested. He doesn't know what
Yeah.
it is.
Does the state lab
Wow.
even do that?
I don't believe so.
And are you familiar with mace, sir?
Yes.
How many times have you yourself been sprayed with mace?
Over 10 times.
And
Is
it's
this
What are you
one
doing,
of
bud?
the less than lethal weapons used by law enforcement?
Oh, yes. It's classified as a defensive deterrent, not a offensive.
Have you been present when mace has been deployed
Yes.
on other persons? Or
Yes.
okay, how many times?
For
Here, the state is trying to score some points on this proportionality issue, right? You're only supposed to use deadly defensive force if you're facing a deadly force threat. She's trying to characterize the mace as being a non-deadly force, less than lethal force weapon for defensive purposes. And that's generally true. But of course, you have to look at the actual facts of the particular case. Mace being used offensively is different than mace being used defensively, because defensively, you're assuming the fight's going to stop if the mace is effective. Offensively, you're assuming the fight's going to continue if the mace is effective, because it's being used in an offensive manner. Plus, if you're using the canister as a blunt weapon to strike someone around the head, it hardly matters what the normal application of mace is. That's not how it was being used on the facts of this case. So I would expect little Miss Pitbull, attorney on the defense, to eat this guy alive on this stuff. I
Yeah.
expect she's
If
taking
he doesn't eat her
notes.
alive first.
What are your thoughts though about not testing for gun residue? Hi. I don't know. I feel like that's going to be a really big issue they're going to have to climb over.
It's a weird thing. It's like, if I were responding to the scene, you would only be testing if you thought that you were going to prosecute it as a murder. So I don't see how they're prosecuting it as a murder. On the one hand, the defendant's not saying he didn't shoot him. So it's not an issue in dispute whether or not a gun was fired. If you tested for nitrates, tested for gunpowder residue, you're going to find it everywhere in the room. You fire 10 rounds out of a high-powered rifle. There's going to be residue everywhere. So I'm sure it would have tested positive. The more disturbing thing to me is that the guy didn't know what that was.
Yeah. Mm-hmm.
For total,
What kind of clown police
well over
department is
20.
this?
In your 27 years or so?
Yes.
What does it smell like?
The easiest way I can explain is if anybody's tried to peel roasted chili at home and you sit there for an hour and your eyes swell up, it gets in your face, and you can't breathe.
Okay, again, we're being very ambiguous here. What was this product, chemical mace, or was it pepper spray? Because what he's describing now would be the smell of pepper spray, not the smell of chemical mace.
Multiply that by about 10, and then that's like a direct spray from a pepper spray. It closes your eyes, it swells your eyes shut most of the time. It's a very debilitating.
Look at her. She can't wait to talk. She can't wait to have her turn.
How long does those effects typically last?
From my experience only,
I feel bad for this guy. He's going to get annihilated.
I'll let him, with respect to his experience only, I'll let him answer that question.
the times I've been sprayed, it's lasted
was
anywhere
delicious.
from an hour, as far as the real where I didn't feel I could go home safe, an hour to all day. You feel it for a few days.
And in your experience, does this get on clothing, bed sheets, anything in the area?
Yes. It was very common for me to get told to change in the garage on instances like that.
Okay. Are you familiar with commercial mace that's sold to the public?
In a way, I provided it, to family members and suggested they get some for travel and safety.
Patreon of the chat, pepper spray on his steak.
In your experience with commercial mace, does it sometimes contain a dye?
Yes.
Objection foundation.
What's his experience?
Yes, it does.
I think this guy always has to get changed in the garage. The
That's
size of him.
primarily to help law enforcement identify attackers, kind of like the bank bags that have the exploding dye packs. This is along those lines.
And in your experience, either you yourself being maced or other people being maced, or you purchasing mace for family members, like you stated, does an excess drip out of the can?
Yes, like you would a spray paint can or a hairspray. There's always some left on the nozzle or dripping down the side on your fingers.
And Your Honor, may I approach the witness?
Mace.
No, I'm good.
I've handed you State's Exhibit 30. That was the can of mace that was previously admitted, sir. Can you please pull it out?
Without
And describe to
gloves.
the jury, is this the typical can of mace that you have purchased for family members or seen commercially sold in stores?
Yes.
Can you tell us what your observations are on that?
I would definitely have gloves on handling a mace or a pepper spray canister that is supposed to have been discharged already. You ever, be working with spicy food and like you got an itch in your eye, you rub your eye by accident.
it's awful.
This stuff gets on your skin and it stays there. And then if you touch yourself, and it might not just be your eyes, especially gentlemen, you go to the bathroom, it's on your willy. That stuff burns.
Mhm.
Wear the gloves, my friend.
Well, I wonder if they fingerprinted it for the other guy's fingerprints.
Black. It's small.
Do they even test
looks
for mace
around
at the scene?
Nozzle and entryway, like dirt, like it's kind of crudted up a little bit. There's a kind of like a reddish.
Some of the police have testified that they didn't smell residue when they got there. But again, a lot of these cops are testifying they got there 6 hours after the fact. So,
Oh, jeez.
Have they said what kind of chemical
Okay.
this was yet, or we
Mhm.
still don't know?
To me, it looks.
Yeah.
old.
Seems like they should have said that.
to him, it looks old. I have a new one here. It looks the
Does
same
it
as this
appear that
one.
There's a dye in this one.
Objection foundation.
Okay, first of all, the dye they're talking about is ultraviolet. So you wouldn't see the dye. You can't visually see the dye
Mm-hmm.
until you put an ultraviolet light on.
Let's move on. I only have a couple more questions.
Thank
Have
God.
you ever tripped and fallen to the ground before?
Yes.
Have you seen other people?
Of course
trip
he
and
has.
fall? Have you witnessed people fall, or when you've seen other people fall, or you yourself have fallen? What is everyone's first reaction?
Not only through
Laughing?
personal experience,
Yeah, I was
They
gonna
point and
laugh.
laugh.
when you're trying to determine if a
What does
person
it do with
fell,
anything?
prior to death. Most people, you react to the direction that you're falling, the first thing you do is you brace yourself and you open your hands and you're just straight out, just trying to stop.
This is nonsense. So they found the victim with the canister in his hand. The body has a canister in his hand. They're trying to suggest here it must have been planted there because surely when he fell, he would have put his hands out to brace himself. Keep in mind, when he fell, he had a bullet through his head and a bullet through his heart. So maybe he was dead before he touched the ground.
Yeah, he wasn't bracing for anything. He was already gone.
And Lieutenant Tomlinson, have you had the occasion to see mace with red dye before?
Yes.
Does that one, Exhibit 30, look similar?
Yes.
I'll pass the witness, Your Honor.
Is it identical? No. So that's
Well, she's
you don't know that
calling
there's dye in the actual product.
Well, that's my question is they bring up this can of mace. They're like, oh, it's like mace that you've given other people. But if it's not the exact one, like, why does that even go into evidence?
It's ridiculous.
She keeps saying mace, but we haven't established that it is mace, right?
So watch Miss Pitbull, Attorney Pitbull, come up,
Yeah.
and she's just like
be
throwing her
good.
laptop onto the lectern. She's like, all right.
Yeah.
Does that one, Exhibit 30, look similar?
Yes.
She's taping up. I rewound it just a
I'll
few
pass the
seconds.
witness, Your Honor.
She's wrapping up her hands like a boxer.
That was awful.
Look at her walk up to the lectern.
I would be like, sir, you're going to want to take your mask off. You're going to want to be able to breathe for this one.
Yeah.
What's this joke?
God,
Like,
that
all right,
hair.
listen, you just got to calm down. This
Calm
is getting
down.
out of hand.
Make it quick. He's getting hungry. Charlie's Angels. This
She's
is
like,
going
I'm
to be
like-
so good.
Yeah, she's like,
Normal speed now.
all right, let's witness this murder.
Lieutenant, how are you?
Good.
Live.
Did the mace have dye in it or not?
Here we go.
Good.
Coming in hot.
That's not my question. Did the mace have dye in it or not?
I believe it did.
Based
How
on
do
what?
you know that? Did you spray it?
No, I did not.
Did you have it tested?
No, ma'am.
Are you
Oh.
speculating?
Oh.
You're guessing, right?
No, I'm going by experience and,
No,
previous
sir, you're
knowledge.
guessing.
It looks to me like it was a can of mace that's sold, and that it has mace or it has dye.
What are you basing that on?
The
Oh my God.
redness
this guy.
around the tip of the.
What?
Can I
What?
show you?
Just the tip?
I don't need you to show me.
Okay.
In a murder trial,
Yes, ma'am.
did the mace have dye in it or not?
I believe it did.
I don't know that for sure because you didn't bother to just spray it, right?
No,
Oh
ma'am.
my God.
You couldn't just spray it to see if it had dye in it.
No, ma'am.
And you didn't send it anywhere to be tested.
No, ma'am.
Okay, how about this? This wouldn't be too hard.
Keystone
How about just
Cops, man.
contact the manufacturer
Mhm.
and say, here's a picture of the mace can that I have. Can you tell me whether or not this model can take? Did you do that?
No, ma'am.
All right.
Do you know anything?
Do you know anything?
He's going to start crying.
What good are you? That's the next one. What
Uh-oh.
kind of
Imagine
topic
being
is
this
this?
woman's husband.
Are you familiar
Oh my
with Paul
God.
Blart Mall Cop? Would you say that that's what you are?
Paul
On February
Blart.
2020, did you look at that mace canister?
I don't believe I did.
What?
So
You didn't even
Maybe
look
maybe
at it?
through pictures. I probably
Why
did.
are we even here?
I
recall
don't.
exactly.
This is so crazy.
when was the first time that you looked at that mace can in person? Was it when trial started?
I don't recall.
You don't recall 3 days ago?
Well, if
man's
it's in
life.
evidence and you go and you open it to look at it, there's a record of that, right?
Yes.
Is it written on the envelope?
Oh God.
Jesus.
She should be pissed. They're trying to put her client in prison for the rest of his life.
They shouldn't even
Yeah.
be here. This is ridiculous.
There's not even a sign-in tag on that.
Now look, she's got her laptop. She's going to expose his OnlyFans page.
The dates are all,
He
I
eats
believe,
there we go.
burgers on OnlyFans.
2022.
2022.
Are any of them you?
Oh,
I
nope.
don't believe so.
So the answer is no.
I would have opened it with the text, so
God.
I can't say whether I did or whether I didn't prior to this.
He can't say.
Liar.
So if you open it with a tech, you don't have to put your name and the date on the envelope?
No, ma'am, she would.
Okay.
So I would return it to her to close it back
That's
up.
not how it works,
So
bucko.
what are the dates in 2022 that it was looked at?
So I have 10/31,
Of 2022.
4/20, which is probably when I sent it to the lab to get tested because I don't recognize the initials. So that's 4/20 of 20,
I think he just said he didn't send it to the lab.
2022.
April 2020, April 2 years ago, and a few days ago.
This guy knows he's fucked.
I can't tell the
He's
other
trying
date.
to stall or something.
October 31st.
Mhm.
Was that you? Can you remember
It
that
could
far
be.
ago?
I believe it says it was defense that opened it.
It was defense attorneys.
Oh,
And the one in
jeez.
April, you think was when it was sent to the lab.
I have
Oh,
no 4/20 of 20.
She's like, this
I believe it was.
fucking guy.
Yeah, the one in April.
Yes, and then there's one from DPS from 1/27 of 21.
And that can't be you because you're not DPS.
Correct.
So based
I
on
really
the
like
dates
her.
that you've just read, none of those could possibly have been you.
Correct.
All right.
Oh my God.
he's never seen it.
Jeez, what kind of cops are these?
Bad
Now-
ones.
It's because nothing ever happens there. It's like one of these tiny little, places. They
Mhm.
just their body cams don't work. The calls are like the cows got out of the pasture again. We
The
got to
price,
go
the
round
price
up
of corn is up.
we-
It is,
Marge
Roadkill
called
buffet.
again.
my understanding
Cat
that
stuck
you
up
were
a
in
tree.
the presence of Mr. Cummings for approximately 6 hours on or about the 29th and the 1st.
Yes.
And did you run a lapel camera?
He looks defeated already.
No, we were.
Okay.
Okay.
Did you run a belt recorder?
No. To my knowledge, no.
What do you mean to your knowledge? You did or you didn't?
I feel like
Couldn't
this is
see my belt,
this is
so
like
I
how it
don't
is
know.
to be a parent
You
when your kid's lying to your
testified-
face.
Before the jury in this case, didn't you?
I don't recall.
Would it refresh your memory if you saw a transcript of the grand jury proceeding?
Possibly, but I don't recall going to grand jury at all.
He doesn't
my
know
God.
if he testified before the grand jury on this case. How would you not know that?
Oh my God.
And my question for you is, would it refresh your memory if you saw a transcript of who testified at the grand jury?
How many grand
we can
juries could there
try.
be
I
at in this place anyway? How do you not remember that? So odd.
May I approach?
Instead of asking, may I approach? She's like, I'm coming forward. She's like, "You need it."
I mean, I would be asking him, is it possible that you testified before the grand jury in this case and you don't remember that? Is that possible?
Yeah, that would have been a good
Just-
follow-up.
I mean, if that refreshes your memory as
So
to whether
unbelievable.
or not you testified at grand jury.
This chick is so based.
Right. And so now the state wants to have a bench conference because they want to stipulate all this. They don't want
Yeah.
this guy kept getting trapped on the stuff he can't remember.
Mm-hmm.
Objection.
Which is smart.
It is my
Hurting our
favorite.
case.
It is my favorite thing in the world to watch defense attorneys make this state look ridiculous. And so far, this is exceeding my expectations. I didn't know what to expect with this trial, but this is going to be one of my new favorites. Obviously,
Of course, the defense should argue against stipulation because it goes to the guy's memory, it goes to his credibility. This is exactly what the jury is supposed to be assessing. He can't remember if he testified in front of the fucking grand jury on this case.
I mean,
It's
how
unbelievable.
long could that have possibly been? I mean, and anyway, how could you forget such a thing?
Well, and my question is if he can't even remember testifying before the grand jury, can we just completely null and void this witness? Like, what good is he?
What good is he?
He just testified that not that much happens. So it's not like he's not in New York City. It's not a 50,000 person police department and they're in front of grand juries 8 times a week.
Right.
Exactly.
He's
a great defense witness.
Well, he has been good for comic relief. We must admit that.
Yeah.
Someone in the chat had put, fat jokes are easy because it's low hanging fruit because it's heavy.
He ain't heavy. He's my cop.
Look, the lady on the right there who works for the court. She doesn't have a hairbrush either.
No.
None of them do. Except for Joe Biden there on the bench.
So explain to me.
I sense a real business opportunity in New Mexico.
Explain to me what it is they're arguing over now. What are they? They're just trying to stop this because he's being embarrassed.
Pretty much.
I think so.
What are they trying to get thrown out or stop from happening?
Oh, so they want something stipulated. So she's asking him, "Did you testify before the grand jury?" He probably didn't. So the state wants to say, "Look, we'll just stipulate that he didn't. We'll just state out front. We'll agree up front. He didn't testify in front of the grand jury." Because if both parties stipulate to a fact, it's not a fact in dispute, and there's no need to have any questioning of witnesses over it. But from the defense perspective, the important part here is not whether or not he testified before the grand jury. It's whether or not he can fucking remember whether or not he testified in front of the grand jury.
Otherwise, he's a terrible witness. Yeah, right.
I love Dave 123. It's like Footloose, except hairbrushes are illegal in that town, not dancing.
Hair loose.
Hair loose.
We need one of those deep fake videos.
Nice one, Dave.
Oh, that was funny.
Just ask the guy what they had for lunch at the grand jury. He'll probably be able to remember.
All right. Well, as long as they're
remember.
doing this, let me see if there's any super chats I have to hit because otherwise I fall behind. Let me see.
Are they paused?
Yeah.
I just paused them now, but you couldn't tell the difference.
In New Mexico, you can pause people. It's amazing.
You really couldn't tell the difference.
Land of enchantment.
I drove through New Mexico on my way to college, and I just remember it being so desolate and so just scary because there was just no one around for hours and hours.
Mm-hmm.
So soy mafia, $2 SGD. You're lucky I don't know what that currency is. The minimum is $5, folks. Asked, has Admiralty jurisprudence been clarified yet? Let's see. Kyle Mitchell, $2 super chat. It's hard to find tarps in the right size for the face mask. Atomic Squid, $10 super chat. Thank you. It's ironic to have a murder at a murder trial. Yes, that would indeed be ironic. Floppy Turtle, $5 super chat. Just wondering how Jeff is doing today after his F-It Friday show.
Wonderful.
All right.
He survived.
And Harry, he's going to make me say his last name. Harry Dickshaft. I think that's a pseudonym. Who was the worst prosecution witness? This guy or no bicep bro in Rittenhouse?
Oh.
That guy was pretty bad. The guy who's changing his name now. Yeah. All right. That's all. Grosskreutz, right?
Grosskreutz.
And from the law self-defense members, looks like an unconstitutional seizure of the defendant and his property without probable cause to believe an unlawful homicide was committed. Yeah, that's what this looks like to me. He's been in jail for 2.5 years, and this is the state's case.
Oh.
That was Donnie O, a law self-defense member, very active member at law self-defense. Paul in Florida says the prosecutor might as well just say it's a military-style assault rifle. Yep. AR-15 is a hot button description. Yep. That's why she keeps saying it.
That's why they keep saying it.
It just means scary gun today.
Charlie Watt asks, is the plaintiff in the courtroom? Has anyone talked to the plaintiff? I don't know if that's a Daryl Brooks joke or there's no plaintiff here. It's the state is the plaintiff and the defendant. It's a criminal trial.
I think it was a Brooks thing.
Lieutenant, did that refresh your memory?
I still have no recollection of the jury, but I trust the transcript.
Well, and listen,
my God.
if I
Look at her. She's like,
you agree with me
Alzheimer's?
that, generally speaking, in a more substantive case, like a homicide case, it's typically the lead case agent who testifies at grand jury. Do you agree with that?
I agree.
And you're the lead case agent in this case.
I agree.
Okay. Now, I understand that this was 2.5 years ago.
Yes.
So, and I want to be fair to you, and I mean that. So we can go through the transcript, or we can just break and you can review the audio recording of the grand jury, because obviously the audio recording is you could actually hear the sound of your own voice.
so he did testify before the grand jury. He just can't remember doing it, even after looking at the records.
Sure.
So if you prefer to do that, I'm happy to do that.
Wow. By the way, so the grand jury proceeding obviously would have been more recent to this trial than the actual event, right? The grand jury happens after the event.
She said 2.5 years ago.
Oh, that's the event was 2.5 years ago. But
I
the
thought
grand
she
jury,
said the grand jury was 2.5 years ago.
well, the event for sure was 2.5. It was February 29th, 2020. So that's roughly 2.5 years ago. I don't know how soon after that the grand jury took place, but the grand jury obviously didn't take place prior to the event, right? It can only take place after the event. So it's more recent. If this guy cannot remember the more recent event at all, why are we supposed to trust his memory for a more distant event where he's testifying about things like what he did in his evidence?
I don't want you to feel like I'm pushing a transcript in front of you that may not be accurate.
Sure. May I answer?
Sure.
I would be happy to explain to you and the court why.
No, we
but
don't need an
it's-
explanation. We
right.
just want to take your testimony.
Oh, I want to hear why you can't remember.
Yeah.
Would you
Traumatic
like
brain injury?
to Go ahead and move through
It's the mask.
transcript
It
with
cut
me,
off
or
the
do you think
circulation
it
of
would
his
be
head.
better if we took a break and you could hear the audio? Sir.
We can go through the transcript together. I'm just letting you know that I do trust the transcript. I
Okay.
have no issues with that. I'm just being honest with the court that I physically do not remember appearing.
He physically does not remember. That's a weird way to put it. But
Yeah.
maybe the guy actually suffered a traumatic brain injury. It's quite possible that that could have happened, and the state does not want that in evidence because it would undermine his credibility. Right? The guy's brain is broken.
Judging by the
and he's
size,
a-
I'm thinking a stroke. Let's be
maybe it
honest.
was a stroke. Maybe something like that happened. So he has a genuine cognitive deficit. He really, for medical reasons, cannot fucking remember testifying in front of the grand jury. And the state doesn't want that in evidence because this is the lead investigator for the homicide. His testimony is critical. They can't have him appear to the jury as being mentally defective. And the defense, the judge ruled in favor of the state. So nobody can mention this guy's actual mental deficit. He wants to mention it because it explains why he can't remember, but none of the parties are allowed to. That might be what's going on here.
During a grand jury.
I understand.
That's all I'm saying.
I understand.
Okay.
Yeah,
He's getting ready to
I'm-
cry.
And I don't want to beat you up for that.
Yes, you do.
By the way, that would explain why Miss Attorney Pitbull is being so sympathetic right now, because the guy does have, I'm speculating, but if he had a genuine mental defect because of something like a stroke, she wouldn't want to come across as unsympathetic in that context. So she's being super kind here. She was not this kind to yesterday's witnesses, to the witnesses in the prior.
Right.
I understand police officers are human beings. There's a lot of things that go on. They have a lot of different cases, and it's hard to remember something from 2.5 years ago. Okay. So if at any point we're looking at the transcript and you feel like perhaps the transcript is incorrect, let me know and we can take a break and listen to the audio.
Very good.
Okay. Whatever you feel comfortable with.
Very good.
All right. Thank you.
Wow, he's breaking down right here.
Your Honor, may I fat shame the witness?
And
Someone in the comments.
I understand that you probably are not going to recall the answer to this question, but I'm going to ask it on the off chance that you do.
You just wiped away a tear, I think.
Prior to giving your testimony
Yeah.
before the grand jury,
He does seem upset.
do you know if you met with anyone from your investigative team?
I'm sure that I met with Sergeant Griffin, obviously, because he was at the scene. I do know that the two other detectives did, after the fact, assist us with parts of the investigation.
This is weird to me because my sense is he doesn't actually remember. He knows from the records that these officers were at the scene, so he must have spoken to them. He's making an inference, but he doesn't have an actual memory of it.
Mm-hmm. She broke him though. He's tearing.
That answers your question.
After he just was touching Mace.
You're sure that you met with Griffin?
Yes.
Okay,
yes.
but it sounds like you're not sure whether you met with the other two.
No, I do know. I met with the other two in other aspects of it. So
Prior to
grand jury.
Okay, you met with them prior to grand jury.
yes.
Okay, great. Who were those detectives?
Sergeant Griffin.
Great. We
Detective
found something you can
Miller,
remember.
and Detective Salas.
It's great.
Were all of those detectives out at the scene?
No.
Okay. Was it only Griffin that was out at the scene?
Yes, ma'am.
All right.
I'm not saying anybody should be sympathetic to this guy necessarily. He's trying to put a man in prison for the rest of his life. I think it's a smart
Agreed.
play of the
So-
defense to come across as sympathetic.
I'm going to ask you this, and then we're going to have to go through a memory refreshment, and so I'm just going to leave that transcript in front of you
Very good.
for your convenience. When you testified at the grand jury, of course, you testified about Mr. Cummings withholding his name and identification.
Could you repeat the question? I'm sorry.
Well, when you testified at grand jury, of course, you would have testified about the crime of concealing identity.
Yes, ma'am.
Okay, and that's, the
The thing he
allegation
didn't
is
do.
that Mr. Cummings failed to provide his name and identifiers, correct?
Correct.
Now, when you testified before the grand jury, isn't it true that you said they Mirandized him, he refused to answer? And if you don't recall, I'll
Good
point
boy.
you.
I trust you. If it's in here, if it's in the transcript, then I have no doubt that I testified to that in grand jury.
Okay, so as we have heard, he was not Mirandized, and so I'm just wondering, if he wasn't Mirandized, why would you have told the grand jury that he was?
Uh-oh.
They didn't Mirandize him?
They don't have to.
Oh God, this is awful.
Page 6.
That's my rooster crowing. Sorry, you guys.
So,
I
folks,
know
they
you're hearing
don't
it.
they don't have to Mirandize you until they want to question you as a suspect. But if they show up on the scene and you're already talking, so that they don't have to ask you questions to get information out of you, they don't have to Mirandize you. You can just keep talking. They won't Mirandize you until it's in their interest to Mirandize you, or they're required by law to. So once they want to sit you down and start asking you questions and they have reason to believe you're a suspect, then they have to Mirandize you, but not until that point. I see plenty of cases where the cops they'll arrest someone, they'll cuff them up, they'll throw them in the back of the patrol car, and they'll turn that dash cam around to point at the suspect and just let them talk and talk and talk. And that's fine. That's all admissible. They don't have to Mirandize them for that because they're not asking him any questions.
Mm-hmm.
It's like the second sentence that he testifies to.
Oh, someone in the comments is saying he was in a coma for 9 days after the grand jury.
Is that real?
Oh,
Is that
Jesus.
true?
I don't know if it's true or not, but that certainly would explain something. Maybe he was in a car accident, or who knows.
Crikey.
The state has to call this guy as a witness. He's the lead investigator. They can't not call him.
Regarding this case,
Frankly, I think it's pretty cruel of the state to call this guy and not allow him to explain, because the defense would be happy for him to explain he was in a coma. That's why he can't remember. I mean, It's good for the defense for this guy's memory to be imperfect. The only reason that's not being brought out would be if the state objected, and the state's making this guy sit on the witness stand and testify about his lack of memory without being able to explain, give a reasonable explanation of why that is. He's not just an idiot.
I would probably
Chad
been
wins again.
provided
Food
that
coma?
information, which subsequently changed. I wasn't at the scene
Chad
when it was
wins.
describing,
Awful.
so it possibly was information
Chad's awesome.
coming from one of the deputies at the scene. That
Hit that like
changed
button.
the information later on.
Okay, fair.
Don't just hit it, slap it a few
Don't,
times.
don't make me get my belt. Don't make me make you get my belt.
The chat
Yeah.
said if he was in a car accident, they feel sorry for the other car.
In preparation for this trial, did you,
Well, it would be an appropriate location, right? Los Alamos.
Yeah.
I mean, you can imagine the mushroom cloud over that car accident.
listen to the entire hour and a half audio recording that was created by the belt recorder of Mr. Walker?
I don't believe I listened to the whole hour and a half. I believe
Okay.
it because there was, as I recall, that I've listened. There's a lot of blank time, driving type stuff. They're just sitting there, not a lot of conversation.
Okay.
Oh, now I feel bad for making fun of him. A little bit.
I don't. This is his job.
Uh,
And
you
as Bronca
indicated
said, he's trying to put
the
somebody
grand
behind
jury-
bars.
There was no evidence at the scene or on Mr.
No
Cummings
mercy,
that
Farron.
indicated that mace had been
No
utilized.
mercy.
Is that right?
According to the transcript, yes.
Well, the evidence at the scene that mace was utilized is that there was a mace can in the decedent's hand. You agree that that is some evidence, correct?
That's evidence Mace was at the scene, yes.
And you wrote a fairly lengthy and detailed report in this case, didn't you?
I believe so.
I trust you reviewed your report
Yes,
before taking the witness stand?
Yes, ma'am.
And do you agree with me that in your report, you indicate that mace lasts about 45 minutes to an hour?
Yes. I mean, when you're sprayed on somebody before you can recover, like I testified.
That's what you wrote in your
Okay.
report, right?
And that's what's in your report. Do you agree with me that there were no police officers who arrived within that time frame?
I think that would be, well, from the first 911, yes. I believe that's a fair statement.
Okay.
Well, of course, the mace would have been used before the first 911 call. So
And the whole, because I'm still new to this case, but the
And
whole
what time was it
purpose
that
is to
you,
show self-defense with the mace. That like self-defense was used. Like they tried to use the mace, that didn't work. Thus, he had
no.
to shoot him.
The mace was in the hands of the victim. So the defendant is saying he was attacked by the victim, and the victim was wielding mace. He had mace clenched in his hand and was
He was
pounding him
smacking
about
him
the
with
head
it.
with it. And so the defendant defended himself with a rifle against that
Gotcha.
attack. Well, he brought out a rifle. Then the men fought over the rifle. At that point, it's a gunfight. It's just a matter of who ends up with the rifle. But the mace was the narrative on both sides is the mace was the property of the victim. The victim was wielding it as a weapon, according to the defense. And when the body of the victim was found, he had the mace canister in his hand. Interestingly enough, he had the mace canister in his hand backwards. So the nozzle was facing back at himself. But if he was using it as an impact weapon, it wouldn't matter where the nozzle was facing.
Okay.
And
Thank
it
you.
might explain why there's, why it would be an incidental discharge of the mist of the spray, as opposed to somebody being soaked down and having hours worth of symptoms afterwards.
Right. Okay. Thank you.
initially had your person-to-person contact with Mr. Cummings?
I'm sorry. Can you just repeat that?
What time was it that you initially had your contact with Mr. Cummings?
If we can, I can refer to the CAD for a more accurate, the CAD report.
Or do you recall at all, or do you need the CAD?
Drive time from the location to our office, so 45 minutes to an hour, so maybe around Again, I'm guessing 11 o'clock. It'll be in the CAD when the deputy arrived at the office.
Okay, but you're guessing around 11 o'clock.
That would be good.
So do you agree with me that when you testified before the grand jury, you said, I was able to talk to Mr. Cummings for 6 hours and never smelled any of it?
If it's in the transcript, then yes, that's what I said.
But what you didn't tell the grand jury is that you didn't have contact with Mr. Cummings until 5 or 6 hours after the mace was used.
Correct.
Okay.
Whoop. So this is the kind of stuff this is why grand juries are such a poor threshold for a prosecutor to have to meet to drag someone into trial, because he said something in front of the grand jury that was true. I was with the guy for 6 hours. I never smelled mace. He just left out the context that's only revealed in an adversarial process like the courtroom. If the grand jury had known you didn't smell it, but you didn't even have first contact with the guy until 6 hours after the mace was supposed to have been used, that would have contextualized his testimony. Instead, it makes it look like without that context, the defendant just looks like a liar. And of course, he's going to get indicted.
I'm going to go do what I'd never do. I'm going to go put the laundry away. I'll be back.
The grand jury, you said, we were able to recover his clothing that he did toss into the back of the truck after searching for.
That's what I was in the transcript, and that's what I said.
11 down at the bottom.
Chad, I got beef with you. 1,300 in here, only 914 likes. Hit that like button,
But what
folks.
you didn't tell the grand jury was Mr. Cummings actually brought the clothing that he had taken off to the attention of officers and asked the officers to please maintain it and put it in a bag. You didn't tell the grand jury that, did you?
No, I did not. If it's in the transcript, no.
That's the point. You didn't tell him, so it's not in the transcript.
Hell yeah, I see those likes popping. Let's get it over 1,000.
You made some statements to the grand jury about shell casings and trajectory, and I'm at the bottom of page 12. So let me ask you, isn't it true that you said to the grand jury, the pattern of the shell casings, the general trajectory indicated that all the shots were shot forward towards Mr. Areola?
Yeah, 1K.
Do you agree that you made that statement?
My name's on it. Yes, ma'am.
Okay. You now understand that some of these shots went directly into the floor, correct?
I'm not a ballistics expert, but I would not argue that.
You've been sitting in the courtroom and you heard the testimony about the scorch marks and the muzzle having to be just maybe on the floor or a couple inches off the floor.
That's interesting. Why is he in the courtroom?
I was just going to ask.
Testimony?
Yeah. How does he get away with that?
That's curious. So you don't want witnesses doing that, folks, because witnesses will color their testimony to make it consistent with other witnesses' testimony.
I thought that's just not even allowed, period.
So do you agree that your testimony that you gave to the grand jury was...
Sometimes weird exceptions, like some states have passed like victims' rights laws where you have a legal privilege to have family in the courtroom, for example, family of the survivor, even if the family is later going to be called as a witness. I think it's a terrible idea. Shouldn't be allowed because that family member is also coloring their testimony based on what they hear from other witnesses.
Yeah, because if you're,
I don't know what the exception would be here. This is weird to me.
I thought, like, just from what we learned with Johnny Depp, that it was experts could only be in the courtroom. Those were kind of the only allowable people to sit and watch testimony, but.
And that's only because they're not actually giving testimony of their firsthand knowledge of the event, right? Their testimony is really independent of any firsthand knowledge.
Incorrect.
Well, he's got no excuse for this. This is not a memory loss issue. He's just not directly answering the question. He knows some of the rounds went into the floor. That's contrary.
Time with the information I had, that is what I believe I testified here too.
Sure.
Again, I'm not a ballistics
Now
expert.
you know that's
I
not
wasn't at
correct.
the scene. I was going by photographs and information provided to me from Sergeant Griffin. So I can't say that things haven't changed between then and now.
Well, but the person who did the trajectory documentation at the scene was Agent Herrera, correct?
Correct.
And it sounds like you didn't talk to Agent Herrera before you went before the grand jury and gave your testimony about trajectory.
I don't recall if I did or didn't.
Okay. You indicated to the grand jury, and I'm in that same paragraph there. It did appear that Mr. Areola was trying to remove himself from the room and was not in an attacking position.
Correct.
What?
Do you think that the evidence bears that out?
Yes.
Tell me how it looks that Mr. Areola was trying to remove himself from the room when he fell face forward, completely away from the door.
Yeah, he was facing like 90 degrees
No, I'm
away from the
asking
door.
what's the basis for the testimony that you gave the grand jury?
Based on the OMI report, based on the injuries to Mr. Areola, the number of rounds, I believe he was, if I may, I believe he was turning to go out the door when he was shot and then fell. But I think momentum carried him to the position he was. It's a very small room. So my opinion is that still that he was trying to leave.
Even though his body is not in a position where he's turning away from the shooter, if the shooter is in that corner where we talked about with Agent Herrera.
Mm-hmm.
Is that correct?
It could be, and I believe it was.
That
my opinion.
Could be.
So is it your testimony that you believe that the findings from OMI support the conclusion that Mr. Areola was trying to remove himself from the room?
I believe he was trying to remove himself from the shooter, based on my opinion only.
But what you indicated was that part of what caused you to believe that was the OMI findings. So we've heard from OMI. What about that testimony caused you to say this to the grand jury?
The direction of travel from the wounds right to left in a downward fashion.
What?
That's what I believe. And to me, he had to be bent over to take those wounds.
Isn't it true that you told the grand jury, tentatively, what we're believing is that Mr. Areola began to take fire from Mr. Cummings. He ducked, turned, and started to run towards the door, which that caused him to suffer the 2 fatal wounds he had and actually caused him to fall deceased to the ground. You stand by that?
First of all, I've never been on a grand jury, but if I were on a grand jury and the evidence presented to me by a police officer was tentatively we believe X, I'm not returning an indictment. Tentative?
No.
I'm not sending someone into a criminal trial as a defendant because you tentatively believe something.
The generalness of it at the time with the information we had.
Hey, Farron, did you get dropped out by accident? Wave if you want to come back in. Or did you? Okay. I don't know what happened. Sorry about that.
Yeah, no, we have really bad storms here right now, and I think the power went out for a second. So sorry about that.
Okay. All right. I just didn't know if you needed to pick your nose or something and wanted to be off screen. So
I did grab another stick of butter, but I mean, we're good.
I believe a lot of that contributes to it.
Do you stand by it now? Do you stand by that statement?
I don't believe now, after learning everything about the scene, that he made the actual complete turn to the door. Given the internal injuries, I believe he was started that way, which is why he took the rounds on the trajectory where they did, and then landed where he was.
Hmm.
I feel like I don't believe is a very easy cop out for these answers, and it should not be allowed. I mean, if you're the lead investigator, you should.
Yeah. So
And isn't it true that you
one of the things the defense did not do on opening, which I think is always a mistake in a self-defense case, is they did not drive home to the jury just how high the burden is on the state in these self-defense cases. They didn't drive home to the jury that the burden is on the state to disprove self-defense, not just by a little bit, not just by a lot, not just by a majority of the evidence, but beyond any reasonable doubt. Because when you don't do that, the juries tend to default to the normal way we assess situations. It's whether it's more likely than not, which is a preponderance standard. This guy is talking like that. I think based on this evidence, I think it's more likely than not that he was turning towards the door. But that's not the legal threshold. And by letting him testify like this, I mean, I would be asking him questions like, well, how certain would you say you are about that? Do you just think it's likely, or are you extremely certain about that? Is it just a likely possibility, or are you virtually certain that's what happened?
You told the grand jury, we're waiting for trajectory test results. And for counsel, that's kind of the middle of page 17. And you also said, let me complete your sentence. We're waiting for trajectory test results to come back, which takes an amount of time to get it right.
I'm sorry. We're still waiting for toxicology to come back.
We're waiting for trajectory test results.
Oh, I'm sorry.
So you're the paragraph below me.
Oh, I'm sorry. I apologize.
Yes, I believe sounds like reasonable doubt. How do you prosecute with everyone guessing? Says News Now Wyoming.
Where are those trajectory test results?
I presumed that the firearms division at the lab or Agent Herrera would be conducting those, but apparently that wasn't done.
But isn't it true that they only do those things if the case agent requests it?
Oh.
Not necessarily.
So that was a you decision, but you don't remember.
When they're processing the crime scene, if they determine that this is, if they determine that it's necessary, then they'll do it themselves.
Yes, sir, but you're the case agent. So
Correct.
if you wanted trajectory testing done,
Correct.
you could have made sure that it was done.
Yes, and I can't recall if I requested it or I didn't request it. I can't recall if I can't recall.
Have you ever seen a piece of paper that indicates that you requested that?
No, I do not.
Do you have any recollection of talking to anyone and asking anyone to do that?
I don't have recollection of that.
Okay. You told the grand jury, I don't believe drugs or alcohol were relevant to the actual incident that occurred. Isn't that what you said? And it's the last sentence in that paragraph that started with, we're still waiting for toxicology to come back.
Yes.
And
Do you
were
stand
wrong
by
on
that
weren't you?
statement?
Yeah.
At the time of this transcript, yes.
And how about now?
Yikes.
I would say
Dude, he was-
yes.
Really?
What?
Yes.
So the fact he was drunk and had coke in his system had nothing to do with this?
Das Ogre, $10. Thank you.
Oh, I thought you paused it. He blinked.
Yeah, I know, right? People do pause in New Mexico. You can definitely see it.
Now, the decedent's personal effects, what's in their pockets and stuff like that, that all goes to OMI, correct? With the body.
Normally it does.
And that's what happened in this case, right?
Yes.
Okay.
Yes.
So when do you get those items back from OMI?
The time frame varies. Whenever their evidence group sends it back to us.
Do you know when you got them back in this case?
I don't have an exact date unless I can refresh.
Do
with
you
my
have the
report.
items here in this bag or in this box?
From OMI?
Yeah, the personal effects.
I believe I have a wallet.
So for the chat, we have some tox data. They did say that the blood alcohol level was 0.118, which is about 50% over the drunk driving limit in New Mexico. So the guy was pretty juiced. He also had cocaine metabolites in the system, but I don't remember any metrics from that. And there were cannabinoids in the system. I don't remember any metrics from that either.
I believe there was a wallet that you requested.
Would looking at that envelope give you any idea?
Probably.
All right.
Yes.
I'm going to object this to relevance. Can we approach?
You may.
Yeah, the state wants this guy gone. This is just, I mean, it's the poor guy's obviously cognitively damaged. This is just bad for the state. Those tox results were for the victim, not the shooter, not the defendant. Oh, sorry, Das Ogre. Yeah, I saw the money, the $10. I didn't see your question. Post it now real quick, and as a regular comment, I'll see if I can catch it. Yeah, what's with the unkept hair? I know. There's no hairbrushes. The judge is like, when can I retire? Can I please retire? I don't know if the defense will be calling any of those officers back to the stand. They seem to be reserving most of the witnesses for potential recall. They did a pretty good job on those guys on cross, though. I don't know if they need them back on direct. Keep hitting that like, thumbs up button, folks. Derna, 1804, $2 super chat. Derna, there's supposed to be $5 minimum. Witness has the same blank stare as cattle. I got to figure out how to fix that. How do I fix that? There must be a setting for that someplace.
I don't think there is.
I just don't know how to use this stuff.
I just don't understand if the state now wants to throw this testimony out. Like, why did they not know this before going into this? I mean, this happened, what, 2 years ago? You've had this much time to build your case. You know your witnesses. This is the lead investigator. You haven't like talked to him post his coma. I don't understand. Why are we fighting about this now?
Right. I mean, I think a just prosecutor's office would, you know, in the weeks leading up to the trial date, they're reviewing all this stuff, looking at, they're talking to the cops again, they're prepping their witnesses. It's like, holy crap, our case went into the toilet, even if we thought we had one at the beginning. You know, we're not going to drag this guy in because, again, folks, there's always at least
you and I had a discussion yesterday, and we went through some of Mr. Ariola's personal effects. You recall that, right?
Yes, ma'am.
That's what I'm after. Are they here in this box?
Yes, ma'am.
State lost on that one. I wonder if the coma could have been COVID. Someone mentioned that in the chat. I mean, we're just speculating, but it would have been the right time period.
I believe so.
And
I've got to take a hike here for a couple of minutes. I'll be back as soon as I can. Work calls at 2:03 a.m. on a Saturday.
During 1804, followed up their $2 super chat with a $5 super chat. Thank you very much. Very kind.
707.
This woman's like walking back with all the
Can you
swag
go
in the
ahead
world.
and
Like,
look at the same
you're
items
done.
that you and I looked at yesterday.
but yeah, if he had gotten, like, let's say if he had gotten the jab or whatever, I mean, he is definitely in the high risk category for something going wrong during COVID. I would not be surprised if that had anything to do with it, but I don't know yet, so don't spoil it, chat.
Have an opportunity to look at those.
Yes, ma'am.
Do you see two separate folded up pieces of white paper?
Yes, ma'am.
And what else is in that bag?
There is a. May I open it? Or just
Can you just look
Sure.
and tell us? I mean,
looks like the handyman tool, currency, some change, a chapstick, a washer.
so I'm going to stop you there. So the only things the only thing that has evidentiary value from my perspective are the two pieces of paper. Do you want us just to put this whole bag into evidence, Judge, or do you want us to separate it out?
Just separate it out.
Okay.
I can do that.
Okay, great.
Oh no, another cop with scissors. They had the rifle in the box all taped up, and it took the cop about 40 minutes to cut the tape away with a pair of scissors and a pocket knife.
On the stand?
On the stand. Yeah.
Oh, God.
He was cutting up his gloves. He had the plastic gloves on.
God.
Awkward question. I don't know if this is paper or lint. Do you want it or not? Seriously, I really. That's all you want. Okay. I just wanted to double check.
Don't brush the mic.
This guy's playing like really nice. He knows he's screwed. Do you want this lint? Do you want this? Chris, awkward question. I don't know my job.
Not at all.
The part that just doesn't, as we're waiting for this evidence, the part that just doesn't,
Oh, sure.
I can't wrap my head around, Bronca, is
Would
that
you like me to do it?
prosecutors need to win cases. That's how you get back in office.
Sure.
I mean,
Well,
this
you
is
don't need
not
to
a
win
case
all of
that's going to
them.
win.
Right. You don't need to win all of them. You need to win like 90% plus of them. You can afford to take a loss every once in a while. And it's never a guaranteed loss. This defendant could be the most innocent person ever, and still there's a 10% chance of conviction. So they might
Yeah,
win
'cause stupid jury.
regardless. Juries are dangerous and unpredictable. And let's face it, it's not like there's eyewitnesses saying this was clearly self-defense. There's only one survivor. It looks somewhat, you could imagine a scenario in which it wasn't self-defense. That ought not be enough for conviction, but it might lead a jury to convict regardless if they don't clearly understand what that legal threshold is supposed to be, disproving self-defense beyond a reasonable doubt. So the prosecution, I don't know if there's political drivers here. I'm told that the victim was well liked in the community. This defendant is a relative stranger to the community. The victim's Hispanic. I don't know if there's some kind of ethnic component going on here too.
Do you agree with me that those white folded up pieces of paper, that it is typical?
It wouldn't be hard to imagine a politically motivated prosecutor who wants to run for governor, for example, saying, hey, we got a case here of a white guy killing one of our Hispanic neighbors with a black evil AR rifle assault gun.
So wouldn't that all the more make you want to dot every I and cross every T, not find out on the stand that your witness is an idiot? No offense to him, but
I think you know that. I mean, they may go into this case knowing they can convict. I mean, there were, like in the Rittenhouse case, there was never any evidence inconsistent with self-defense on the part of Rittenhouse. They brought the case anyway because they figured they may get lucky and get a 10% conviction, just noise in the system. But even if it's an acquittal, they fought the good fight, right, for their Antifa brothers and sisters. Same thing in the Zimmerman trial. There was never any evidence in the Zimmerman trial inconsistent with self-defense. They brought it anyway. If they can get a win, 10% noise of the system win, they'll take it. But even if it's an acquittal, that prosecutor won her very difficult re-election campaign. So they have reasons other than the legal merits to bring the case sometimes.
This is true.
Unfortunately.
Of the way that cocaine or other powdered drugs are packaged.
I have seen them packaged in a similar manner.
And when did you receive that information from?
So on the victim, not only did he have cocaine and alcohol and pot in his system, he had they found a glass pipe on him as well.
Oh, geez.
OMI, if you can tell.
So this was tagged into evidence on 5/7 of 2020. So it would be within a week or two of that I received it from OMI.
Okay. Did you ever look at it?
The papers?
Any of that stuff, any of the personal effects that you got, did you look at that stuff?
No. I mean, let me rephrase.
Boy.
The lead investigator didn't look
It
at
was
the
listed. I tried my best not to open anything from OMI to tag straight in, especially personal effects. And so I glanced through it to confirm that was in there, which is 2 pieces of paper.
Why wouldn't you have looked at the personal effects to see if they were relevant to the case in any way?
Well, I mean, I did through the bag. I didn't examine them or separate them out or anything like that.
Okay.
And verified that was in the bag from the packing slip.
Okay, and you didn't indicate in your report that there was anything that looked like drug packaging?
No.
Okay. Permission to publish, I can do it on the Elmo, or I can hand it to the jurors.
No, show it here. You haven't moved for admission yet.
Oh, thank you. Move for the admission of Defendant's Exhibit O.
Now, this the defense attorney, you said she's not, she doesn't practice in New Mexico. She's a self-defense attorney, or is she in New Mexico? Do we know anything?
This defense attorney, her office is in Albuquerque, so she's in New Mexico.
Okay, gotcha.
She's just a local criminal defense attorney. I mean, there's no reason we would know her. She's just a regular, regular criminal defense attorney, except she's very good. I like her a lot.
Yeah. I just didn't know if she specifically, practices on cases like this, like how you do, or if she was just happened to be.
Oh, nobody does what I do. So no, she'd have a generalized criminal defense practice. She'd be doing DWI cases, theft cases, all kinds of things. I only do use of force cases.
Gotcha.
Which is a very, very siloed portion of criminal defense. It's a very narrow specialty.
I think it's ready.
Yes, it's ready.
Which is why you should go get your free book, lawofselfdefense.com/free book.
I heard there's a place where you can get that book for free. Right there. Do it. You can do it.
What is this?
These were the pieces of paper in the defendant's wallet that are of the type used to.
Do you agree with me that the way that paper is folded numerous times in that fashion is typical of packaging for illicit powder narcotics?
It could be.
You've seen that in your career?
Yes, I have.
All right. And do you agree with me that there was also a straw on Mr. Ariola's person?
I'm not sure if it was a straw or a pen with the stuff taken out. It was white.
Okay,
and
same thing. For our purpose,
we have it.
It was
here.
a tube. Suitable for the snorting of drugs.
Strider in the chat. Who stole Hunter's stash? Oh boy.
May I get some scissors, please?
Oh. Mommy, can I have some scissors?
These cops are not safe with scissors. They should give them those little kindergarten scissors with the rounded tips.
Yeah. They can't cut for shit.
Just plastic scissors, no metal edge at all. Just
Yeah.
Yes, ma'am, I have it.
I missed a super chat here. It's been brought to my attention. The reason I didn't mention it, Karen, you're complaining in the chat. It's because it's only $2. $5 minimum, my friend. But it's about you, Farron. So I'll read it regardless. It says, here are some Branca bucks. Also, love you, Farron.
Aw.
From Cayenne. There
I'll
you
just
go.
give Bronca another $3 and he'll be happy.
Let's go ahead and mark that as defendant's exhibit.
So only about 40 minutes left in this in these proceedings from yesterday. This might be the only witness of the day, really.
Defendant's exhibit P.
Be admitted.
Well, prosecution's going to have to take the rest of the day to figure out how to clean up this mess.
Yes, ma'am.
And you agree with me that what this is a fifth pen that has the top, the center, and the end removed?
Correct.
And is this something that can be used to sort cocaine?
Can be, yes.
I think in the company of the drug envelopes, it's pretty much an open and shut. I mean, what else would you be carrying it around for? You
Yeah.
can't write with it.
Yeah, exactly. You ain't writing letters.
And based on your investigation, Mr. Areola was known to carry mace.
Yes.
Oh, that's important. That would undercut any state argument that the defendant had it himself and just planted it on the victim.
Mm.
Let me just review my notes. One moment.
Let me figure out how I want to
So-
murder you now.
You indicated to Mr. Cummings that you were going to test the swabs that you took of his face and hands for mace, right? Or for chemicals.
For chemicals, yes.
Did you do that?
I did send them to the forensics lab in Santa Fe.
Right, but you didn't request that they be tested for chemicals.
I have nothing on paper that says I did. I don't recall if I had a phone conversation or not with them about that. I don't recall that part, but there's nothing in my reports that say I did.
Well, and you've heard
How does he
from
remember?
the folks at the lab, and they testified that's not even anything they're capable of doing.
Correct.
So did you take any steps to get the swabs or the shirt tested as you told Mr. Cummings you would?
No.
Oh my God.
This is a clown show.
And by the way, why would Cummings request his clothing be tested unless he believed the test was going to come back positive and corroborate his story of self-defense?
Mm-hmm.
Right? Crazy. And someone in the chat mentioned this, and it's absolutely true. If someone were arrested by cops for some reason and they found those envelopes and that empty pen barrel on their person, it would absolutely be logged as drug paraphernalia.
Yeah. But I'm sorry, he said that drugs didn't have anything to do with this?
That's what he told the grand jury.
Yeah. But again, this is just stuff that the state, you didn't see this coming at all?
You were asked on direct examination if you've ever requested testing for an ejection pattern, right?
Yes.
We're changing the subject now, folks, just so everyone's aware. From the pepper spray, from the mace, we're changing the subject now to the brass casings being ejected from the rifle. That's what she means by ejection.
Oh,
pattern
ejection
here.
pattern. I
The
thought she was
state-
still talking about the mace. Good clarification. Thank
The
you.
state lab has a ballistics unit, right?
I believe so.
What?
Did
You
you
believe
ask the ballistics unit at the state lab to do any testing for you?
I didn't even know they had a specific ballistics lab. that
What?
was with firearms is what I knew of to send them up for firearms testing. My experience, the crime scene, people do the ballistic analysis as far as like trajectory and stuff and ejection. That would be, in my opinion, done at the scene. I didn't know they had a specific ballistic lab.
Did you ever call up to the state lab and say, what kind of testing can you guys do for me?
I don't recall if I did or not.
But you remember sending stuff to Santa Fe?
One moment.
This case is insane. If they really did not test the clothes for the mace, first of all, they should never have brought these charges. They cannot prove that his story of self-defense is false without that.
They charged this guy with murder 6 days after the event. He was charged with murder.
Well, then the other question is if the lead investigator never tested
Just
it,
for completeness.
couldn't the prosecution
Mr.
have
will
tested
also
it?
have a marijuana pipe on his person.
Like the prosecution could have ordered that?
Let's go ahead and move that into
Probably.
evidence.
Defense should have had it tested. I wonder if they did.
Now the defense, you have to keep in mind that the defense is not, it's not like they're there immediately. The defense team's brought on later, sometimes much
That's
later.
true.
And they're not in possession of the property. They have to request the property. They may have to file motions with the court to get the property. There has to be hearings. The state doesn't want to give it up. They don't want to give up control of the property. So it can be very difficult, especially, by the way, in some cases, like in the George Zimmerman case, he went through several defense attorneys before he ended up with his final legal team.
Jeez.
So the final legal team has no control over what those earlier defense attorneys
But
were
are you
doing.
telling me that the prosecution can make it difficult for the defense to test evidence in their possession? Because that's
No,
crazy
they
and should
often
be
do.
criminal.
I know they often do. They often do. Yep,
That's insane.
for sure.
That's so wrong. That is so wrong. I hate the way the state does these things. I just hate
And either
it.
they'll either say no, or they'll just slow walk it through the process. So it takes forever. And of course, some evidence dissipates if it's not evaluated right away, right?
That's
So yeah,
awful.
it's not right. There's bad prosecutors out there. Most of the prosecutors I've ever worked with have been good civil servants just trying to do a good job, but they have unbelievable power and discretion. And if you put that power and discretion in the hands of a bad person, you end up with a very, very, very bad prosecutor indeed.
I don't like anything about this case. Nope.
So now we know the, and by the way, I should say, as I do from time to time, none of us, nobody knows what actually happened, right? I don't know that this was actually self-defense and not a murder. I wasn't there. Nobody, the judge doesn't know, the prosecutor doesn't know, the defense doesn't know. I mean, who knows? Maybe the defendant himself doesn't know, but so you never know these things with absolute certainty. So is it possible this was a murder? Sure, of course it's possible, but that's not the legal question.
They have to prove
They have
it.
to
They're doing a
disprove
shit job so
self-defense
far.
beyond reasonable doubt. And if this is your case, you ought not subject an accused to a criminal trial where there's a 10% chance of conviction, even if they're pure as the driven snow, when this is your case. So it is a marijuana pipe, apparently, not a crack pipe.
What's the law in New Mexico? Is it legal?
I don't know.
And let me just ask you, is that a typical looking marijuana
I believe
pipe?
it is.
You want me to keep going? Open it all the way
Well,
up?
haven't you seen pictures of it?
Yes, it is.
Okay, it's just a
Yeah, it was
regular
legalized this
marijuana
year.
pipe, right?
Yes,
Okay.
yes.
Oh, 2 years ago,
So I'm
maybe
not gonna
not.
have you open it
Okay.
and go through all that. We're just gonna mark it as Defendant's Exhibit Q and I'll move for its admission.
Counselor, can we agree that it was just the same pipe that's in that picture?
Yeah.
Okay, you'll be admitted.
I like this judge. He's very careful about the record. I like him. That's his job.
The pipe?
Yes, he'll be
Okay,
admitted.
sure.
I don't want someone to speculate that there are two pipes.
That's a good point to bring in because they have a surprise magazine for the AR for the rifle in question. They came up with a magazine, 30-round magazine out of nowhere. So he just wants to make sure there's no further confusion with these items of evidence.
And as a point of clarification, Mr. Areola was not the only one of the two folks involved in this altercation who apparently used marijuana. Is that correct?
Could you rephrase it? Are you talking
Was
about?
there any evidence discovered that Mr. Cummings also used marijuana?
If I could refresh my report, but I don't believe
It's
so.
okay.
Thank you.
I'll pass the witness.
Just welcome.
Am I the only person left on earth who doesn't smoke weed? It's like when I go to the gym, I'm the only person there without a tattoo.
I don't have any
I
tattoos.
just have a couple
Neither
of
do I.
follow-up questions for you, sir. So, and I'm going to start right where Miss Morrissey left off. We talked a lot about your grand jury testimony and the transcript. I believe one of the grand jurors asked you, do you know whether there was drugs or alcohol involved in this? And your response was, Mr. Cummings, we did recover some marijuana in his unit. Do you remember that?
I don't recall it, but if it's in the transcript, I'll agree that I responded that way.
Now, grand jury proceedings are different than a trial. Is that correct?
Correct.
It's a finding of probable cause.
Yes.
And the people who are the grand jurors get to ask you questions, right?
Correct.
And they can ask pretty much on anything so long as they're curious and it's relevant to the case.
Correct.
They would have to know what to ask.
You testified at the grand jury on March 19th, 2020.
Okay.
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 Pretty soon after the homicide.
Correct.
Would it surprise you that Agent Herrera didn't complete his report until April 7th, 2020?
No, that doesn't surprise me.
So you wouldn't have had any of his trajectory stuff or his report or anything that he did on scene?
Correct.
You wouldn't have had OMI at that point either?
I really doubt it. Normally they'll send the report with the evidence. Sometimes they send it separately, but I doubt I would have had the all my report by grand jury.
Okay, and you testified on cross-examination, which memory is a big part of testifying, right? This case is over 2 years old. You
Correct.
testified that you physically do not remember testifying at the grand jury.
Correct.
Why is that?
Oh,
Here we go.
Excuse me.
Uh-oh.
And sorry.
Oh, no.
oh, family member died. Car crash.
2021. I was in a coma for 9 days. And because of that, I have some memory issues. Long term, some short term. I apologize.
Oh.
So it's not that you don't remember testifying at the grand jury, you just physically don't have that memory anymore.
Correct.
Um,
You know you don't have any further questions.
Also in your question about the grand jury testimony about why you believed mace was not used. Let me just find that page. I think it was 12.
I mean, that's not helpful to the state. That explains why he doesn't have memory, but him not having memory does not contribute to disproving defense beyond a reasonable doubt.
Oh, my camera's doing weird stuff with my lighting. Sorry.
Yeah, you look a little
You-
backlit.
Yeah, I don't know.
Believe that mace was
Fix
not at
something.
all sprayed because it was pointing backwards at the decedent?
Objection, leading, and foundation.
His memory is not an excuse for any of this, unfortunately, for the state.
Let me find the page then. On cross-examination, you were asked about your grand jury testimony and that you testified to the grand jury that you do not believe that the mace was ever used. Is that correct?
Objection, that is not the testimony that came during cross-examination, I don't believe. We talked about some of his testimony regarding the mace, but that statement didn't come out.
And I disagree. I believe it did come out.
Overruled. See if you find that in that grand jury testimony.
So for folks who most jurisdictions have a rule where you have direct questioning, whoever called the witness, and they might ask about 5 different topics, A, B, C, D, E. On cross-examination, the other party's only allowed to ask about those 5 topics that were asked about on direct. So they could ask about all 5, they could ask about 4, they could ask about A, B, C, A, B, A, whatever, subset. But they can't ask about F. If F was not asked about on direct, you can't ask it on cross. If you want to question that witness about F, you have to wait until you're calling witnesses and call them back to ask about F. So that's from direct. On cross-examination, you can only ask about what was questioned on direct. If you're going to, after cross, do a redirect can only ask about what was covered in cross. So it's like a diminishing period. So if you asked about A, B, C, D on direct, and then on cross-examination, they only ask about A, B, C, on redirect, you can only ask about A, B, C. So the objection from the defense here is, hey, I didn't ask them whether or not the mace was ever used on cross. She should not be allowed to ask that on redirect. But the judge seems to be taking the attitude that, listen, you were asking about stuff in the grand jury transcript. I'm not going to let you bury a topic of interest to the jury because you obviously deliberately didn't ask that question. And here's the truth, folks. You know, when the ultimate rule for when evidence is admissible in court, if the judge says it's admissible, that's the guy that we have all kinds of rules about what's admissible and not, but those rules are applied by the judge. And if the judge says it's admissible, that's it. It doesn't matter what the rules are, really.
Bronco, like 25 motorcycles just went past my house, which is why I muted myself because it got really loud. There's like a
trains that go by here several times a day and blow their horns.
So at page 10, the very first paragraph, you were asked on cross-examination whether or not you testified there was no evidence at the scene or on Mr. Cummings that mace had been utilized. And the question was, do you still believe that statement?
Say that one more time, please.
Sorry, it's kind of convoluted. So you were asked on cross-examination.
This is a state witness.
Whether or not you still believe that the mace had not been utilized.
Correct.
Why do you believe that?
There's a number of different factors in it. Typically when mace is sprayed, it remains in a room, it remains on clothing, it remains on people, it remains in the air, it remains. There's parts of it it's just not poof and it goes away. It lingers at least in some parts, and no one at the scene, even though there had been a great amount of time, I can see that there had been a time between. There would have been an indicator somewhere of the odor, if there was.
But he never had it tested.
Color dye, which I believe there was.
No, and he doesn't know how
some
much
remnants of that somewhere.
I mean, he just doesn't know.
Fact, there would have been some.
And that would be my question to him. They should recross and just ask that one question. But you don't know, right? You weren't there. You don't know. You're making inferences. This is your personal belief, but you don't know.
And you didn't bother to check either. You did not bother to have it tested. That's the part that I can't get over. How could the state not test those clothes?
Indication of mace discharge. Someone with all the people going through, it would have been evident to them and they would have reported it to me.
What was the only piece of evidence that mace was used? Was it Mr. Cummings' statement?
Yes.
Was there any corroborating evidence that mace was used?
No corroborating evidence.
On cross-examination, you were asked, and this was on page 12 of the grand jury transcript, you were asked about your testimony during the grand jury, why you believe that Mr. Ariola was turning to leave the room.
Yes.
Oh boy.
Well, your testimony was, tell me, as Mr. Ariola was trying to remove himself from the room, why do you think he was trying to remove himself from the room?
I believe because the defendant had a rifle on him and began actively shooting. Is why he tried to leave the room.
Right, but what makes you, with the physical evidence of where Mr. Ariola's body was positioned, believe that he was trying to leave the room?
I'm sorry, I don't understand the question.
Okay.
How do you know?
This guy might be the single reason this case came to trial. I mean, think about his testimony. I believe the defendant's lying about being maced. I think the defendant shot this guy as he was trying to run away. That's just a murder.
Mm-hmm.
All conjecture. It's all conjecture.
Right, and they didn't challenge him. They just accepted what he's our lead investigator. This is his professional opinion. That's enough for us to move this case forward with. If you assume the guy has an evidentiary basis for these opinions, you might feel like you have a strong enough case to move forward with a murder charge. But then you lift up the covers on this guy and there's nothing under there.
Is anybody else concerned that he is still employed as an investigator and he has such terrible memory problems? I don't think that's a good idea.
I have questions.
I don't know if he's still a lead investigator or not. I don't remember what he said he was currently doing, but he's still a law enforcement officer, still a sworn officer. I mean,
Yeah.
It seems to me like his medical condition should, preclude him from doing this kind of work.
yeah.
So on cross-examination, you were asked about all the shots were shot forward toward Mr. Ariola. And Morrissey asked you why you believed he was trying to leave the room if you did not have the OMI stuff and you didn't have any of the other stuff. Can you stand up and show the jury how you believe Mr. Ariola was shot?
I'll do my best.
Thank you, sir.
Objection. Let's approach.
Yeah, so he has no personal knowledge of any of this stuff. So unless he has some demonstrable expertise in recreating these kinds of events, this is inappropriate testimony.
Yeah.
It's nothing but speculation on his part.
Which, I mean, state, I believe, I don't recall, I assumed,
Yeah.
I
This is
assumed, it's all CYA words.
Crazy.
Right.
This is a terrible case for them to have brought forward. They're going to look really dumb. They already look dumb. And I feel I kind of feel bad for Cummings being dragged into
Let me ask
this.
this in a different way, sir.
He's not allowed to do it.
Can you verbally tell us how you believe Mr. Ariola was shot?
I believe as he entered the room where your momentum's traveling forward, the defendant began to shoot. Ed Booth,
Unprovoked?
most people do when you hear a gunshot is duck, which would put him in a bent over position as he's stopping and trying to turn. And that's when he takes the lethal rounds, and even the one that didn't go in him, the one in the back for his clothing. His momentum's still slightly going one direction as he's turning, and then he just collapses down.
Well, that's not trying to get out of the room. That's still charging into the room.
With OMI, people and items fall in weird ways, and because you have no control.
What he just described was someone acting like an aggressor, coming into the room, bending over, charging at someone holding a rifle.
It's not set in physics.
This is so
Because
bad.
of momentum.
Momentum, all kinds of other factors.
I mean, if I were the defense, I would include this testimony in my closing argument.
This is but it's also a fairy tale. Like he's just making it up because he wasn't there. He has no idea.
We don't know what exactly momentum-wise, physics-wise happened in that room.
You don't know anything about what happened in that room.
Now, you were asked on cross-examination, Lieutenant Tomlinson, whether or not Mr. Ariola was known to carry mace.
Yes.
Uh-oh.
Was he known to carry mace with a die?
I was told he was.
Okay, that's hearsay.
Yeah. Objection hearsay.
Why didn't? Was there an objection?
Mm-mm.
Yes.
Why would the defense let that go?
That's a weird thing.
Would you like me to leave this? Yeah, leave everything there.
Man, there must be some kind of motorcycle convention because I've had like about 100 of them go by now, and like every few minutes.
You may call your next witness.
Your Honor, at this time, the state rests.
Oh,
Okay,
that's it.
ladies
You're
and
gonna
gentlemen,
rest
the
on that?
time is rest of the case in chief. What we're gonna do now, we're gonna recess.
You just
Wait a minute, wait a
lost.
minute, wait a minute. Andrew, were
Let
there
me
other
read you
witnesses that we missed?
recess in-
Well, I don't know what you watched. I've watched the whole trial, and all the
Okay,
witnesses were like this quality for
Were
the
they-
state. They
were
weren't
they
any
all
better.
officers? Was there anybody who created a motive, like he wanted, he wasn't the guy decided not to sell the property at the last minute and told, I saw them, whatever. Was there anybody to create some kind of motive for this?
No, nope. There was a real estate lady who was a seller agent for the victim here, who had written up a sale agreement
Right.
that the defendant had taken and said, "Okay, I want to take this to go have my attorney look at it." And the real estate lady wouldn't let him take it to have his lawyer look at it. But she never said, she had no testimony about any kind of animosity or disagreement over price or anything like that. She was very sad the victim was dead, so she was very tearful on the witness stand. Then they had the guy who was on the motorcycle who first encountered the defendant, but the defendant just said, "I shot somebody in self-defense. Can you can you look at the scene, right? Call police." And everybody else, of course, the medical examiner, but she doesn't know whether this is murder or self-defense.
Right.
She just knows the victim was shot and the manner
How
of
he
death.
died. Mhm.
Everybody else has been a law enforcement officer, like this guy.
This
They
is
didn't
insane.
test, they didn't collect, they don't remember, they can't recall, they think this might have happened or that might have happened or probably this or probably that. Nothing with that in any substantive way undermines this defendant's claim of self-defense.
I think it is absolutely criminal that they brought these charges, because now this guy's life is in the hands of a jury, which is probably more than likely stupid. And all you need is a couple of people who decide they want to put somebody in jail, and they'll do it. I mean, I just witnessed a trial like that myself. No evidence, definitely lots of probable doubt,
Reasonable doubt. Yep.
lots of reasonable doubt. Thank you. And they still came back with a guilty verdict, and absolutely stupid. So putting somebody's life in the hands of a stupid jury, which is what they usually are, is so outrageous to me with this little evidence. This is bad.
Yeah. And I would argue that no rational jury could conclude from the state's case in chief that self-defense has been disproven beyond any reasonable doubt. I mean, this should just be
Not all
a
juries are
judgment
rational.
by the judge. It shouldn't even go to the jury.
It shouldn't go.
That's
no.
that's my thing. Like let's recap. Your only evidence is from your lead investigator that can't remember shit, that
Didn't test
anything, doesn't remember why he didn't test things, but then remembers he did one test sent to Santa Fe. It's a mumbo jumbo of word
Garbage.
salad by him, and you still wanted to take this to a jury.
Yeah. No.
Of course, there is other evidence. There's the holes in the structure and all that kind of stuff, the brass that was collected, but none of it is inherently inconsistent with self-defense. It would be the same evidence you'd expect if the defendant was telling the truth about self-defense. So it
extremely uncomfortable. I'm extremely
And Henry
uncomfortable to see
Bowen in the
evidence.
chat too. Henry Bowen makes a great point, but New Mexico won't charge Alec Baldwin.
Which is an open and shut involuntary manslaughter case. I mean, there's no contrary argument to be made there.
Well, he's
it's
not being
absolutely open and
charged
shut.
because he's
No.
famous and
Probably.
wealthy.
Yep. And that part of New Mexico in particular, the Santa Fe Taos area, that's also where this ranch was. And I don't think it was in this county. I'm not sure about that, but it's the same general part of New Mexico. They like their movies there. They like Hollywood. It's a very progressive. The whole state's pretty progressive, but that's part in particular. They would love for more Hollywood films to be done out there. And I would reasonably assume that if they start prosecuting Hollywood actors, they're going to get less film business out there. So there's a financial motive as well for not charging.
Andrew, how does it
Baldwin.
work? How does it work if the judge would decide not to send it to the jury? What are the standards there?
So this happens in every criminal trial, by the way. The defense always files for the acronym is a little different in different jurisdictions, but here I believe it's called a judgment of acquittal. So the judge is ruling an acquittal, and the legal standard is if we look at the evidence, all the evidence in the light most favorable to the state, is it possible for a rational jury to believe guilt has been proven beyond a reasonable doubt, or in the self-defense case, that self-defense has been disproven beyond a reasonable doubt? I would argue here, I'm sure the defense will, that given the state's case in chief, and looking at the evidence, even in the light most favorable to the state, no rational jury could believe that self-defense had been disproven beyond any reasonable doubt. There's a reasonable doubt that this could still have been self-defense, even if you look at the evidence entirely in the light most favorable to the state. So that's what the defense will ask for. They'll ask for a judgment of acquittal. So then it would never go to the jury if it's granted. They'll ask for a judgment of acquittal on all 4 charges. So the murder, second-degree murder, the lesser included of voluntary manslaughter, the concealment of identity, and the tampering with evidence. They're going to ask for all 4. In fact, hopefully they'll do that
How often do judges actually grant those? Do you know?
because if there's even most judges' attitude is if there's even a 1% chance that a jury could arrive at a guilty verdict rationally, they're going to let the jury make that call. That's the jury's job.
So here's a question. This is your field of expertise. You've watched this trial. The state just rested on that, whatever that was. Do you put Cummings on the stand?
I don't think they can. I think Cummings has his own mental health history. Lots of conspiracy theory stuff, lots of paranoid stuff we haven't heard about it. Now, I don't know this is true, by the way. This is what's reported in the media about him.
Allegedly.
And he was a famous guy. He was a famous skier. So there's been magazine articles and stuff about him that suggest these mental health problems. But if those are true, you wouldn't want them in front of a jury. And I think the reason we've not heard about them in the trial is because they've been appropriately excluded as character evidence about the defendant. So the jury's not supposed to know this, whether they know it or not, who knows, but it's not supposed to be a character evidence is generally excluded, inadmissible in a trial.
I
But
wouldn't
if you
think
put him on the witness stand, then he's just a witness. And you
Yeah.
can impeach a witness's credibility with whatever you got. And that would include this mental health history.
I don't
So
think
I don't
he
think they
needs
can
to
afford to put him on the
testify.
stand.
I don't think he needs to. The state has not done their job. They have not proven this was not self-defense. There's no they have zero evidence of that. I haven't seen so far. I haven't seen anything. And if you're saying everybody else has been pretty much the same, I don't know why he would need to. I don't think he needs to testify at all.
Someone in the comments is mentioning what's called a JNOV, which is a jury not judgment, notwithstanding the verdict. That happens at the end, folks. That happens if a jury returns a guilty verdict. Then you can motion for a JNOV and argue to the judge that, listen, I know the jury came back guilty, but that's an irrational decision. No rational jury could have believed guilt was proven beyond a reasonable doubt. And you can try to convince the judge, if he agrees, he can make the guilty verdict go away. They never do that either. But you always ask, but they never do it.
Mm-hmm.
All right, let's see what's happening here, because I think we may hear the motions for JOA on the 4 charges right now.
I read you at the beginning of the case, and then I'll give you a few scheduling information in a second.
I'm going to skip any instructions to the jury here. They would just be general stuff like don't watch the news.
During recess, do not discuss this case with other jurors or with any other person.
And real quick, I got to dip out, but thank you so much for having me. Make sure you
Hey,
guys
thanks
hit the
for coming
like
in.
button, all that stuff. I'll see you soon, Branka.
Good to see you, Karen.
Bye, Megan.
All right, let me see. Judge is away. He may be reviewing those motions in chambers, making his decision. Is that him back? He's back. Okay, so let's see what's happening here. It's muted. That's not me. The jury would be out of the courtroom now, so he's just talking to the lawyers and the defendant. If they put the mics on. It's not me, right? No.
No, I don't think so. It's to me, this is very disturbing, and I really hate watching the state bring charges against people that are this flimsy. I really, it makes me very angry. I get rageful inside.
Especially given the stakes, right? I mean, it's a murder charge. If he's convicted, he's in prison for the rest of his life.
Yeah, it's huge. And I wonder how much money this has cost him. Like did he hire private attorneys, or are these public defenders? Do you know?
The woman who's been, they're arguing to the judge, but they got the microphones off. The fence is arguing to the judge. She's arguing now for the JOA, I'm sure.
I wonder why they have the mics off. Are we not allowed to hear that?
No, sometimes they forget.
That's not tampering.
Oh, here we go.
Evidence is also overwhelming that when he was washing his face and hands with the water from the spigot, he was doing so because his eyes and his skin were burning, and that he was trying to remove whatever it was, the irritant that was burning his skin and eyes. So there was no intent and there's no evidence of him trying to conceal or destroy evidence. To the contrary, all evidence shows he was trying to preserve these items for evidence. In regards to concealing identity, we also have uncontroverted evidence that Mr. Cummings called 911 himself directly. That is indisputed by the state's witnesses. When he called 911, he specifically told them his name and gave his phone number, and then of course went on to tell the operator what had happened at the ranch that day. But the evidence is indisputable that basically as of about 5:31 or 5:40 on February 29, 2020, Mr. Cummings had already given his identity to authorities. So for those reasons, we would move for directed verdict.
Come here from the state.
Mr. Chairman, and if I may at the podium.
You may.
Yes, sir. In regards to the second degree murder and the voluntary manslaughter, the state
So they asked for, I've been calling it a JOA, but a directed verdict is the same thing. The judge just hands down a verdict without it going to the jury. And it was, unfortunately, the courtroom microphone was muted during the initial arguments by the defense, but they would have started with the highest charge first, the murder, then the manslaughter, then the tampering, then the identity. We only heard the last two, but I'm sure they argued for directed verdicts for all four. And now the state's going to argue contrary to that, why this matter should go forward. The defense should have to present its own case in chief to the jury, and the jury should make the call.
The chat is mentioning that Cummings has been in jail for 2.5 years.
2.5 years since it happened. Yeah.
What? Why
Yep.
didn't he get bail?
Well, it's a murder case. Often in murder cases, there's no bail, especially
Wait,
if they think
what?
the person's a flight risk and he doesn't have a residence in the, he was looking to buy. So he's not technically even a resident of the county.
God. This is
forth
outrageous.
that
What's that?
I think that's outrageous. Especially
Imagine what would happen to your life if you spent 2.5 years.
Destroyed.
And this is part of the way the process itself can be used as a punishment, right? So
Right.
even if he's acquitted at the end, he's a free man. He still lost 2.5 years of his life in jail. He doesn't get that back.
there has been sufficient evidence for this case to go to the jury in the light most favorable to the state and all reasonable inferences. The homicide was committed without sufficient provocation. There's no evidence that the mace was actually sprayed. There's no witness that smelled it, no witness that observed any physical sign that it was on the defendant's person. He didn't have any runny eyes. Nothing indicates that it was actually sprayed. He didn't have a rash. And indeed, the evidence shows that the can of mace in Mr. Ariello's hand was actually pointing at the decedent. It wasn't pointing out. Furthermore, there's no physical signs of a physical fight in that residence. None of the.
So again, the real legal standard here is if the jury believes the version of the facts as presented by the state and does not believe the defense version of facts, could they arrive at a guilty verdict on this charge? It's a very difficult standard for the defense to defeat.
Furniture's overturned. There are no marks or abrasions or anything of that nature on either party's hands to indicate that there was a fight. In fact, the only evidence of a fight came from opening statements, and that was it. Nothing came through the evidence.
Sorry, John. I was desperate. I apologize.
And Your Honor, at the scene, the defendant said there was a fight for a gun, but again, there's been no evidence that there was actually a fight for the gun. In fact, the evidence shows that this was a homicide committed without sufficient provocation. Indeed, OMI even said that Mr. Audiola could have been on all fours when he was shot, again, indicating that this was committed without sufficient provocation. In regards to the tampering with evidence, the state asked that the court send this charge to the jury. The defendant told the officers he washed his face and changed his clothing. That's not in dispute. However, he did intend to prevent apprehension or prosecution of himself for these crimes. His interactions with Mr. McCullough, he comes up to Mr. McCullough, asks him about his motorcycle, leaves, comes back. Those interactions infer that he was intending to not turn himself in. He was intending to flee. He was trying to prevent the apprehension of himself for these
I'm
crimes.
going to change my laundry.
He only called law enforcement after Mr. McCullough already called. He didn't call before. And so for these reasons and the evidence-based that the state has put forth so far, we would ask that the court send this charge to the jury. In regards to the concealing identity charge, which is New Mexico Statute 3022-3, Deputy Crespin testified that he asked the defendant for over 3 hours what his name was, and he refused to say. He even told him that if you don't tell me your personal identifying information, I'm going to charge you with concealing identity. And even then, he still continued to refuse. He would only say Dean. He didn't give his first name, his last name, or date of birth. And I believe Deputy Crespin even testified that he kept changing his date of birth. Just because he called Sandoval County Dispatch or the Bureau of Indian Affairs doesn't mean he's telling the law enforcement officer who's asking him right here and right now, what's your name, what's your date of birth? That doesn't mean that it gets transferred over. And for concealing identity, it consists of concealing one's true name or identity with the intent to obstruct the due execution of law, or with the intent to intimidate, hinder, or interrupt any public officer, which is exactly what he did on February 29th. And in the light most favorable to the state, we would ask that these charges do go to the jury. Thank you.
Ms. Moss, any response?
Yes, Your Honor. Specifically regarding the tampering with evidence, the DA is twisting their own theory of the case. The tampering with evidence is based upon the defendant allegedly changing or hiding his clothing. It has nothing to do with whether he was trying to flee the scene, which is absolutely ridiculous. We've all heard the evidence. We know that is not true. But the charge is based upon the fact that he removed his shirt and his jacket and put him in the back of his pickup truck. The evidence is overwhelming that he did that to preserve the evidence, not to destroy or hide it. Furthermore, lost my train of thought on that.
I would point out there's an inconsistency here by the state, right? They're saying, well, he's removed his, why would he, the only reason he would be removing his clothes to hide evidence is if the clothes were evidence, they'd only be evidence if they were maced. If there was no mace, there's no reason to change your clothes, right? You're not changing the facts of the event if the underlying fact never occurred. So if the state is arguing there was never any mace used, they can't say this guy's changing his clothes to hide evidence of an event they say never occurred.
But so the evidence is overwhelming that he was doing that specifically to preserve evidence, not to in any way try to hide it or tamper with the prosecution. Also, the state is saying that there was no evidence on his
There we go.
They're trying to have it both ways. They're saying that the mace was never sprayed, which means there's no evidence on the clothing, and yet he's still trying to destroy clothing. So it makes no sense. The state's not totally twisting their own theory in a desperate attempt to keep this count to the jury. Regarding the concealing identity, there is no evidence he was trying to in any way disrupt or interfere with an investigation. In fact, all of the evidence shows that he, in fact, was trying to further the investigation by providing his name as soon as he possibly could to law enforcement. Also by telling them his father was coming. All of this information that he provided to law enforcement freely that shows that he was not in any way trying to conceal his identity.
All right, the standard on these motions is in viewing the evidence that lies most favorable to the state. Is there legally sufficient evidence for this matter to go to the trial of fact? I'm going to deny the motion with respect to the second-degree murder and the lesser included. I'm going to find there is legally sufficient evidence for those charges to that charge or the lesser included to go to the final fact. I am going to grant the motion of directed verdict with respect to the tampering with evidence and the concealing ID. There's no evidence of that in the eyes of the court, but the murder charge will stay, and that one will go to the trial fact, which is the jury. So, folks, have a safe weekend, and we will see you Monday at be here by 8:45. All right.
All right. So, appropriately enough, the tampering with evidence charge and the can you hear me, Megan? Are you back?
I'm back.
You're muted. Okay. So the tampering with evidence charge and the tampering with evidence and the concealment of identity charges were both dismissed by the judge.
Appropriate. Yeah.
And but the murder charge remains, and that would include the lesser included. So that now it's go big or go home for the state. They can't hope to get a minor conviction on one of those lesser underlying charges. They're going for an intentional homicide, or and the way it effectively works, folks, is the state would say, all right, we believe this is an intentional homicide, and if the jury believes it was not a justified killing, not self-defense, the defense can still argue, all right, if you believe it was an unlawful killing, it still wasn't murder because there was adequate provocation. It was done in hot blood, not cold blood, as a consequence of the fight, the physical fight between the men that was started by the victim. Perhaps it wasn't an intensity of attack by the victim that justified him being shot, but he did start the physical confrontation. Hot blood, no intent to, none of the intent required for murder. It mitigates down to manslaughter. And manslaughter is bad, man. Manslaughter is, 10 to 20 years. But with manslaughter,
God, really?
Yeah. Especially with a gun, there'll be a firearm sentencing enhancement added on top of.
And it's an AR-15, so
it
they'll
looks
probably
bad.
get the chair for that. Yeah.
Yeah, it's not an AR-15. It's a SIG 5.56, but they're calling it an AR-15. Sure.
Right. They're calling it that. Yeah.
And that's what matters for practical purposes. But at least with manslaughter, you may have a possibility of early release. I mean, I'm not a sentencing expert, but in many states, you can do as little as a third of your sentence and be eligible for early release. So you're sentenced to 20, you might do 7 and get out. You can still live some kind of life. If you're convicted of murder, it's generally life in prison without possibility of early release. So that's forever. So a manslaughter conviction really sucks unless the only alternative would be a murder conviction. But now the defense at least doesn't have to worry anymore about tampering and identity charges. They only have to worry about murder, second-degree murder, intentional murder, and whether that might be mitigated down to manslaughter.
See, now I think if a judge has to throw something like that out after the state has brought it forward seriously, when the judge then decides no rational jury could actually, convict on that, I think there should be some kind of, I don't know, like shock bracelets on the prosecution that at the very least someone can send shocks to them for doing that. Like there should be some kind of punishment, whether it's public caning or something for doing that, for bringing forward charges that no rational person could agree with. That there should be a
that's the ultimate weakness. The judge is literally saying, even after you've had days to argue to a jury, there's 0 here. 0.
Yeah, that's pretty bad, right?
I mean, that charge. Yeah, I would listen. I mentioned my Kyle's law, Rittenhouse law earlier. I would hold prosecutors personally responsible for a civil suit by a plaintiff that had to defend against a charge that was dismissed at this point in a trial because the only reason it's dismissed is there's literally 0 to back it up. There's nothing for a jury to consider.
Shameful.
Hey, you're going to end up with a man if you keep folding laundry on camera. Like that should be your OnlyFans channel right there, just folding
laundry. But you guys, do you recognize though how bad it is that I'm still folding laundry? That's how much laundry I have to do. So, feel sorry for Mr. Fox because it builds up all week, and then my Saturday is just frantically doing laundry.
All right, let me address some of these super chats here. STFUFFS, only $2, but he followed up with $5 in a moment. So thank you. He says the cops here have utterly shat the bed. Shameful indeed. Again, STFUFFS, $5 super chat. Thank you. I would like to know how a 6 Sauer 5.56 had a 22 long rifle Savage Arms magazine and was being fired at police. Seems inconsistent with reality. I'm not sure what you're talking about there. So to clarify for the audience, the weapon used to kill the victim was a 6 Sauer SIG 5.56 model rifle that fired 5.56 millimeter rounds. That's the caliber of the gun. There was a second rifle in the room not involved in the fight. It was tucked under a mattress. It was a 22 caliber rifle that had a 22 long rifle caliber rifle that had a magazine for that rifle with 22 long rifle rounds in it. But those rounds were not ever fired in this event, and nobody ever shot at the police. The police only arrived after the fight was long over. News Now Wyoming, $5. Thank you. Says I believe Sounds like reasonable doubt. How do you prosecute with everyone guessing? Yeah, good question. Das Ogre, I already mentioned you. There's no comment, just $10. Thank you very much. Derna, 1804, witness has the same blank stare as cattle. Liberty or $10 super chat. Says, I agree with you, Andrew, and there should be a law against lawfare. These prosecutors, they should not just be against the law. It's supposed to be against the law anyway. There's supposed to be a probable cause threshold. They're supposed to not be able to drag you into court unless they're walking in with at least 51% of the evidence that you're guilty. So the legal system itself should prevent this. But if it's not going to, we need to encourage prosecutors to police themselves. And the best way to do that is make them personally liable in civil court when they engage in this nonsense. Let's see. Shut Up, I Can Cook, $5. Thank you very much. Says, hello all. Get hard at Law of Self-Defense. Yes, I mentioned the free book. You can get the free book here. That's the URL. We only ask you to cover the cost of shipping and handling, but we'll send you the book for free. On Amazon, it's $20 or $25. Or if you'd like a really nice looking hardcover version, these are not free. They're too expensive to print up to give them away. But they're beautiful books. They look great on the bookshelf. If you'd like one of these, you can get it at lawofselfdefense.com/gethard. Lawofselfdefense.com/gethard. There we go. There we got another one.
They do look lovely. It's a lovely looking book. It's a great cover. Highly recommend.
And it's got my picture on the back, although it's my, yeah, there you go. See, you get, you get the book.
Oh, yeah. See? Beardless. It's beardless Bronca.
Beardless, indeed. Ghost Fox, $5. Thank you. Says, good job on handling a potential drug snorting implement with bare hands. Yeah, I thought that too, man. These days, you couldn't pay me to touch anything drug related without gloves on. Fentanyl is everywhere, and that stuff is dangerous. MAN, $10 super chat. Thank you. Says, lead investigator in a criminal trial sits with prosecution during trial. Okay, fair enough. Yep. The idea is that the investigator already knows what the testimony will be, so hearing witnesses does not color his testimony. Okay, fair. Shut Up, I Can Cook, $5. Thank you for your stamina and the tie. I do not smoke weed, Branca, nor do I have tattoos. So there's two of us. By the way, I have nothing against people who smoke weed. It's just, it's not my vice of choice. James Buchanan, $10. Why isn't the defense objecting every time the state used their practice scary AR-15 reference? I think that would throw prosecutor off her practice game. Of course, that's just prep and practice. The defense may just not know. They may actually think it's an AR-15 too. They may think AR-15 is just a generic description for a black, scary-looking rifle. You know, most people, you know, in my community, my space, and that means all of you in the chat, you generally have a pretty good familiarity with firearms, maybe genuine expertise, but that's not true of the general public or of most lawyers, even criminal defense lawyers.
Yeah, it's not. And they have sufficiently scared people with the rifles, you know, to the point where it's like pointless to even try and discuss it with people who are scared by it and brainwashed by the style of the gun. It's almost like I just give up.
Domo arigato robato. I remember that song. Sticks, I think. $10. Thank you all for your insights. Also some moolah for prosecutorial combing for evidence. To all be well and safe. Namaste. Namaste indeed. Kyle Mitchell, $20. Wow. Thank you. The problem with juries is they have nearly zero experience. They don't have anything to compare it to. This case is pretty easy, but many others are more muddled. I was on a jury and barely knew what sustained or overruled meant. Yeah, so I mean, I just happened to get come across a news article in like a local newspaper or someplace where someone was had written in, like local people do to local newspapers, describing their experience in a jury trial, and it was a murder trial, and manslaughter was a lesser included charge, and they kind of described the whole experience. And by the end of the article, I realized they had no idea what the difference between murder and manslaughter is. They kept using the terms interchangeably, and they're very different criminal charges with very different sentencing consequences. And that person had just been a juror in a murder trial for days and heard these legal concepts argued. and been instructed on them by a judge,
God.
and they still don't know. And if they don't know what they're being asked to choose from, it would be like, going into a Chinese restaurant and being given a menu in Chinese. If you can't read Chinese, you don't know what you're doing. It's crazy. And that's why you hear me say it over and over again. If I have to put you in front of a jury, there's a 10% chance you get convicted no matter how innocent you are. And that's why we should have substantive barriers to having the accused dragged in front of a jury, which unfortunately we really have in American law.
That is so. This is a question that I'm having about the Absug case too that I've been working on. Is that I'm trying to figure out what in the world was the probable cause for her for charging her in the first place. I'm going back and looking at that because, in my opinion, they had so little evidence at all of a conspiracy to kidnap that they should have, a judge, instead of giving it a warrant for an arrest, should have given it a warrant for maybe surveillance. So they could have got some evidence about this thing they said was going to happen.
But as a practical matter, all that needs to be done to meet a probable cause standard is some articulated theory of how the person can be guilty. That's it.
That's crazy because all they had was a mentally ill 15-year-old saying, I heard this. I heard this. And I mean, I don't know how that's probable cause. I could definitely see how maybe you'd be like, okay, let's bug her. Let's get a bug on the phone and let's tailor to see what she's up to. If they had done that, they would have found out that nothing of the sort was going on.
Right.
But no, instead they just charge her with it, and then a stupid jury finds her guilty of it because the prosecutor lied and all sorts of other stuff.
And by the way, the law enforcement prosecutors lie on these probable cause things all the time if they're politically motivated. And sometimes the lies are even exposed later. And you know what happens to them? Not a fucking thing. They're not held accountable. Nothing is done. Because by then it's 2 years later, like we're watching this trial now, right? If they'd lied on a probable cause document 2.5 years ago, nobody wants to talk about it anymore. Even if it's exposed. To my mind, it should invalidate the entire rest of the process. That's the seed. If it's a poisonous seed, the whole plant should be poisoned. But they don't do that. They just say, we're here now. We don't want to talk about what happened 2 years ago. It's terrible.
It is terrible.
James Buchanan, $10. How can the judge stop the defense from disqualifying or ripping apart this witness who has no idea if he testified, et cetera? Everything he said has been a waste. I think the defense just... Maybe they knew the guy was just going to start crying on the witness stand, and this defense attorney who was doing that cross, she's vicious when she wants to be. So the fact that she wasn't with this witness told me she made an affirmative decision just to take a soft approach with this guy.
Well, she went in hot, but then she pulled back. If you noticed, she pulled back way back.
Her nature is definitely pit bull for sure. Farmhand Tom, $10. Thanks for the stream, Branka. It is my pleasure. What better way to spend a Saturday than with all of you? I think that's the super chat. Let me turn now to the, let's see, anything on Rumble? Any colorful comments on Rumble? Rumble doesn't seem to give me, I have to say the interface for Rumble is not very good from a content producer's perspective. I know Nick is working with them.
Rumble chat
Rumble
needs
rant.
a lot of work.
Hit that plus, show your love. I think that's the only one. And then on the Law Self-Defense members site, let's say we got a bunch of comments here. The state, Charlie says the state chart. These are all Law Self-Defense members now. By the way, all of you should be a Law Self-Defense member too. It's much more cost effective than being doing all these super chats to YouTube. And you can become a Law Self-Defense member. Less than $10 for an entire month, folks. About 30 cents a day, and I'll answer every question you post and read out every comment you put in the member chat. 30 cents for a whole day instead of $5 on Super Chat. And you can become a Law Self-Defense member right here at lawofselfdefense.com/join. And you can always change your mind if you decide it's not for you. I think we offer 110% money back guarantee. So it's a zero risk membership. Charlie, Law Self-Defense member, says the state charged Cummings with murder 6 days after the event. He's been in custody for almost 3 years. Yep. If acquitted, can Cummings claim his Sixth Amendment right to a speedy trial was violated? So speedy trial is not a thing, really, folks. It's you have a U.S. constitutional right to a speedy trial. I won't get into the technicalities of that. So you may wonder, how can it take 2.5 years to get to trial? Because normally the defense is waiving that right.
They normally waive it. The
Right.
defense always wants more time.
Right. They're always afraid. Remember, 10% chance to get convicted if you go to trial, even if you're innocent. So they're hoping something will break their way. Maybe a plea offer will be made. It's generally in their interest. Even though this guy was in jail, he wasn't convicted of life in prison. Right. So that's better. Waiting in jail with the prospect of an acquittal is a better situation. So what typically happens is it's the defendant who's waiving their claim to a speedy trial. Let's see. I wish Steve Gosney was here because he likes to talk about that particular issue, but he's on
Steve's
a mini
on vacation
this weekend.
Yeah.
Yep.
I'm going to have Steve on next week sometime. I want him to go over the sentencing in the ABSEG trial with me because I really want to hear from a criminal defense attorney about what he sees as, look at watching her defense attorney work. Because it's brutal, man. He just does not fight for his client at all. And it's so frustrating. So Steve, I think, is going to come on with me after Tuesday. He's going to be back on Tuesday or sometime after Tuesday. So maybe Wednesday. I'll let you know if you guys follow me on local
Wednesday
stuff.
afternoon, just FYI, Wednesday afternoon, he teaches our law class, our criminal law class.
Well,
So
it won't be Wednesday afternoon.
Okay.
So maybe I'll get him for Thursday if he's not busy.
Charlie says, Andrew is ignoring the member chat to grift on YouTube and Rumble again. I'm reading the member chat right now. So there you go. Northman, good morning from Minnesota. Charlie, taking odds on whether or not the prosecutor finally has a competent LEO. We got that answer, right? Nope. Super not competent. I mean, literally not competent, mentally incompetent. Charlie again, is the max exodus from police forces due to defund movement means we're going to see more of these obviously barely competent LEOs. These guys were pretty bad. What I typically see is police departments replacing their experienced street officers with very young people. So those people are not necessarily, it's not like they couldn't eventually be competent cops. Maybe they could, maybe they're not mentally deficient, but they're not yet competent cops. You can't be if you're 7 months or 1 year or 2 years on the street. So we won't see better decision-making from these young, inexperienced officers. That's for sure. Charlie, quit ragging on Officer Hagrid. Maybe he supplements his salary as a secret shopper for all-you-can-eat buffet restaurants. That could be. Joe, officer's wardrobe by Kodiak Canvas Tents. Fair enough. Charlie, again, as I remember it, didn't they enter the residence until the crime lab folks from the state police got there around midnight? I don't remember that detail, Charlie. Let's see. Everest, the 911 audio, that's the tribal police department relaying info to the county sheriff's office. I think that's correct. That's the little recording we heard earlier today. The female talking to this lead investigator or somebody in the lead investigator's office. Stogies and boomsticks. Has the state finished making the defense's case for them yet? Well, they made the defense's case on 2 of the charges, right? Those have gone away now. I would argue they also did it for the murder charge, but the judge disagrees. Let's see. Yeah, so the Everest writes the spoiler, the detective had good reason for his poor memory, as he talks about at the end. Yes, we heard that. Joe, Binger had a better case against Rittenhouse. That's a hard sell for me.
That's a hard sell for me too. I do not think so. Anybody who watched that video should have been like, yep, nope, case closed, self-defense, move on.
Let's see. Joe, the chief medical officer gave the medical testimony. She did not perform the autopsy. Yes, she was not in that job when the event actually occurred. A different medical examiner did the actual autopsy. That person presumably is no longer with the office. So the current medical examiner basically read from the other person's report. Let's see. Chris M. I don't get these cops. Every time I get a subpoena, I pulled my report and read it. So I guess Chris is former LEO. And printed a mugshot of the defendant. So my memory was fresh and I could comment intelligently on the case. Yes, you'd think the witnesses would prepare for their testimony. You'd think the prosecution would demand that they prepare for their testimony, for sure.
You would think so. Seems reasonable.
Let's see. Charlie, you can literally, some of these are jokes, folks, and just in the interest of saving my voice, I can't read all the jokes. They're very funny. I'm just going to read the substantive comments. T writes, I find it odd that the suspect, while maced and in a scuffle, was able to find and load a rifle. Branca, you are presuming that the mace was used offensively. The only facts backing that up are the statements from the suspect. I'm presuming the defendant is innocent until proven guilty, beyond a reasonable doubt. All the legal presumptions are supposed to be in the defendant's favor. That's how this system works. And nobody says he was maced and in a scuffle and was then loaded the rifle. The rifle was already loaded. He wasn't loading a magazine with a third hand. The state's not arguing that he loaded the rifle after being maced and in a scuffle. No one's arguing that. Could this be grounds for a mistrial? Well, it basically was a mistrial. Well, it was better than a mistrial. I mean, he dismissed the charges on those two lesser counts. Let's see. Yeah, Joe, this police officer forgot the beginning of her question by the time she finished the end of the question. Yeah, he did. Let's see. Monica, how damaging is this particular guy's inept testimony to the state's case? Well, it ought to be real damaging, but how damaging depends on what use they make of it in closing argument. That's where the damage will be really inflicted. Northman, firearms training, different clothing, washed face and hands, 6 hours had passed. No wonder he couldn't smell anything. Yep, I think that's reasonable. And presumably, I presume the defense is going to bring on an expert to talk about all these mace factors. Let's see. Joe, this is cruel, like a Joe Biden press conference. They should shoot him and put him out of his misery. Well, no shooting, folks. Paul in Florida, a man is on trial for his life and he can't recall, quote unquote. Yeah, it's outrageous. Charlie, how could the state have continued prosecution of this case when they knew their lead agent had no memory of the case? That's a damn good question. Yep. Donnie O, defense needs to open with stressing there is a legal presumption of justification and that the legal presumption must be rebutted by the state beyond a reasonable doubt. Then hammer every witness. How sure are you? Yeah, I agree, Donnie. That's what I tell them on every case I consult on. I tell them to do it during jury selection before the jury's even chosen and impaneled. Get those prospective jurors to emotionally commit to understanding that the judge will instruct them that the state has to disprove self-defense beyond a reasonable doubt. And when you demand that of them, every prospective juror, their heads all nod. You got them locked in. If you wait to make that argument to the end of the trial and closing argument, it's too late, in my opinion. Charlie, statistics on homicide equal 86%. I don't think alcohol or drugs was a factor in this case. Yeah, it's almost always, of course, a factor. Paul, so you saw through this cruddy screen through all these bushes from 200 feet away. Are you sure about that? And that's a quote from my cousin Vinny. Das Ogre, Jim, do you think the ground troops will be endeared to prosecution? I'm not sure what you mean, but normally the testifying officers in the prosecution perceive themselves as being on the same team. Monica writes, Charlie, yes, 86% is the statistics for under direct influence of alcohol, but alcohol specifically and other consciousness altering drugs affect bodily function and negatively impact mental condition for days afterwards. Charlie, how many more witnesses until defense motion to dismiss? Well, we heard it. That was the last one. Das Ogre, good. They had no business even bringing the case after their prime witness was Vulcan mind wiped. Monica, in this case, it's just sad. It seems lonely and definitely doesn't aid his self-defense. I'm not sure what you're referring to there. Charlie, did they allow this witness in the courtroom in order to refresh his memory? Paul, he didn't know they had a lab. The officer didn't know they had a lab, but can't recall if he called them to test ejection patterns. Yeah, it's very, very brain blended. Das Ogre, to me, this looks like the judge thinks it's okay for prosecution to create a flawed record, wipe the witness's mind, and then hide Vulcan mind wipe. We can convict defendant anyway. They clearly don't have much of substance on legal merits. Das Ogre, regarding the mystery magazine, I thought I saw a photo of it yesterday with the top round inserted in the wrong direction. Anybody able to shed any light on that? I think that was the 22 long rifle magazine, which was a second magazine for a different rifle found at the scene, but it wasn't involved in this event. The mystery magazine is a second magazine for, well, that would fit the rifle actually used in the shooting, but nobody knows where it came from. Das Ogre, I want all to know I blame the prosecution for all the nasty things I said. What about the trooper yesterday? Corrupt prosecutors. Yeah. Salween writes, if he has no memory, he shouldn't be a witness. Yep. Let's see. Northram, if the deceased thumb was on top of the canister, it could have been flexed enough during each blow to release its contents, which would then be flung around during subsequent blows. So here's the thing with these cases, folks. The actual, it's a plastic case on the outside with the little plastic flip top lid and the big thumb button, right? But the actual OC canister is a metal can that's inside this, and it's fairly loose. So it's not hard for me to imagine that if you slam this hard on the surface, you could trigger the valve and eject a little bit of OC spray just by accident, unintentionally. And that would be true even if you were not intending, even if you had not flipped up the top, even if you were not intending to spray, so you were not pointing the sprayer at the person you were attacking, but if you're striking them hard on the head, it wouldn't surprise me if some OC would come out just from the impact, jostling the valve of the canister. Presumably, the defense expert is going to talk about that. Das Ogre, Megan, you are so hot as a brunette. They want to date you now. Okay.
That's ridiculous. But thank you.
Why is he on the stand? He can't remember anything. Das Ogre, how egregious does this have to be before the judge to clarify things for the jury, even if the defense doesn't? No, the judge doesn't do clarification, folks. That's up to the parties. Joe, wow, just wow. Paul, hearsay. Yes, we all heard that hearsay at the end. Joe, that's what they wanted, to keep his medical condition out of the record. He'll never be able to testify again. He shouldn't be able to carry a gun. He certainly shouldn't be testifying about cases for which he has no actual memory. Let's see. Move for dismissal time by Salween. Das Ogre, unfortunately for prosecutors, even delusional, paranoid folks still have homes and still have self-defense rights. Donnie O, jury is always made up of people who were too stupid to be able to get out of jury duty. Not always, but they're a very naive audience for often complicated legal doctrines and fact patterns. Let's see, Das Ogre. Andrew, could you talk about Kyle's Law during a break in testimony? I think I did a few times. Das Ogre, the defense Valkyrie, that would be Carrie Morrison or Morrissey. I can never remember. Morrison, I think. The defense attorney Pitbull, I like. The defense Valkyrie is going to clobber this moron. She was actually quite gentle with him, given her normal demeanor. Let's see. Salween, shouldn't it be malpractice to put someone on the stand and testify about something of which he has no recollection? Well, yes, I would say it's certainly inappropriate. It's not really malpractice. Malpractice is an action brought by someone who's been damaged by their own lawyer, and they're suing their own lawyer, like you sue your own doctor for malpractice. This cop testifying is not a client of this prosecutor. So, but it's certainly, I would suggest it's misconduct. Donnie O, it's not just Andrew assuming that there was mace used. The law presumes mace was used, and the burden is on the state to prove it wasn't beyond a reasonable doubt. Right? There is evidence that mace was used. It's the defendant's testimony. He's presumed to be innocent until proven guilty beyond a reasonable doubt. Monica, the last comment on the Law of Self-Defense member page, and then we'll wrap up. My comment about Cummings seemed lonely. Oh, my comment was that Cummings seemed lonely was in reference to the number of drugs in the system. Drugs are false ways to deal with a real human being. So the tox stuff, folks, is not Cummings, the defendant. The cocaine, the alcohol in the blood, the marijuana in the blood, that was all the victim. There was marijuana found in the defendant's dwelling. I don't believe any toxicology was ever done on him, though, so we don't know anything about that other than he had marijuana in his possession. I would think he'd be lonely. He has no wife or children, apparently. He's moving to New Mexico by himself late in life. That's not a great existence, really. All right. I think that is everything. Hey, Megan,
this was fun.
Thank you so much for coming on. It's always a pleasure to have you. It's always fun.
Yeah, it was a good
Oh,
time.
somebody writes, this defendant, speedy trial doesn't apply. He spent 1 year in a mental institute. So I believe there was a couple of years where they were evaluating him for mental competency, and they just recently decided he was in fact competent for trial. So that, of course, would in effect be a waiver
Took
of
a whole year for that.
who knows, COVID.
That sounds nuts, but okay.
And that was let's see who wrote that. That was News Wyoming, $5. Thank you. Ammo is currency, $10. Writes, cops and prosecutors that are found to have lied to bring a case belong on the, and there's little meme things there, but I don't know what they are. They should be in jail. They should be sentenced to whatever sentence the unfairly accused would have had if they were convicted, is what the punishment should be. You falsely accuse someone of murder, and it can be proven beyond a reasonable doubt that you falsely made that claim, you should get a murder sentence.
The prosecutor? You mean the prosecutor should? I agree. I agree.
Yep.
I think it's absolutely outrageous that they face no consequences if they bring charges that are easily proven false. I think that's nuts.
C. Warren, $5 super chat. He's asking about our American law courses, our self-defense law courses. You can learn more about those at lawselfdefense.com/law courses. These are law school level courses that we're teaching. Steve Gosney is teaching our criminal law class this semester. We have courses upcoming on criminal procedure, constitutional law, evidence, and other topics we'll do as well. We don't have someone lined up yet for the constitutional law class. I'm still trying to decide who would be the best person for that. I mean, any lawyer can teach it. I could, if no one else does, I'll teach it. I would love for Nick Recato to teach it, but I think he's making too much money these days. So I'm not sure I could talk him into the time investment. But we're definitely going to do it. So yeah, constitutional law is one of the courses at lawselfdefense.com/law courses. And is that it? Is that it? So many. All right. I think that's it. All right, Megan, we're finally done for real now. I can give you your Saturday back. Great job folding the laundry.
Thank you. I'm still going.
We got plenty of laundry at my house too. I'm sure my wife would appreciate any assistance you're willing to offer. Folks, thank you so much for spending your Saturday here. Any closing remarks, Megan? You got anything you want to pitch or plug, or your channel, or?
Sure. You know, everybody's been, I've been covering a lot of these board meetings, the contentious board meetings, and I try and live stream them when I can. I've been hooked up with Moms for Liberty for a while doing that. So pay attention on my locals, meganfox.locals.com. Because we love to go and watch the weirdos and make fun of them at these board meetings, the ones who want to show porn to kids. They're so weird. I don't know why they want to do this, but they go and they speak publicly and they defend this. So I spend a lot of time on my channel, both on Rumble and YouTube. And you guys should get me, definitely subscribe on YouTube and Rumble, Megan Fox Investigates, and follow me on Locals, because that's where you'll see what I'm doing and when, meganfox.locals.com.
All right, awesome. Hey, folks, thanks for joining us on this Saturday. We know your time is precious. We really appreciate it. Thanks for all the super chats, all the support. Thanks for becoming a Law Self-Defense member at lawselfdefense.com/join. If you haven't done that yet, now would be the perfect time to do that. And until we will be back on Monday. Monday, I'll be following the trial proceedings in real time. We're all caught up now. So in real time, starting with the defense presentation of their case in chief. So if you're interested in the coverage, I'll be streaming all day. I'll be inviting the usual gaggle of folks I like to come in and participate as their interest and schedule allows. So Megan, expect a message about that once I have the link set up. So I hope a bunch of you join us there. And until then, remember, if you carry a gun, so you're hard to kill, and that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. You'll also owe it to yourself and your family to make sure you know the law, so you're hard to convict. All right, folks, enjoy your weekend. Stay safe. Take care.
Bye, everybody.